Good morning,
Good
everyone.
morning.
It
How did you
is
do that with 2 of us at the same time?
I have it on for me, it's the third one in on the screen
Oh,
setting.
clever little thing you are.
I didn't make it. It was the it's the
Welcome,
default.
welcome. We're
We're
back.
we're the Giggle Sisters. I'm alternate
So,
Jer, and this
I'm the
is
difference rests or
she
never
is
rests.
from the land down under. I
Uh-huh.
say you get to tomorrow before we get to today. So, as
Oh,
long as you're
yeah.
still alive, I know we're still alive.
You'd think I could give you a heads up on what's happening, but it doesn't work like that.
Yes, like lottery numbers or something, that'd be great. It'd be
Yeah.
great.
Mhm. Verdicts.
Yes, yes,
Mhm.
just, something.
We don't have to wait. We can just ask Jodie. She's 14 hours ahead.
Yes, she knows, it's already happened. It's already
Mhm.
happened.
I wish.
Hello, Carmen, and good night, Carmen. Go to bed.
Party people.
She is worked all night, so go to bed.
Oh, have a good sleep, Carmen.
Hello, Christine, how you
Welcome all.
doing?
Hello.
And Gabby, of course, hello. You got what up? You got
Ms.
what's my peeps? She said she says up.
Hello, Governor. I played that to my daughter this morning, this afternoon. I said, "You got to watch this." I said, "This
Good night,
Gabby was
Carmen.
the soggy bun."
Yes. Yes, she is. Okay, so we're going on back on to day 2 of the Black Swan trial. I paused it. She's walking into court. Uh, I didn't
Who's convinced?
I'm not convinced either way. Are you? I didn't see all the witnesses yesterday, because I was in and out of
Oh, I think
the
she's innocent,
stream.
but um, yeah, I don't know if I'm biased because
I
it's a bit triggering for me. This one,
I
bit close to
understand.
home.
Yep.
Mm.
And
That's all
exactly what you're
right.
saying, like, it doesn't have to be, physical. It can be
Exactly.
verbal and emotional and mental game. I've been down that path myself,
Well,
and,
yeah,
so the fact that she doesn't have any injuries means 0 to me.
absolutely.
I hope that, the jury's kinda picking up that you don't have to have physical injuries. Um,
I was getting really angry with Vinnie Politano's supposed experts during the lunch break. They were just, ugh, yeah, no.
yep,
They
that's
just made her out to look like well, they actually called her a gold digger.
oh, good. That's good.
Yeah. Yep.
No problem. I
She was just
the
there for the baby, and then once she had that and the baby, she didn't need him anymore. She just used him and manipulated him and tossed him out.
Well, the thing about being a woman, if you want a baby, you can probably just go to a bar one night,
Oh, why
and
would you
not have
choose someone 30 years older? You could have had
yeah,
Uh-huh.
it's Carmen, no, that's her defense. She either unalived him in self-defense, which is what she is
Mm.
claiming, or she second degreed unalived
Yeah,
him, which is what the
with a
state is
pew pew.
claiming. She's claiming that it was DV, um, but their state yesterday was like, "There's no injuries on her." It doesn't, and that's what we're saying doesn't matter. So, it's not
Uh-huh.
like an essay or anything like that.
No.
It was a custody battle that was getting really heated and a divorce that was going to follow. They got married 13 days after they met because everyone so well after
Yeah.
13 days. Basically, they wanted
And
to
as
have
I was
relations.
Yeah, that's it. That was exactly why. But as I was saying yesterday, though the defense was saying that it was only 3 days before the custody went to court, like the custody battle went to court. So they were saying that she had no other option because she'd failed at the previous hearing. What was the hearing that
The injunction?
No, the one where she got dismissed with her DV.
Oh, the stand your ground.
Yes, yes. Um, because she'd lost at that, and then there was only 3 days to go before the custody battle was to start, they said that she had no other option and took things into her own hands. But what I was trying to explain was that it may be also that in his mind, people, narcissists like that would be bubbling and bubbling and bubbling inside his head. He's got the risk of losing his daughter. He's got the risk of losing his wife. And then the day comes and they're moving and he finally realizes that's it. There's no turning back from here. They're just really explosive.
Well, and she was leaving the state.
Yeah. Yep.
And,
Yep.
when you're in that point of
Massive trigger.
things,
Mhm.
there's a lot that happens. The threat of them unaliving themselves,
Yep.
self-deleting,
Oh, yes.
all
Yep.
that comes out
Self-threaten
1,000
that.
times, and they never do it because they're never going to.
Did you hear the
And
911 call?
I heard part of it from the neighbor. I heard hit.
No,
I
if you
think
listen to the 911 call, she's innocent,
I'll go
I
back.
reckon.
Is that with the neighbor, the one that was on the stand when they were playing
Yep.
his?
Yep.
Okay.
Yep.
Yeah, I heard part of his. Um,
Yep.
but
And
those
she
are
was
always
crying her
fabulous
eyes out.
looking. Yeah. And she looks like she's reliving it. Some people are thinking when I read the chat, like on other channels, you know, like that we're watching from, uh, that she's faking, she's cold, you know,
No.
they say a lot of stuff about her. And I'm like, man,
Mhm.
maybe I'm watching through a different filter.
Everybody reacts differently. Survivors survive. That's what they do.
Yep. So I don't know. I don't, I did see some comments,
Oh,
why hot.
yeah. Sorry.
That's okay.
Ooh,
I can't help
no
you from
tongue.
here. I don't know what 911 is in Australia. So,
Triple O. Do
okay. My guess
you
was
know what?
111 or
I've
but
watched that much American stuff that I reckon if I had to, I'd probably ring 911 from here. But they have they have got it set up that 911, if you call from Australia, will go through to 000 because so many people watch American stuff.
yeah, that's what you guys know. Yep. That makes
Mhm.
sense. That's good because
Yep.
Americans, we would be like, no, you learn 911 or you don't get saved.
Uh-huh.
It's like, it's our way. I got a hair that just keeps flying in my face, it's driving me nuts.
Oh, annoying, isn't it?
Oh, it's like
Tickling your face.
I can just keep seeing it go in front of my glasses. Jodie is alive. She is. I
I
was
am
telling
alive.
Bree.
Hi,
I was talking to Bree right before we went. I said you popped in. I was like, I gotta go, Bree. But I was
Bree.
telling her that how long you stayed up yesterday, and that I appreciate it so much. It's
You're
made
welcome.
things easier, so
Welcome.
we didn't have to
It
start so
does.
early
It
today,
does.
and I'm gonna
Yeah.
go till the end today. So, but you do what
I'll
you
see
need to
how I go.
do.
I will try my darndest. I can't guarantee it'll be the 8 hours though.
Yeah, nope, no problem at all. And then Friday, I will if you can host tomorrow, then I'll host Friday,
Yep.
and then
I think it'll be
hopefully
done Friday.
I hope so. Hopefully it doesn't go to the jury late though on Friday,
Mm,
because I don't like one, I just don't like when juries deliberate on Fridays because it feels like they wanna go
yeah.
home. They want their
Yep.
weekend, and I know it doesn't feel fair. So,
Well, the state have one witness Thursday morning because they couldn't come any earlier, and then they're resting.
yes,
So they've got their, was it 8 witnesses today to get through,
I think that's what they
and then
said, yeah.
one tomorrow, and then the defense starts. And I think they only said 4,
And we'll see,
4
because sometimes
ish.
they say they're going to call people and then
They
they
could be on
end
the
up getting.
stand all day.
Yep. And then they don't, or they don't call anybody, they just rest.
Mhm.
But I do think if she's gonna claim self-defense, I think she's gonna have to testify. Oh, good, Carmen. I know that's gonna be confusing to some people, but she was waiting for clearance. Um, when you get a federal job and then they have to investigate you, investigate your
Ah,
life. Uh,
mhm.
so I think she's like moving on through. So good. Hope
Excellent.
that's what it
Good
is.
job.
And good job.
Congrats.
Whew, it'll be a weight off her
Mhm.
shoulders. But then she's got like a year before her final clearance will be finished. It's insane. Insane. Alrighty.
Boop.
Let me. There we go. There's her.
Oh, nice, lovely pastel teal.
And I just got a boop in my ear. So
Oh, which one? Mr. Bry.
good
Yay.
morning, Brian. You're in the
Good
sandwich.
morning, everyone.
Good morning.
Jodie's the meat in the sandwich.
Yep.
Soggy bun here.
How'd your dentist appointment go? Y'all clear and all good?
I've got to go there.
Yes, everything went great.
Good. I think I
Now
have
I'm
one
eating
next week.
candy.
It's funny
I've got
because
my M&Ms.
when I got your email this morning, I have a dentist appointment next week, and that the first thing that popped into my head, I'm like, who is emailing me about my dentist appointment? Then I was like,
I
oh,
love
it's
going shotgun,
Brian.
Gabby. I'm in the middle.
Well, I don't know. I have never tried to move people around, so I don't know how. Oh, I think I just nope. I don't know how to move you. I know people do,
No, I couldn't work it out.
but I don't know.
Blow that schnoz.
Alrighty. You guys ready to
On mute.
I know.
don't release the Kraken. Keep that thing in check. All right, you guys ready before we go too far
I'm
off the
ready.
rails? Oh, I gotta move my stuff. I can't see my screen. Alrighty. I've got everything boosted and turned up, so hopefully it's good for y'all. And let me know.
I'm going to sit back and relax.
Yes, you do that.
Gosh, she's
There's no
so
sound.
thin.
So she's got a dancer's bod for sure.
If breeze would just blow her over.
Yes. She looks better today.
She does.
I like her outfit better too.
Yes.
I do too. It's not just so plain. She kind of looked like she was in custody yesterday.
Yeah. She
Come
needs
on,
a
say
regrowth
something.
done though.
Her skin tone. I'm trying to figure out if she's tan, if she's Hispanic, and not always that tan looking, or what her national like. If she's not saying she's not American, but you know what I'm saying.
Yeah.
I think she put a bronzer on today.
Okay, because her skin is definitely. I have a bronzer on, and I don't look like that.
I have too. But it is winter over here.
Well, you're not doing it right.
Apparently, I'm like all shiny up here with this giant forehead, just being like, I put a billboard message. That Bree
I
says
don't like too much makeup.
Madison is wide-eyed hearing you all talk. She's invested in the trials. She's invested in eating. That girl wants to eat.
How
and
old is
eat
she
and
now?
Eat. She will be 4 weeks tomorrow. She's born on the 27th, but on Thursday. So she is almost 4 weeks. We still have no sound. A month tomorrow. Yeah, Brie.
Wow.
She's like, it's
Yep.
going too
And
fast.
one day you'll say, oh my, she's 21. It only seems like yesterday.
I told him, You'll understand when you have a child, and she is definitely
Just goes
she's
poof.
getting that. Yep.
Yep.
Yeah. She says her forehead will put mine to shame. I don't know about that. I don't know about that. Thank you, Miss Gabby. When you go to the bank, make sure you don't take more money than you're supposed to. I always ask her, like, are you robbing the bank? Because you're there all the time.
Who goes to the bank nowadays?
Gabby.
I just do everything online.
Robbers.
Yes.
True.
Gabby
Yeah.
and robbers.
Mhm.
That's why I asked her. We're going to start with a sidebar. Let me.
Of course we are.
That was one bad thing about this trial. When we approach, I'm like, no. Guys are like constantly approaching. And he does just look like Jim Gaffigan. Brian, the
I have
judge.
no idea who that is.
Yeah, he does.
Who's that? That lady in front has got a frown. Lady, smiled.
You're not frown
Smile.
upside down.
She
Like,
is
I'm
not
trying.
happy with, she's not happy with her seat.
Apparently not. It's like, smile, lady.
No, the
She's
judge
sitting on
is
a pickle.
praying.
It doesn't look like he's
He looks like a priest.
Oh Lord, let all the jurors show up today.
Forgive me, Father, for I have sinned.
It has been 30 days since my last confession.
Yeah. And 2 minutes since my last sin.
Yes. Oh, Gabby. That is what that lady looked like. That was a frown.
If you turned her upside down, it'd be a smile.
It would be a big smile. I feel sorry for her because no matter what her expression is, they're gonna read into it. If she looks like she looks right now, she's cold. If she looks down, she's looking away. Everything is going to be dissected.
We
Oh,
have the sound. That's it, Gabby. Oh, that was you. I thought I'd test out the clicky chat, and you clicked at the same time I did, and I thought I did it.
All right, y'all can have a seat. Good morning, everybody. Welcome back.
Good morning. Thank you, Judge.
Check and make sure we got the right notes in the right place. Those are yours. Check your pens.
Yep.
Make sure they still got plenty of ink.
Yep.
Hang on.
Got it.
I can't hear you.
Oh, I'm just making fun of the judge. Sorry.
Okay, that's fine because it's really loud. You know how it is. It's really loud on my end. So if you need me, wave.
Good morning, everyone.
I will.
I just want to make sure that nobody began discussing the case amongst yourselves or started deliberations. Nobody discussed the case last night or this morning with anybody outside of the jury. Nobody approached you or talked with you or tried to influence you in any way. And you didn't do any research on the people, places, things, or legal topics we've heard anything about. All right, everybody says no. Thank you. When we finished up yesterday, the state.
That lady in the black behind her, is that Jules from Take Care of Maya case? You know the lady I'm talking about?
Research on the people,
it was on with RA?
I just want to make sure that nobody began discussing the case amongst yourselves or started deliberations. Nobody discussed the case last night or this morning with anybody outside of the jury.
It is. You're muted.
I don't know who that is. You say is she like a guest on RA or?
Yeah. She sat in the courtroom through the Take Care of Maya case and then did interviews at lunchtime and after the court at the end of the day.
Nice.
I think it's Jules.
Bree, I am not an old grandma and can't hear now. This audio is very loud on my end and I can't hear Jodie. That's all.
which is very, very rarely said.
So, like, if Jodie Brian say anything, I can't hear because I have so my ears don't bleed. I have to pull my earbud out of my ear.
I'll keep an eye on RA's chat and see if it is her.
Okay. All right. We ready to roll?
Hearing? Nobody approached you or talked with you or tried to influence you in any way? And you didn't do any research on the people, places, things, or legal topics we've heard anything about?
No, sir.
All right, everybody says no. Thank you. When we finished up yesterday, the state was still presenting its case. So, state.
State calls Alicia Byers.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Good morning, ma'am.
Morning.
My name is Judge White. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. We need to get you about 12 to 15 inches from that microphone. It does adjust up, down, left, right as you need it. If you speak in a loud, clear voice right into it, it'll pick up everything.
Thank you.
Yes, ma'am.
Good morning. Please state your name.
Alicia Byers,
Can you spell your first name and last name, please?
ALICIABYERS.
And your relationship to Ashley Benefield.
She's my daughter.
And
All right. I'm curious why they called her mom to testify for the state.
Mm. Mm-hmm.
I don't know about this. We'll see what happens. Maybe. I mean, dang. I know if they called my mom to testify against me, she would be like, you're going to regret that one.
Uh-huh.
when did she start living with you in Florida?
I can't clearly remember.
Okay. Was there a time when Ashley moved in with you when she was pregnant?
Yes.
Okay. And she was married at the time, but it was just Ashley that moved in?
Yeah, he brought her down.
Okay.
And yes, and yeah,
And she moved in with you?
yeah. He told me I needed to take care of her. He dropped her off.
Okay. So she stayed with you from that time on, correct?
Yes.
Okay. And does Ashley have a concealed weapons permit?
Yes.
Does she own firearms?
She doesn't now, no.
Did she own firearms then?
Yes.
Okay. How many?
2, I think. Yeah, 2.
Did she ever go to the firing range or anything?
Yes.
I'm sorry.
Yes.
Okay. How frequently would she go?
Well, we did all the courses to get the concealed carry, and I don't remember.
Okay. And very shortly before the shooting, she went to the shooting range with your neighbor, correct, John Fantz?
I don't think that was close to that time, no.
So it may not have been close in time, but they have gone together? Ashley and John Sands.
I'm not sure.
Okay.
I don't know.
Okay. And you and your daughter obviously are very close. You lived together, just the two of you, right, for a while.
Mhm.
And then once the baby was born, the baby lived there with you,
Correct?
correct? Okay. And around that time of the shooting, were you planning to move to Maryland?
Yes.
And you had a house that you inherited in Maryland?
It was the house I grew up in.
And moved to Maryland with Ashley and Emerson, the baby?
Mhm.
Okay. And Doug, Ashley's husband, was also moving to Maryland?
He was moving somewhere else. He was, yeah.
Okay,
He had found his dream job.
so he was moving to Maryland, but not moving into your same house?
Correct.
Okay. And he was moving, packing up to move at the same time you were.
I assume so, yeah.
But he was coming over to help
Yes.
you move.
Yes.
And on a regular basis, almost every day, he was at your house.
Maybe the last week.
Okay.
Yes.
Helping move boxes and things like that.
Yes.
And you all rented a U-Haul, right?
Somebody rented a U-Haul. I don't know who.
It was in your driveway though, correct?
No, it was not my driveway.
The day the shooting happened, was it in your driveway?
I think it,
If you don't
the
know, that's
U-Haul
okay.
was getting there when I was leaving.
Okay.
Yeah.
But you also had a pod, one of
Correct.
those
That was in my driveway.
in your
Yes.
driveway. Okay. On the date of the shooting, what time did Doug get to your house? Do you remember?
No, I mean, it was, I can guess, maybe like 5 or something. I don't know.
So it was still light
Oh,
out
yeah.
and maybe in the afternoon sometime.
Yeah, I don't clearly know.
Okay. So when he showed up, what did you do? Did you stay there or leave?
I was leaving when he pulled up.
And where did you go?
We went to the park.
Okay. And when you say we, who is we?
Oh, Emerson and I.
Okay.
Yes.
So just you and Emerson. And
Yeah.
how old was she at the time?
So I guess 2, maybe. Yeah.
Approximately.
Yeah.
And at the house, was it just Doug and Ashley then
Yes.
when you left?
Mhm.
And you've obviously been in contact with your daughter almost every day since the shooting, correct?
Leading. No,
You've been in contact with her basically every day, correct?
Not
Since
initially, no.
for the last
I don't know.
several
I
years,
haven't
you've been
heard
in
from her
contact with her every
today.
day.
Well, yeah.
Okay.
I
And
don't know how to, okay, yeah.
did she ever, during any of these conversations, tell you what happened when she had to shoot Doug?
Never. Nope.
When you came back from the park, I'm assuming she was already in the squad car or she was already with law enforcement?
I had no idea where she was.
also staying.
Okay. So at the time that the shooting happened, she didn't tell you what happened,
No,
correct?
we've never talked about it.
And
No,
to this day, you've never talked about it.
No.
Thank you. No further questions.
Cross.
Good morning, Ms. Byers.
Morning.
Are you nervous?
Yes, very.
Brian is
Scared?
in the way.
Yeah.
All right, just try to relax. If my questions aren't clear, please just ask me to repeat it.
Okay.
Was there ever a time when you and Ashley resided here in Bradenton, in the home, that Doug lived in that house?
Never.
I don't know.
Would it be safe to assume, and perhaps you can enlighten us a little bit, how was your relationship with your granddaughter, Emerson?
Oh, very good. Yes,
Okay.
we're very close.
And would you try to spend time with her?
Yes.
Would that include you taking her somewhere on a regular type basis?
Yeah.
Would that be to the park?
Yes.
And tell the ladies and gentlemen of the jury, Ms. Byers, how often you engaged in that practice of you and Emerson going to the park?
Usually several times a week. And we'd go after it cooled down because a park does not have very good, tree coverage. So it was very hot. That was the only comfortable time to go.
So we think trying to avoid the heat or minimize it'd be later in the afternoon.
Yeah, it was brutal out there otherwise.
Yeah.
Florida,
Almost as bad as it is now.
Right, exactly.
How far away was the park?
It's a short walk. I mean, we'd always walk over there. So I don't know, take us maybe 5 minutes to get there.
Okay.
So
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived.
yes, we're walking down the driveway and I had her in the stroller.
And on this particular occasion, there was nothing unusual about you going to the park, just
Oh,
like
no.
you
No,
did
but
regularly.
Yes.
Give me a moment, Your Honor, please.
Who are you talking
He's
to, Gabby?
driving. She's driving. That's what happens when she drives. The trash bag has no mother.
I believe that's all I have, Your Honor. Thank you, Ms.
Can you redirect?
No.
Oh, hold on, ma'am, don't get up yet. No redirect.
Yeah.
Can this witness be released?
Yes.
Yes.
Ma'am, you are released from your subpoena. Your, the rule of sequestration had been invoked, but you're now released from your obligation.
Okay. All right. Thank
There
you.
you go. Thank you.
Judge, I apologize. In consulting with counsel, I do think I want to leave her under subpoena for
All right,
sorry.
Ms. Byers.
So what does that mean?
I'm going to explain that.
Okay.
All right, so what that means is you remain under subpoena and subject to being recalled at the trial.
Okay.
The attorneys at the beginning of the case invoke what we call the rule of sequestration. So the instructions I'm going to give you are similar to what you've already probably been told by the attorneys. You're not to discuss your testimony.
I think the prosecution's leaving her that way so she can't talk. And she can't sit in there the rest of the trial.
Bad pause, bad pause. What you gonna do?
I'm good
What
at
you gonna
that.
do when it pause for you? Bad pause, bad pause.
It's a gift. I didn't know I had it until YouTube showed me. But I think you're right, Brian, that they are saying
Yeah.
that got her out of the house. But I also
No,
kind of
it
wondered
just
if they
means that-
were. Go ahead.
It just means that he could drop his act because people like that won't behave badly in front of the mother.
Yep. That too. Excuse me. I don't know why I'm so hoarse in the mornings, but I also wondered if
That's
they
all right,
wanted
I'm
to
a
show
goat.
the difference between the how she acted towards the defense and towards the state of, I don't know, she didn't talk to me. And she softened towards the state, but that happens all the time. I don't know. And Carmen,
She
you
had
do tell me a
counsel
lot.
very quickly.
Yeah. But, Carmen says she tells me everything. But to a point, I know that she knows in her field of work, they're saying she cannot tell me. So if somebody asked me if Carmen told me everything, I could honestly say no.
Mm-hmm.
So I know there's things that she does not tell me because she cannot tell me. And I probably don't want to know.
Yep.
But I think it's kind of crappy that the state is keeping her under subpoena. They're not going to ever call her back. I think they just are going to not let her sit there.
Yeah.
Testimony here in court, the questions asked of you with anyone else, including the attorneys. You can't talk with other witnesses about what their testimony was or the questions they were asked. And it's my understanding this may be online. You are prohibited from watching anything that's going on within these four walls, ma'am, until you're released from your subpoena or until the jury comes back and the verdict is released. Okay? All right, thank you, ma'am. You're free to go for now.
Yeah, that's pretty crappy.
All right, State.
State will call Barbara Russell.
Oh, this way. There you go.
There's been 47 objections so far in this trial. Yeah.
Was it snowing?
Do solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth.
So help me God, I do.
All right, I didn't hear. What are you laughing at? My stomach's growling. Sorry.
I was wondering if they nailed down whether it was snowing or not.
Well, maybe those white sandy beaches are something to
What, if
nail
anything, was
down
the
there.
weather doing?
Yeah.
What, if
He
anything, can you
went there.
tell us about the sunshine in Florida and all year? Like, I don't know.
Thank you so much. Good morning, ma'am.
Good morning.
My name is Judge White. I'm going to be presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches away from the microphone. It does adjust up, down, left, right, however you need it. But if you just speak directly and a loud, clear voice into the microphone, it'll pick up everything.
Thank you, sir.
And please state your name.
Barbara J. Russell.
Can you spell Barbara Ann Russell?
BARBARARUSSELL.
And what is your profession?
I'm a licensed clinical social worker. I have a doctorate in clinical psychology, and I work as a clinical and forensic mental health professional.
Okay. And how long have you known Ashley Benefield?
I've known her since April of 2020.
Okay. And when you first became involved with Ashley, it was on a professional level, correct?
Correct.
All right. And then since the time that you had that interaction, you have stayed in touch with Ashley.
Correct.
And subsequent to the shooting that happened, she actually moved into your house, correct?
Correct.
Okay. And who all lived at the house?
Myself, my husband, and my 19-year-old daughter.
All right. And approximately how long did she live at your house?
Approximately 8 months.
And you would see her on a daily basis?
Pretty much, yes.
Okay. Did she, when you first spoke, when did you first see her or speak to her after the shooting?
About 1 o'clock the following morning.
Okay, so this happened in the evening time, so it would have been 1 o'clock the next morning. And at that time, did she say to you, oh my God, he came after me, I had to shoot him? Did she say that?
She didn't discuss what had happened at all, nor did I ask.
Okay. And to this day, are you still in contact with her?
Not that one. I'll overrule on that question.
To this day, are you still in contact with her?
Yes.
And to this day, has she ever told you what prompted her shooting, Doug Benefield?
She never gave any kind of narrative of what prompted the shooting. My understanding is that
I just want to know if she told you. I just want to know what she told you. She did not tell you anything, correct?
She never gave me any narrative about what had happened.
Thank you. No further questions.
Cross, sir.
Morning, Sarah.
Good morning, Dr. Russell. I have a question from your own personal knowledge. You're aware that
Good morning, Sarah.
Ashley's lawyers instructed her not to discuss the facts, correct?
Of course, any good lawyer would do that.
Carmen.
Give me just a moment, Your Honor.
Of course. Yes, sir.
Did there come a time, Dr. Russell, when a detective, Warren, contacted you about the case?
Yes.
Did you have discussions with Detective Warren?
I met with him once, yes, for about 90 minutes.
And in that meeting, did you relate to him that,
Objection, yourself.
I'm asking a question to this witness.
Well, I understand, but if it calls for hearsay, why don't you approach so I can hear what the question's going to be?
In my defense, Brian wasn't a huge fan of Gilligan, and I wasn't a huge fan of the Munster, so she really might not know.
Me either.
I like the Addams Family better. Yes, Gilligan's Island,
Do.
but Gilligan just got on my nerves. Like, how do you guys have so much stuff for a 3-hour tour? Why did she bring her wardrobe, the actress? Why did you bring your jewels? Why did you... None of that makes sense. And Todd, He's like, it's just a show. I'm like, but it needs to make sense and it doesn't. And that's why I don't like it. How did these people end up there? But they never get help. Like, yeah, your dad watches it when I'm not around because I don't like it. Like, you turn that. I guess we just all need to take everything when we go on a 3-hour tour at the Coconut Radio. The professor was great. You know what's kind of bugging me about
Professor
this
and
witness?
Marianne.
They say they didn't allow their DV witness for the defense to come in, but yet they're allowing this witness to come in for the state. That kind of bothers me. Wilson.
I don't think she stays for very long.
I mean, she's
Huh.
yeah, everybody. Wilson.
If you're a member of a channel, how do you bring that up in the chat?
What do you mean? Like,
where it says, you've been a member for so and so months.
well, it took Gabby and I a long time to figure it out, but we did. So every month you'll get a free chat, and if you click on the $ down below where the chat is, if you hit
it will bring that up.
It'll give you the option to put one of those up. So I was trying to explain it to Carmen because she should have one.
Free membership milestone chat.
Yeah.
Cool.
Yeah, it took Gabby and I forever to figure that out because I'm like, I can't bring it up, but you can. But I knew people, like Gabby's been here for quite a few months now, but I couldn't bring it up. But then we finally figured it out one day. All the clean clothes, the gowns, Sarah, everything was great on that island. Everything worked well. Like, no problems. They got steam from the volcano.
When you spoke to Detective Warren Justin, you identified yourself.
Correct.
Okay. This was a face-to-face conversation.
Yes.
If you were to tell us today in court
Me too, Carmen.
about the discussion you had with Detective Justin, would it be any different than what you told Detective Justin on that day?
No, of course not.
You have an opinion, do you not?
Objection.
Rephrase. As you sit here today, do you have a conclusion?
Objection.
Sustained.
All right, give me a moment.
Let me figure out how to ask this question. All right.
I see the pictures that were in here yesterday.
She should just blurt out what she wants to say.
I can't hear you, Brian. What'd you say?
Oh, I said she should just blurt out what she wants to say.
Just look at her. Look at her face, man. That was a horrible pause on her too. I don't know that there's a good one. Yeah, I don't think she wants to say it though. She's not gonna. I don't think she wants to say anything to help the defendant, to help Ashley, but maybe.
I think she's her doctor.
Yeah, but I don't. Is she want to help her, or is she?
Well, she did make that
Skeleton meat thing?
statement that, when you said, her lawyers told her not to say anything, and she's like, yeah, any good lawyer would say that.
Yeah.
So she's flattering the lawyer at least.
Yeah. I don't know. The state's fighting it pretty hard, but they called her. Oh my gosh, you guys are not being nice.
What are you munching on, Bri?
Peanut M&Ms. Sorry. I guess my microphone's better than I thought it would be.
I'm going to join you.
I'm gonna eat some Cheez-Its. I have strawberries sitting
I
here.
almost got those on my way home.
They were 2 for $6, so I got the original and the white cheddar. So I'm gonna eat some of those while you guys are munching away too. All righty. Just yell if you need me. I am so sorry. I cannot hear you guys.
Dr. Russell, you had an opportunity that morning, from what you had to say at approximately 1:00, technically the next day, to observe Miss Benefield, correct?
Yes.
I'm going to pass you a picture that's previously been marked as State's Exhibit number 21, picture of Ashley Benefield that was taken on the day of the incident.
Yes.
May I approach you on it?
Yes.
Does that picture reflect any swelling to Ashley Benefield?
Objection, as interpreting the picture.
Sustained.
Did Ashley Benefield look like that when you saw her prior to the day of the homicide?
Prior to the day, no.
Okay, what was different about her?
When I saw her after the incident, there was edema, sweat swelling on the side of her face.
Okay, and did that include her right eye,
It included her left eye.
left eye rather?
Yes.
Okay, and when you saw her before the homicide, did she have swelling on the left side of her face, on her cheek and her eyelid?
She never had, no.
In fact, when you saw her immediately following the incident that morning at about 1 a.m., was there any indication that by Ashley that her head was hurting?
Objection, hearsay.
Sustained.
Spontaneous statement, Your Honor.
That existing mental, emotional, physical condition.
Can we vote?
Yes.
Oh, sidebar.
I gotta go talk about the snow.
Mm-hmm. Oh, funny
I
looking.
all right, ESPN. Her trials reset for January, I believe. So
Who?
Karen Reed.
Really? Oh,
Yeah,
yeah,
they
yeah,
had a
yeah.
hearing
It has.
last week.
27th. Yep. Yes, it has. But they've got to still go through the they haven't addressed the motion to dismiss or anything. The jurors, they've reset the date for that. Bev didn't do anything.
How do you call it? How do you go back to trial when your investigators are being investigated?
Yeah. She just set the date. just to lock it in.
Did Ms. Benefield that morning give
Good
you
morning,
any
Peter.
indication that she was in
Good
pain?
morning.
Yes.
And did you refer to any particular area?
Yes,
What?
her head.
Thank you.
Did I hear a boop?
I heard a boop, but I don't see anybody.
Good, Rick.
No.
Can this witness be released?
Yes. Oh, I'm sorry. No. She's Jermaine. I just
She can be released at this time. Ma'am, the rule of sequestration has been invoked by the attorneys, so that means that until you're released from your subpoena or until the jury is discharged, you're not to discuss your testimony in this case with anyone outside this courtroom, including the attorneys. You're not to talk with any other witnesses about your testimony. You're not to talk with any other witnesses about their testimony or the questions that were asked of them. And it's my understanding this may be online, so you're prohibited from watching anything that's going on within these four walls.
Absolutely.
Thank you, ma'am.
Thank
Just
you.
leave the picture there.
I will do so. Thank you.
All right, State.
Judge, the state call Lieutenant Dan Dickerman. I know he was caught in the line, so I just want to make sure it's here.
I think this is the lead investigator.
Do what?
I think this is the lead investigator.
Okay. Gabby, did you boop? I heard a boop and there's nobody here. I'm looking around like I'm still trying to find somebody. I have nobody. So I don't know what happened. Yes, but I heard a boop. Are we approaching again? Yep.
Mm-hmm.
Yes, Carmen. Don't say it too much because you'll start booping your animals in the nose like I have been the poor dogs. You did not poop. I didn't ask if you pooped. I asked if you booped. Don't really care about it if you go to the bathroom or not. But we all heard the boop. I agree. Must be witchcraft afoot. All right, let me unmute us.
You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do. Oh, sorry.
Carmen,
My name is Judge Ryder, presiding over the case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It does adjust up, down, left, right, however you need it. Just speak in loud, clear voice and should hear it.
Yes, sir.
Good morning.
Good morning.
Please state your name and spell your last name.
Daniel Dickerman, Dickerman.
one of
And
those.
where do you work?
At the Manatee County Sheriff's Office
How long have you worked there?
for almost 29 years.
What is your current position?
I'm a lieutenant in road patrol.
And what was your position back in 2020?
I was the senior homicide investigator assigned to the Manatee Homicide Investigative Unit.
Okay, so Manatee County, say that again?
Manatee Homicide Investigative Unit, MHIU.
MHIU. Okay,
Yes.
so you were the senior investigator in that unit.
Yes.
And if you could just explain a little bit, what is that unit?
So that unit is a group of detectives formulated from all the agencies within the county, the sheriff's office, Braden Police Department, Palmetto Police Department, and all three beach agencies. We all respond out to all homicides that occur within the county, regardless of city jurisdiction, everything, so we can all work together and investigate that and determine if any criminality as a result of that homicide will need to come forward.
And just discuss a little bit how you work as a unit, and is that different than how a detective may work in a different part of the sheriff's office?
Yes. In the sheriff's office, most cases are assigned to a single detective. They go out, they do all the work, they write the report, they bring everything together in a normal, smaller case. In these cases, we determine what we call a lead detective. That lead detective then becomes for all intents and purposes, the supervisor of the case. He makes assignments. We go out, all the other detectives, we do our respective assignments, we report back. The lead detective becomes a basic gathering point and a keeper of all the information to make sure the flow goes smoothly to one location and we're not duplicating efforts or stepping over each other's toes. And then he makes the ultimate decision once he has all the information.
Okay. And are you, as a unit, a part of any decision-making that happens within the unit or that happens in a case?
Yeah, we have meetings on every case
Okay.
to discuss the comings and goings and the happenings of the different case.
And so did you work in this unit, the MHIU, at the time that the shooting occurred?
I did.
On the date of the shooting, were you notified of the shooting?
I was.
Okay. And about what time was that
It
approximately?
was between 7:30 and 8 p.m.
Did you go to the scene?
I did.
And when I say the scene, where the shooting happened.
Yes, to the neighborhood of White Rock, I believe it was.
Was the defendant there?
Yes.
Where was she?
She was in the back seat of Deputy Burley's patrol vehicle.
Did you go into the house?
Not at that point. I did after the crime scene unit had already documented everything and made sure nothing would be contaminated, done their investigation inside. Then I went in briefly at the end.
Okay. And what did you see?
I saw some blood trail on the floor, a bullet strike in the wall of the bedroom from a projectile. And that's about it.
And were other members of your unit there at that scene?
Yes.
Were there other members of the unit at other scenes or other places?
Yes. Detectives were also sent to our main offices, criminal investigation division, which is where our interview rooms and our offices are located.
Okay. And from the beginning of when you arrived on scene, you knew that there was a self-defense element of this crime.
Sustained.
Did you know there was a self-defense element when you got there?
Object the leading. How will the rule on that?
Yes.
Okay. While you were at the scene, were you made aware that the defendant was going to be going to the station?
Yes.
Okay. Was the defendant's mother, Alicia Byers, there?
Yes.
Did you speak to her?
Yes.
And at some point, did she hand you a phone?
She did.
Okay. And did you know why she was handing you the phone?
Originally, no, but then
Okay.
I found out shortly after.
Who was on the phone?
A lawyer.
Okay. And did you speak to that lawyer?
Object. Sustained.
Did you explain to Alicia Byers what was going on and where her daughter was going to go?
I did.
And ultimately, how many lawyers ended up at
Relevance. If you want to approach it, explain the relevance.
It's bizarre watching yourself on two channels with the delay.
It is. It's crazy. So I tried to just turn you up. So if I turn Jodie's volume up, but if I turned it up
I
for
can-
you guys, it's too loud. Let me know.
I can turn my mic up. Is that better?
Yeah.
Can
I
you
can't
hear
hear
me?
you or Brian like when the court is going because it's so loud.
Mm.
So I can't edit his settings because he's on mute. Oh, I agree 100%. And they didn't let her mom stay, Sarah, so I don't know.
At the time the defendant
I
went
don't know who's
to the
there.
station, was she under arrest?
No.
Was she ever arrested that night?
Object leading. Sustained.
When was she arrested?
Sometime in November.
Okay. And the shooting happened?
In September.
And that seems to be a month or two delay. Do you know what delayed that?
But for the investigation to continue into the self-defense claim.
Okay. Did you go to the neighbor's house, John Sant?
I did go there briefly, yes.
Okay. And did you have any discussions with him or anyone?
I did not, no.
Okay. Was Child Protection Services on the scene?
Yes, they were called to the scene.
And well, just briefly, what is Child Protection Services?
Objection. Relevance. Consistent with the court's prior concern 403.
He did bring this up
Ooh.
at the beginning.
What is Child Protection Services?
At the time, it was a division of the sheriff's office entrusted with protecting the children from abuse, or make sure they're in good locations, or just make sure they're healthy.
Okay. So do you know why they were there?
Objection.
Did CPS try to speak to Alicia Byers?
Yes,
Okay. Were you present when
Yes.
Alicia Byers?
yes.
Was Alicia Byers cooperative with them?
I wouldn't say fully cooperative. She did ultimately answer a vast majority of the questions, but not cooperative per se.
Okay. And was there anyone else present at the time when they were trying to speak to Alicia Byers?
Off and on, Barbara Russell was present.
Did you also assist in executing a search warrant?
Yes, I was on scene
And where was that search warrant? Was that at the house?
at the house.
Okay. Did you have any assignments for gathering evidence?
Yes.
And what evidence was that?
To originally look for video in the area of the park of the neighborhood.
And did you do that?
I did.
Were you able to obtain video?
I was.
And on that video, did you see what we believe to be Alicia Byers and the child at the park?
Yes, they were at the park.
Did you also obtain other types of videos?
Yeah, I also viewed ring video from the scene itself.
Objection. Relevance.
What video?
Ring from the
Ring.
scene.
But overruled, I mean, you could say he viewed it.
Okay. And in viewing that, did you see any part of the incident that we're here about? Was it captured on the Ring camera?
The shooting, no. The arrival of the U-Haul and the arrival of the deputies were on there.
Okay. I have no further questions. Thank you.
Close.
Good morning, Lieutenant.
Good morning.
So through your testimony, among other
Thank you. Jodie.
Ping, ping, and pew pews.
Pews. The ping ping comes because of the we figured in the Bell McNabb trial that everybody was spitting, chewing tobacco. And hitting the platoon. So, but thank you. I appreciate that very, very much.
Welcome.
What about Back to the Future? Was that a good video? So, yeah, Carmen, I can't put it up because it doesn't show in StreamYard. That's all it shows is spittoon, spittoon, spittoon.
Yeah.
They didn't charge her with first degree. So they don't think there was premeditation there. So this whole thing about her mom taking her daughter to the park, who cares?
Mm-hmm.
If you're not bringing up premeditation, it doesn't matter. Or maybe I'm not thinking it correctly, but if they were
I
trying
agree.
to, they didn't
Waste of
charge her that
time.
way. Yeah. So I don't know. I don't know what's happening here, but not a lot. So maybe that's why they kept the mom and then that doctor under a subpoena. Maybe I thought he was going to say something so they could call him back and say, "Isn't this what you said?" But he didn't say anything. So I don't know what they're trying to do here, but we shall see. I expect a ton of objections.
Mhm.
Things, the state proved this morning that there was a U-Haul truck there
Yes.
and that the deputies arrived
Yes.
and that there was a homicide.
Yes.
Okay. Now, you
Well,
mentioned that often the practice is when you respond to a homicide, it takes some time to conduct an investigation to determine if there's criminality.
Absolutely.
Okay, so in other words, you don't come upon a homicide and determine as soon as you see a dead body it's murder.
Correct.
Okay. If I wanted a job in your unit that you supervised and I felt all homicides are murders.
Objection.
Fair question, Your Honor.
Objection. Pre-trial one.
Sustained.
man, she looked pissed.
Yeah.
She's gonna freaking body slam him.
You mentioned that the arrest of Miss Benefield, well, let me start from, I think you told us she was in the back of the squad car.
Yes, sir.
She was in handcuffs.
Yes.
And this is a squad car with the doors that you can't open from the inside and the back, correct?
That's correct.
With a cage.
Yes.
So she's
Relevant.
in the back of the squad car, in handcuffs behind her back,
Yes.
in a car with a cage, and you can't open the doors, but she wasn't under arrest.
No, she wasn't charged with anything.
Okay. So I think you told us that the reason for her being arrested approximately 6 weeks later, I think, was so that the investigation could be conducted.
Correct.
Because you had to determine if there was criminality.
Correct.
Okay. Could have been a homicide that was self-defense.
Could have been. That was the claim.
That's the whole point of the investigation.
Absolutely.
And that kind of an investigation, understandably, takes time
It does.
and patience
Yes.
and professionalism
Yes.
and knowledge and experience.
Yes.
Do you know how old Lieutenant Alicia Byers is?
I don't.
Do you recall meeting her?
I do.
Approximately, give us your best shot.
I mean, I would guess in the inner 40s to 50s.
All right. Was she a young woman?
No.
She was pretty exhausted that day, wasn't she?
That's
She appeared
young.
to be. There was a lot going on.
Would it be a fair statement, Lieutenant? You seem like a pretty straight guy. Was she emotionally distraught?
Yes, there's a lot of emotions going on there. Yes.
In fact, her first thought upon coming back from the park with the daughter and seeing the
Objection.
cars was
Hearsay.
that her daughter was
Please
dead.
stop
Sustained.
talking.
She's nasty.
Unless you'd like to make an argument for an exception, then you can approach.
Rest gesti?
Well, if you'd like to approach.
It's all right, Your Honor.
I'm with you, Brian. But this is crap.
I think, Lieutenant, excuse me, you told us that you went into the residence after crime scene had completed their portion of the investigation.
Yes, sir.
And do you recall crime scene was there before or after EMS?
A crime scene comes after EMS. The sanctity of life always comes first.
All right. So EMS was there first, and you were there, so you know they dragged Mr. Benefield out of the home from
Yes.
the bedroom.
Yes.
So when you told us that crime scene was there to preserve the scene, can we agree, Lieutenant, that what crime scene preserved was the scene following the EMS people not only working on him in that bedroom, but moving?
Yes. As always, that we preserve the scene after we attempt to save the life.
Okay. And so those crime scene photos show us, for example, what that scene looked like when crime scene took the photograph.
That is correct.
It doesn't show us what the scene looked like when EMS was running around doing what they do.
That's not possible. No, that's correct.
Okay, and that would have included the initial deputies on the scene as well.
That's correct.
Give me just a moment, Your Honor.
Yes, sir.
My nephew turns 21 next month, right?
Well, at least he's still young. Compared to us old people over here.
Thank you, Lieutenant. Appreciate your candor.
Thank you, sir.
That's all.
Redirect.
Yeah.
Mm.
Can this witness be released?
Yes.
Mr. Taylor, can this witness be released
Yes,
from your
sir.
subpoena? Sir, you were released from your subpoena. You're free to go.
Yes, sir. Thank you very much.
Don't release him.
Please state.
We approach.
Keep him in witness jail like everyone else.
Mm.
What'd you say, Brian?
I said, don't release him. Keep him in witness jail like everyone else.
Yeah, he did nothing.
They're screaming through the witnesses.
They are. What did he bring?
Yeah.
Oh, yes, Carmen. AARP, even though you spelled it wrong up there, you corrected yourself below you. Don't worry. They will send you something, so make sure you have it on your 50th birthday. Because they did me. Whoopsies. I was like, thanks, guys. Thank you,
Well,
Sarah.
I keep throwing mine in the trash, but I guess now I know I'm like super old. I better start opening it.
Welcome to Team Koala, Sarah. I appreciate that. It's awesome. Yes, we are old. We just were told we are not young anymore.
Welcome, ASMR on Cloud 9.
Well, you missed the crunching a little bit ago.
Hang on. I can fix that.
Yes, Sarah. It
I had
was.
to stop. I'm making myself sick with all this candy.
Oh yeah, I put mine in the drawer, so it's out of my I have to work a little harder to get it, but I kept the crackers out. I'm getting my strawberries in a minute. It's Grandma. You little.
Oh, hello, Grandma.
I love that. That's hilarious. That's funny. I didn't, Sarah, you should have told me it wasn't working. I would have looked into
What
it for
wasn't
you.
working?
I guess trying to become a member.
Oh.
Because she said it worked, and then she said, wonder why it worked finally. I don't know, but let me know if you have any more problems. Grandma, you're so nice. Be careful running around if that's what you're doing.
Can you set up your membership tiers prior to monetization, like and have it setting there ready to go, or?
I don't think so. And once you set them up, you can't edit them as long as there's members on it. It'll cancel everything. So like you can't edit maybe like with the benefit, like if you're a member at this tier, you get this, or because I need to edit some of my descriptions, but I'm scared to touch them. I mean, you and well, I don't think you and I have had some conversations about monetization. Gabby and I was just telling her that like last night that it's just a stupid game. Because if I tried to monetize the stream while I'm streaming, then ads run, and that people don't like that. I was skipping them yesterday afternoon when I could watch them. And then, but if I monetize it after the stream, I have to make sure there's so many like things I have to make sure didn't happen. And then it's like it's almost like you accept the rules that we may not have even written yet, right? If you want to monetize the stream, and if you do that and you break one
Ah,
that you don't even know about, you're like in more trouble than if you just monetize it to begin with.
so you have to select that while you're setting up the stream.
It's easier to set it up while you're setting up the stream, but then so like people that don't have YouTube Premium see ads every so often. And so I know that's annoying. I was like, I don't know. I'm trying to find a balance on it because I don't want to
Mm.
punish myself in it.
I don't mind the ads now that I know that you get paid. So
Thank
bring
you.
them on.
I
Bring 'em
appreciate it. I've skipped a few. I put it down to the lowest that I could this morning for YouTube to put them in automatically. Yesterday was on the one, like the middle one. So I don't know how often they were popping up, but I skipped them yesterday afternoon when I got home and I could actually see it. But I don't know.
I don't know.
Just,
I don't get them.
it's a crazy game, and you're about to join it. You are about to volunteer as tribute. I hope we both survive.
Like a sacrificial lamb.
Yes. to the YouTube games, where the rules will never ever be in your favor, and they will always
correct. Can manually put in ads by clicking in the studio. So when there's a downtime like that. Ah, okay.
Yes. But can you do that when you're live? Because I've seen that one too. And I didn't know if I could do that live because I didn't really want to go back through 8 hours and trying to find a break to put them in. I can. So awesome.
What do you get paid per ad? Do you know, or?
Oh, it's a tier system. Nothing.
Oh, depending on how many you let through.
Yeah. Yeah, the odds are never in my favor and be never in your favor.
Mm-hmm.
Or ever in your favor. Sorry, I read that wrong. Yeah, Gabby was reading it off to me one night. I was like, okay, so I get a half a penny or something.
Uh-huh.
I mean, it's gonna take a while, and it's views, and it's everything.
Yeah,
it's everything. People.
It's time as well.
It is
time still.
I don't think there was time, but it was how many people view the ads. I don't think you get docked if they click through them. Like when it says you can skip, I don't think you get docked on that. I don't know. I haven't had it long enough to see what it's going to be yet.
Yep.
Because they're like no data yet. So I'll tell you when I have data to. Well, I don't know, Carmen. I was kind of being sarcastic, but probably not. Probably about right.
I hope they round up.
Oh, me too. Well, Sarah, we'll just make you an honorary American. Yes. Yeah, you don't get in trouble if they skip. I'll have to watch and start putting them in. Well, not tomorrow. Friday, I'll try to do it manually. Put them in on the breaks. And then I can tell you guys, hey, I'm about to run an ad. Sorry. Yes.
Well, you may as well when they're in a sidebar.
Yeah. Yeah. If they skip the first one, the second one won't play. They're what, 5 seconds? They're not long, right? Or do you have to watch 5 seconds? I don't remember. And then you'll also get you get something from YouTube Premium too. So if you have people that sub that have YouTube Premium.
Yes, I do.
Know. If you put them in on sidebars, you probably could retire after the Canton trial.
Yeah.
I don't know if I can change it now. I'll hit play and let me look to see what happens here. I'm sorry, that officer is shaped funny, and I'm sure he's got a vest on. Oh, I did not think that it did. It's less than half a penny. Oh my gosh, 2 days in a row. Chrissy, what have we done to deserve your
How's
presence?
school going?
Whew. Chrissy's our Southern California girl. Yes, how's school going, Chrissy? You're on a break, right? I think
Wish they all could be California.
$1 per 1,000 views.
Oh,
Okay.
mhm. Yay!
Wow.
Okay, don't give up on your 401k.
Ah. Yeah, Sarah, the bad thing about YouTube is you learn live. I
Yeah,
can't,
in
you know
real
what I
time.
mean? You're learning with everybody watching you learn, and so it's like it's scary to try to choose one, and then when they say this is recommended, it's like fine, just do that one. Let's just do that. Chrissy is on a break. I thought she was. I hope so, Grandma, because yeah, it's been fun. Jodie and I have had fun. Having to send her
Hello, Bob.
messages because we keep getting demonetized because of music. That
Oh,
it's stupid.
yeah, that we pay for.
Yeah. Hello, Bob. We are here giggling.
Yeah.
4 weeks. What do you got, Chrissy? 4 weeks left in this term, and I think a week off. All right. I'm just happy to see you, Chrissy, because I miss you. She was, even though she's 3 hours behind, she was always with me every morning early.
Oh,
So I miss her. Thank you, Sarah. We're working hard.
yeah.
Hardly. It is a job that looks easy, that it takes everything out of you.
Yeah. Got no idea what goes on behind the scenes. Mm-mm.
Okay, I'll shut up now.
No.
Well, so far I haven't heard I think you drank some hot tea and made it
Had a
better.
lozenge.
Yes.
Well, no one seems to have been confused today, so I'm using my regular voice. But if you're
Yesterday
getting
was
mixed up, let me know and I'll switch back.
Okay.
yesterday was rough. I'm like, who's talking? All righty. Like I said, I know that guy has his vest on, but okay. I won't say anything else. Okay. Well, I mean, is it hard to challenge it, Grandma? Because that's why I just haven't done it, because I'm not a lawyer.
The silly thing is, I chose the free music on Canva Pro that I pay for, and they still copyright.
Yep. And it's whatever is at the end is what it was. That's what I got. So I just muted it. I just took all the noise. It's just silent now.
Yeah.
It's like Bri has a touch of
Yes.
what is the type of voice you want to read you a story. Yep. I knew she messed up, so I knew she didn't mean touch. You miss squeaky lettuce?
Huh.
Well, you're not here. All right, Grandma. Well, I guess I just need to buck up and do it. You just don't want to screw around with them too much because they'll be like, "Oh, well, sorry, your channel's gone." Oops.
All right, here's the jury. We're gonna go ahead and take our mid-morning break right now. So you can step back into the jury room. Please close your notes, leave them right where they are. It should be 10 or 15 minutes. Stretch your legs, get something to drink back there, use the facilities. Please don't begin discussions amongst yourself. You are free to still use your cell phones to send, receive text messages, calls, anything like that. But please don't discuss the case outside of this group and don't do any research on the people, places, things, or legal topics we've heard anything about. Thank you.
Okay, so this is where you insert Liberty Bibbity. Liberty
I'm trying.
Mutual.
I'm trying. I changed it, but now I don't know. How do I do it? Because as soon as I changed it, it says, "Focus on your stream and let YouTube insert ads for you."
Right.
Wait, are they showing the jury walkout?
No, I think those are the
Oh, that's just okay.
spectators.
The next witness
Ones
up
who are in
is,
witness jail.
I think the next witness after is the custody attorney.
Where do oh, here it is. I inserted an ad. Is anybody seeing an ad?
Now I've got YouTube Premium.
Let me know if you just saw an ad. I hit the $sign. It said, "Oh, okay. Yep, Sarah got one." All right, guys. Well, then I will be in. Well, here, I'll click it again. There we go. Ad inserted.
No, I don't see it.
I know you guys don't all get them. Yeah, at the same time. Chrissy got an ad. You get an ad, and you get an ad. Boop. That's on you. Boop.
Yep.
Oh, look at you, special Gabby.
I must have
All right.
my YouTube force field on because I'm not seeing any.
There's one more.
They're probably storing them all up for me, so I'm probably going to get 4 hours worth of ads.
Oh, it's random on each person's channel, depending on how much they've seen. Well, Bri, I know you've got them before.
Yeah. Did you send an ad for the great state of Florida? Because that's what I'm seeing.
I did not.
I think they're just random, aren't they?
No, he's talking about the seal.
Oh.
All right, I hit it again. Gabby says I'll get like 10 in a row at some point. Right, I'll quit messing with you guys.
Hit me with your revenue stick. Hit me.
How many times can I click it? Can I just be like, click, click, click? I'll just all through lunch. Click, 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 click.
Yep.
All right. I knew we had some time.
So anyway, before they've only been going for an hour and they'd already take a break.
Uh-huh.
Yeah, it feels like. Really, Chrissy? I had them. See, that's what I was worried about. I was skipping them. You shouldn't have been getting anything yesterday afternoon after I got home because I skipped them because I don't want to be annoying.
Well, maybe YouTube taxes are higher in California.
Don't you bring that magic 8 ball out, Gabby. Judge got a tinkle. He had to go to the little lawyer's room. That's what one of an attorney said when we were watching the trial one time. He's like, Judge, can we take a break? I need to go to the little lawyer's room.
Yes.
Seriously? Why can't they do this? All right, you guys are getting an ad. I'm punishing
He's
you.
like,
You're welcome.
he's like, what? I'm trying to go to the bathroom here.
Just get your hazmat suit out. Then you don't have to move.
Gabby told me last night because I was telling her about my friend, getting testing positive for COVID, and so I can't see Madison again right now. She said, wear a hazmat suit. And I was like, yeah, and I can pee in it too.
They're doing a lot of construction
Wow.
at my hospital. I'm going to have to ask them, do you guys pee in those suits too?
Thanks, Grandma.
Bye, Grandma. Thanks for all the advice. Grandmas are good for advice. I will need it again, Grandma. You know I will. So let's be ready.
The next witness's dress is bright.
Okay.
Get your sunnies ready.
Yikes. Hello.
MILF.
Bye, Grandma. Love you too. Thank you.
Bye.
Hello, ma'am.
Good morning, Judge.
My name is Judge White. I'm going to be presiding over the case. Get yourself about 12 to 15 inches from the microphone. It does adjust up, down, left, right. Just make yourself comfortable. Will you speak directly into the microphone with a loud, clear voice? We'll hear everything.
Thank you.
Thank you.
Good morning.
Good morning.
Please state your name.
Stephanie Murphy.
How do you spell first and last name?
Stephanie is Stephanie. Murphy is Murphy.
And what is your profession?
I'm an attorney.
How long have you been an attorney?
This is my 23rd year as an attorney and actually in the Sarasota Bradenton area.
And are you with a firm, sole practitioner? What do you do?
My husband and I have our own firm, and I've had that firm for 16 and a half, 17 years. Before that, I was at a larger firm in Sarasota.
And what is your topic of law that you practice?
I practice family law, which is generally comprised of divorce, custody cases, or what used to be called custody cases, and adoption cases.
Okay. I want to ask you about Doug Benefield. Did he hire you?
He did.
And approximately when did he hire you?
He hired me in March 2018. He came for a first consultation on the 13th. He hired me on the 14th of March 2018.
And what was the purpose of your duties to begin with?
Initially, the purpose of hiring me was to draft a letter to Ashley Benefield, who was pregnant with their child at the time, which I did. I drafted a letter and sent it the day after I was retained. But the purpose of that letter was actually just to initiate.
Can't help what I learned at the last trial, Bob.
She stated that she sent a letter, that she was retained to send the letter. Not wanting to explain something.
Okay. Overruled.
What was the purpose of the letter?
The purpose of the letter was to open the door for discussion about Doug's participation in the upcoming birth of their child, but also to advise that if she did not feel comfortable with him being present at the birth, he was respecting her need for space.
And when did you send that letter?
I sent that letter on March 15th at 9:59 in the morning by email to Ms. Benefield.
And did you receive a response to that letter?
I did not receive a response directly from Ms. Benefield. She checked herself into Tampa General the next day to start induction.
Sustained.
Yeah.
So when was the child born?
Well, the child was born early. She was born on March 19th, I believe, is when she was finally born.
And you said early, how many weeks early was that?
Well, the child was originally scheduled, or her due date was April 8th. So I think
Sustained.
So you said you never received a response
not from Ms. Benefield.
from Ms. Benefield about the letter.
Correct.
And to your knowledge, did Doug ever receive a response to that
To
letter?
my knowledge, he did not receive any response from Ms. Benefield or anyone on her behalf.
And I think you might have said this, but the child was born on what day?
She was born on the 19th of March.
And at the time the child was born, did you or Doug know that the child was born?
No, gosh, we didn't know for a good 5 or 6 weeks after she was born.
Okay. And how did you find out that the child was born?
I actually found out because I had been monitoring the docket for Manatee County court system, just because there had been no response. And so on May 6th, I saw that Ms. Benefield had filed a petition for protection against domestic violence on, I think it was April 23rd. So about 2 weeks prior to me finding out, she had filed the petition. And in that filing, there was, she identified the birth date of the child, as well as I think the child's name, which is the first time we learned about that too.
Okay. And you said she filed a petition for, what did you call it?
It's a petition for protection against domestic violence. So it's an injunction. A lot of people refer to it as a restraining order, but it wasn't granted as an injunction at the time.
Okay. So when, just for knowledge of people that may not know, when someone does a request for an injunction, what is sort of the procedure that it needs to go through?
So a person who files a petition for an injunction, they file it at the courthouse in the clerk's office, and then that gets sent up to the judge, usually a family law judge who's just in charge of injunctions that day. And then the judge has 3 options, I believe. One is just to deny it completely. The second option is to grant a temporary injunction, but then there's a follow-up or a return hearing.
Overrule.
And then the third option is what happened in this particular case, is that the judge denied the petition as a temporary injunction. So there wasn't enough evidence in the petition to warrant a temporary injunction, but a hearing was set to review it.
Okay. And when was that hearing set approximately, to your knowledge?
I believe it was originally set for May 8th, but Ms. Benefield made a request to continue that hearing.
Okay, so it was then continued?
It was.
Before the hearing actually happened, did you file any documents on Doug's behalf?
I did. So, well, of course, I filed a notice of appearance in that injunction case. And then we started an entirely separate case. So I filed on Doug's behalf a petition for a parenting plan unconnected with divorce. So he wanted to establish a parenting plan so that he had really time sharing and decision-making for his daughter, because he had none of that up to that point because she was withholding all that information.
And some of the lingo may be familiar to us, but so time sharing, what is that?
I'm sorry. So time sharing is what lay people and a lot of people used to generally call visitation. So it used to have custody, parent had custody, and then another parent had visitation. That was changed, and now in Florida at least, and especially in our circuit, we have parenting plans, which is a comprehensive agreement or an order by the court that lays out all the details of parenting as a not intact family. So the major components are decision-making and time-sharing schedule. So how often the child spends with each parent.
And you said not connected with a divorce proceeding?
Right.
So I would assume that means it can either be with a divorce proceeding or without.
It can be, and of course it can be also in a paternity case, so parents don't have to be married. But in this case, because they were married, Doug was not initially pursuing a divorce because he hadn't had any contact with Miss Benefield for a while. His initial,
Sustained.
Okay. So initially it was not connected with divorce.
right, his priority was his daughter.
And you mentioned the injunction case and then your motions. Were they two different case numbers?
They were two different case numbers. So the injunction case number was 2018 DR 1823. And then the new case that I filed for Doug was 2018 DR 2318. Now they're companion cases though, so they might be separate cases, but they travel together as companion cases and they're assigned to the same judge through this unified family court program.
So when the hearing was set and ultimately heard, were both of those case numbers heard?
Both of the case numbers were heard, but it wasn't our first pleading wasn't the same pleading that was heard at the time of the injunction.
Objection. It's narrative, non-responsive to the question.
Sustained.
So what generally were the allegations in the injunction petition?
Generally, Ms. Benefield was alleging that Doug had been violent toward her. She alleged that he had hit the dog, fired a gun into the ceiling. The biggest allegation was that he was poisoning her and their child in utero with heavy metals.
Okay. When was this hearing finally held?
The hearing was held in two parts, actually. It was July 30th, and then the second part was September 17th.
Not responsive to the question.
Overruled.
And that was the year 2018, correct?
Yes, it was.
Okay. And what judge was this in front of?
It was in front of Diana Moreland.
Okay. And you said it was held on 2 days. Why was it held on 2 different days?
It took a very long time. So we had, both sides had experts, toxicologists, and we had a number of other witnesses appearing. We had,
Objection. Not responsive to the question.
Overruled.
there were also people from the child protective team testifying. And so there were too many hours. And so we couldn't squeeze it all into one day.
Okay. And ultimately, at the end of this, did Judge Moreland make a decision?
At the end of that, she did. There
I'm
were
sorry.
other decisions along the way, but ultimately she made a decision on the two matters that were set as the companion cases.
And what I meant was on the second hearing day, did she make a decision?
Yes, she
Okay.
did, September 17th.
And what was that decision?
There were two parts because, there was two cases.
Objection, Your Honor, just final decision.
For the prior motion?
Yes.
Yeah. Overruled.
Okay, go ahead.
Thank you. For the injunction, she made a lot of rulings and a lot of findings about lack of evidence and then denied
We don't
the
want to,
petitions.
we don't want to talk about
Oh.
what went into that. We just want to know what her
Gotcha.
ruling was.
Okay, she denied the injunction. So
Okay.
that was the first part.
Okay. And then the second part,
The second part was on the parenting
Good
plan
night,
case, the
Carmen.
time sharing case. And so in that,
Good night, Carmen. AJ, you're muted.
God, I'm trying not to crunch my crackers. Good night, Carmen. Go to bed. I wondered how long you were staying up. Also, I can't stop watching the attorney on the stand's eyebrows.
Yeah, she's had some work done.
They haven't
For
moved at all.
sure.
She haven't moved at all. Alrighty. Oh, goodness. She really wants to talk, though. I mean, they're attorneys. It's like 3 attorneys fighting.
Yeah.
2 attorneys against one because they seem
They
so
like
happy.
the sound of their own voice.
Yes, and she's like so satisfied every time the objection gets overruled.
Uh-huh. The other attorney, the prosecutor's got the harshest face. It's very hard.
She does. Somebody said she looked like a wrestler yesterday. Probably Gabby.
Mm.
And she does.
Yeah,
So I
she's
think-
wearing her
Throw
wrestling
down.
like dress.
Yeah.
I think she's gonna body slam that defense attorney when she gets a chance. She's just waiting. There's gonna be like a folding chair in there. She's gonna hit him upside the head.
Yeah.
She entered a ruling for a time sharing schedule. That would be an introduction schedule because Doug at that point had never met his daughter, and that would increase over time on a temporary basis. And then she entered a ruling that he would have ultimate decision-making authority over the child's medical needs and otherwise share decision-making.
Ooh.
And otherwise, I'm sorry.
Otherwise share parental responsibility, which is joint decision-making.
Okay. And as of that day, was Judge Moreland's ruling timed? Like, was it immediate? Was it in the future for the time sharing?
It was immediate. Well, not that day, but she said the first day, and it was just a couple of days later, the 21st, which is when Doug was supposed to meet his daughter for the first time.
Okay. And this time that Doug met his daughter for the first time, were you present?
I was, yes.
And where did this happen?
It happened at Manatee County Sheriff's Department on, I think it's 301.
Did you arrive together or separate with Doug?
Oh, we arrived separately. When I got there, Doug was already there.
And how old approximately was the baby at the time?
I think she was around 6 months old. She was born in March, and this was then the 21st of September. It's about 6 months.
And can you explain how that interaction went? Did you observe it, first of all?
I did.
Okay.
So when I arrived, I got into Doug's truck and we just waited because we were there early. And then he saw Ashley arrive with the baby. And so he pulled the truck closer, and then we both got out of the car and started walking toward Ashley. And then it was just an odd kind of interaction, actually. She turned to me with this nasty look on her face and said to Doug,
I'll sustain as to the characterization.
she turned to Doug and said, "Are you dating her?" And so obviously we both said, well, of course not, no. And then I hung back, and Doug then was standing there, and Ashley approached him with Emerson, and they started talking. Eventually she let him hold the baby, and they just kept talking for a few minutes. Then I was advised that they were going to be leaving together, strangely, that Ashley was going to be going with them for the time sharing.
Was this a surprise to you?
Absolutely. We had just been in knockdown, drag out litigation for months with just horrendous allegations that were unfounded. And yet she said, "I want to go with you." And he said, "Okay."
Objection to the characterization of the allegations being unfounded and continued editorializing by this witness.
Can we approach?
Sustained.
I figured. Can we approach, Your Honor? Because we're doing things wrong. I mean, what does...
That's not fair.
No. Because she just gets to ramble on, and then
Yeah.
it's out there. Like, you can't unring the bell, as they say. But you know what I can do? I can close the
But, you know, she's been paid by Doug, so she was representing Doug, so she's biased towards him, and they're letting her opinions come in.
Absolutely.
That's not fair.
So when they told you they were going together, what was your response?
I pulled Doug aside and I cautioned him about going with her. I advised, his attorney, and so I did advise him. I said, "This isn't a good idea. She's trying to set you up for something. Don't do this." And he said, "I understand. I'm going to go ahead and do it anyway." And so I stayed and observed as Ashley strapped the car seat into the back of the truck, and she got in the truck with Doug, and then they left together for his first time sharing with his baby.
Okay.
For their baby.
So after this first time sharing, did this seem to start a time of peace, so to speak?
It was a time of peace. Actually, before the 26th, but on the 26th, Doug and Ashley both signed a stipulation that I had drafted at
Thank you.
Doug's request, which expanded the time sharing that Judge Moreland had ordered at the hearing on the 17th. So within a week, they had already agreed that he was going to have even more time sharing than Judge Moreland had said.
Okay.
And so that was filed in the court file. It took away the restriction of meeting at the sheriff's office if they chose.
Non-responsive.
So yes, that was the beginning of a time of peace that extended for quite a period of time.
And during this time, well, how long did that last, the peace?
It lasted, to my knowledge, about 11 months.
Okay. And during this 11 months, did you see Doug and Ashley?
I saw them in magazines. Actually, they were attending gala events together. And so they were kind of
Speculative and hearsay.
so other than seeing them together at the sheriff's office, I didn't personally observe them out in public, but I did. Like I said, I saw them in various forms of media. They're quite the couple.
Okay. And you said this peace lasted about 11 months. What broke this peace to your knowledge?
Well, it was my understanding from Doug that they were getting ready to move in.
Hearsay.
Let's not talk about what happened with what Doug said was supposed to happen. But during this time, did Ashley stop speaking to him?
I'm sorry, I didn't hear the question.
During this time, did Ashley stop speaking to Doug?
Leading.
Objection. I'll let you know it calls for hearsay.
Effect on the listener.
Thank you. They continuously spoke to one another for 11 months until August 16th of 2019.
Objection. I thought that was a yes or no. Objection, non-responsive.
Sustained.
Okay. So around this time, you said November 16th?
August 16th
August 16th.
of 2019.
Okay. What happened at this time?
Doug was supposed to be moving in with Ashley and her mother, Alicia. He had moved all these things in.
And we're not going to talk about the specifics of that.
So, counsel, I'm sorry to interrupt. Drunken, I request the instruction from the court about,
Can we not do speaking objections?
Do you need to approach?
Can you stop asking your witness
You know what's
questions she's not supposed to answer?
Yes.
Yeah.
Here comes Oprah again, Gabby.
That prosecutor's forcing me to open these peanut M&Ms again.
Well, the attorney's eyebrows mightn't move, but her eyes can sure as hell roll.
Oh, yeah. It is witchcraft, I tell you. Oh, you disappeared. I hit show and you were like, nope, there it is. You got the 8 ball. That means you're effed. This is way more fun. It's like spinning a weird version of spin the bottle because I don't know who's gonna get it. I think we have time for one more. Here you go. Oh, that's way more fun. Makes me feel better too. That I'm not just being annoying. Even though I knew I wasn't being annoying, I was in control of the annoyance.
It's time for a Fleischer's.
Great, I hate things.
So that guy in the back looks
Chrissy.
a little less sad today.
Aw, which
Did
one?
we figure out who he is? Is he her brother? They do look alike.
They look alike.
Mm.
Chrissy, I like your idea, but I don't do shots anymore. So I'll do a shot of water. You and Gabby can do shots.
have you heard any more about the Hannah Landon trial,
I
AJ?
haven't heard anything. I think we got what till the 31st. I think it's what you sent me last time.
Oh,
That
I
the
can't remember.
competence. Are you
Ah,
calling me
okay.
a liar?
All right, members of the jury, this is one of those situations that's going to take us a few minutes, so I'm going to excuse you back to the jury room. Again, please don't begin the deliberations amongst yourselves. Please don't
What now?
contact or speak to anyone outside of the jury about this case. Don't do any research on the people.
I'll just mute them till they get out. Okay, I will do an occasional shot, but I can't play a game of shots. How about that? Does that make me less of a liar?
If you don't want to do shots, don't let them pressure you.
I'm not doing shots because, well, I was gonna say I don't have anything in here to. I don't have anything in here where I'm sitting to do them with. I'm not. It's not a boomer thing to say. Oh goodness, but
So
yeah,
they're
no
going to
pressure.
spank this witness.
We'll see.
Ma'am, the rule of sequestration has been invoked. You're not to discuss your testimony or the questions that have been asked with anyone, including the attorneys, any other witnesses, any third parties. You're not to talk with other witnesses about questions they were asked or testimony they provided. And it's my understanding this may be on the internet somehow, so you're not supposed to watch anything at all that's happening within these four walls.
Thank you.
Thank you.
They're going to trust her not to open her mouth. She can't keep her mouth shut.
Mm.
She's an attorney. She's like, and a bright pink dress. It is pretty, and it does
Mhm.
look good on her. Look at her little perky boobs. Carmen just woke
And
up.
she knows it.
Oh, I know she knows. Yes.
Mm.
Brian, you're in trouble.
They must have been a birthday present.
You're in trouble with Gabby and Chrissy, Brian.
What'd I do?
Because you told me not to give in to peer pressure.
Oh, well, that's what old people say.
And
Mhm.
you know, you're right, Chrissy. Those boobs were not big enough for Carmen, so that did not wake her up. Yeah. And the greatest thing I have found since I turned 50 last year, I really just don't care anymore. There's a lot of things I'll do because I don't care. I don't care anymore. I don't have to be the most stylish. I don't have to be nothing. I really just, it's like, whatever. And it's nice. It's freeing. All right, let's see what we got. We got boobs in the chat.
Judge, I don't have a specific instruction. We may need to craft one, but what I'm looking for, so that the court knows, is an instruction to the jurors that these hearsay statements that have been repeated by the witness thus far, and for purposes of the remainder of her testimony, the other statements she will undoubtedly try to get out are not being offered for the truth of the matter, but rather being offered for whatever reason that the court wants to ascribe to provide the context to her narrative in response to the question.
So as I said, go ahead, do you want to be heard?
No.
So as I said, I'm not aware of a standard jury instruction in the 2.1 to whatever it is, 2.8 range or 2.9 range that does that very thing. So I want to give the parties the opportunity with the jury not present to look and see if there's a standard jury instruction.
I don't think.
I can give it. Like I said, I drafted one for a prior homicide trial where there were a number of statements that were admitted by me, by the decedent, where there were objections, just like we're having now, numerous objections to hearsay. But obviously, none of them were being offered by the state for the truth of the matter asserted. That's what was argued, and I made that finding. So in order to have just a blanket instruction, I crafted the following and the parties ratified it. So I gave it specific to the decedent statements in that case to, it was either an attorney or some sort of financial planner about some final wishes. And here's what it says. You are about to hear statements made by declarant, and I put the name in. These statements are relevant only to explain the reaction and responses that they elicit. That is, the effect those statements had on a reader or a listener, because there was also a letter that was involved. You are not to consider the statements by declarant's name as true, but only to establish the context of readers or listeners' actions, reactions, and responses.
That'll be fine.
I disagree.
Except for the you are about to hear me.
I can't hear you, Brian.
I disagree with that completely.
I don't like it.
How do they even know that he said those things? She's just saying that he said those things. That's hearsay. No, should not be admitted at all.
I don't like them. I just don't like special jury instructions because you're expecting them to understand them in the context like the attorneys would. So if that makes sense. I don't.
And and in this particular case, they're allowing this witch of a lawyer to characterize statements that we can't even say were ever even made.
Yep.
But he's
That's
the
a
judge.
classic pause, though. Sorry.
Oh, it's good.
Check those expressions out.
Great. Especially the paralegal writing.
Screenshot that.
They are like glaring over there. I don't know who the one is behind the defense attorney, but she's side-eyeing pretty hard.
The paralegal, he's like, are those Doritos up there?
He says, I heard something about peanut M&Ms being opened. Can I have some of those? All right. I told Bryce, Mike.
And Ashley's like, these are my Doritos.
Yeah.
Get your eyes off my Doritos.
Don't touch my Doritos. So are Jodie and Brian's mics okay for all of you? Because I turned them up. I don't think it did anything for me.
Hello.
There you go. I
Hello.
can hear you. I wonder if I can turn you. Maybe it's probably the same.
I turned my mic up before on the settings.
Yeah.
Well, I'm not going to talk much anymore, so.
It's okay. Sometimes I just don't know if it's you or the defense attorney. So I have to, if I see your little sailor moving down there.
My eyebrows aren't moving.
Sometimes I don't think things through.
No.
We'll just soldier on.
I don't think you heard what I said, Jodie.
He heard.
You heard you're ignoring. All right.
My little sailor is.
Your little
just
sailor's
fine.
moving. Go ahead, say it, Chrissy. Go ahead, say. Go tell me my credibility's gone again. It's fine. I can take it. Good to see you, George.
Hello, Georgie. George of the jungle.
He likes the torture. Don't let him fool you. All right, Chrissy. All right, I'm playing. Sorry about your pauses, people. Kinda not.
They've already heard some, so.
So the court want to substitute.
Unga
You've
bunga.
already heard and may continue to hear. And by suggesting that, I'm not suggesting that I agree to the further admission of hearsay or her interpretation. That's not directly responsive to the question.
So reserving on other objections. And certainly, there may be objections you have as we go where you think that they are not being offered for the effect on the listener. And that it's hearsay without exception. So
Why are we going
those
through
still
jury
may come up.
instructions now?
All right, so when we bring the jury back in, you want me to give that instruction?
Please.
You have
Okay.
you have heard and may continue to hear statements made by Doug Benefield to Stephanie Murphy. These statements are relevant only to explain the reactions and responses that they elicit. That is the effect those statements had on Ms. Murphy.
If I may, Your Honor?
Yes.
I would suggest that it just name Stephanie Murphy, not Doug Benefield, because I think in her testimony it's been broader than that. So I think by identifying the instruction as it relates to this witness, the jurors will consider the testimony appropriate.
All right, so let me go through this again because I have declarant and recipient, reader or listener. So you have to tell me where you're talking about.
Sure.
You are about to hear statements made by Doug Benefield.
Yeah.
These statements are relevant only to explain the reactions and responses that they elicited. That is the effect those statements had on Ms. Murphy. You are not to consider the statements made by Doug Benefield as true, but only to establish the context of Stephanie Murphy's actions, reactions, and responses.
Okay, so here's my concern. For example,
Oh my God.
Ms. Murphy also testified about Judge Moreland, about a couple of the medical records and things like that. And I would prefer, and I think the fairest interpretation would be, ladies and gentlemen, Stephanie Murphy has previously said and may continue to refer to out-of-court statements. You are instructed that these statements, if and when made, you should not consider them for the truth of the matter asserted, but rather for context as it relates to Stephanie Murphy's testimony. That's how I think appropriately it should read, Your Honor.
Response?
Judge, I think these things that he's talking about were objected to and they were stopped. So I don't know that it's better to highlight it anyway, but I don't know if adding names in of people to fit this, statements of Doug Benefield, this person, this person, I don't know that would be effective to the jury. So I'm a little confused about how to handle it.
All right. Any final thoughts?
No.
All right. I'm open to giving limiting instructions, curative instructions that are suggested by the parties. However, the most recent one proposed by the defense, I don't think is legally accurate. It would be telling the jury to disregard testimony and evidence that's already been presented. I thought the request from the defense, because the objection came specific to Doug Benefield was supposed to move in with the defendant, and that's where we stopped. So it was my understanding that the instruction that was requested was specific to any statements made by Doug Benefield to Stephanie Murphy, that those are only relevant to explain the subsequent actions an effect that those statements had on Miss Murphy, and telling the jury not to consider the statements by Doug Benefield as true, but only to establish the context of Miss Murphy's subsequent actions, reactions, and responses. I don't think the limiting instruction proposed by the defense is the correct one to give. So I'm open to considering language that we can talk about some more, but no, the one you just said I don't think is appropriate.
All right, well, the message that we're trying to give the jurors is that when this witness makes hearsay statements, that the jurors should not necessarily receive that information as true, that it is being offered rather not for the truth, but to show the effect that it had on this witness. After all, that's what this witness is testifying to. She did not limit it just to what Doug told her, Judge. She's referred several times to what she heard from Ashley. She's referred to medical records and to allegations. She's also referred to Judge Moreland's decisions. She's expanded upon them. She's incorporated hearsay into her testimony. This was why I approached the bench before she took the stand. So I anticipated this. That's the way she's conducted herself in the deposition and in all of her prior statements. So what I want, respectfully, Your Honor, on behalf of Ms. Benefield, what I want the jurors to understand is that as it relates to Ms. Murphy's characterizations based on hearsay, that they should not receive it for the truth of the matter asserted. Rather, they should receive it to show the impact that it had on Miss Murphy.
I said that 10 times.
Response.
Judge, first of all, anything that Ms. Benefield said is not hearsay, so it does not qualify under any of this analysis. I do not believe she said anything about medical records. I may be wrong. She did start to mention that she checked herself into the hospital. There was an objection and she stopped speaking. So I would agree that that your idea is correct and that should be the instruction.
Final thoughts.
So, everything that a defendant says is not necessarily admissible. It's not necessarily relevant. It's not necessarily an admission. For example, Judge, if during the course of all of this, Ms. Benefield may have stated how much she loved this routine of a mouse named Topo Gigio, I think we could agree that that would have no relevance. And if this witness wanted to get up and talk about that merely because that is something that Ashley Benefield repeated, that wouldn't make it acceptable. So I vehemently disagree with Ms. O'Donnell's statement that anything the defendant says is admissible. And I'm concerned about the editorializing by Ms. Murphy being interpreted by the jury as truth, as unvarnished and documented conclusions. And so I would like the jurors to know basically the definition of hearsay. I would like the court to instruct them that it's not being offered for the truth of the matter asserted. It's an exception, and it can be considered to show how this witness reacted to it. That way, Judge White, it expands the parameters wide enough that the instruction would include hearsay from any source that Ms. Murphy refers to, whether it be Ms. Benefield, whether it be Doug Benefield, whether it be the hospital records or Judge Moore.
I agree with his argument. I just disagree with his
All right, thank you both very much.
presentation of it.
I had to unmute myself. Yes.
Yeah.
I agree with you. I agree with
Yeah.
him, but
He's repeated himself umpteen times. Just get on
yes,
with it.
yes. The judge is like, okay, I got it.
Yeah.
You've said it
Mhm.
1,000 times. Let's go.
It's a valid argument for sure.
Absolutely, because she is doing that.
Mm.
She is
Yeah.
editorializing or whatever.
Mhm.
Yeah, he's not finding a good way to state it.
And I don't think he should be giving in. He should just be saying, "This is hearsay. Don't let it in."
Mm.
And when it comes up, he objects, and the judge rules, or then the prosecutor's got to say, "I'm not offering it for the truth of the matter." And
The prosecutors are being
that's what
sneaky
they
though.
should be doing, so that you force the prosecutor to say in front of the jury, this is not for the truth. Every time in front of the jury, this is not for the truth.
Yeah.
And if you stop that sentence right there, this is not for the truth. I think juries would understand that better. But when you add that last part on, I think I'm not offering it for the truth of the matter. Like, well, what,
Mm-hmm.
you know what I mean? I can see
Yeah, but
what's that.
I think if you make her say it every time for every objection, then they get to understand that, yeah, we're not saying that he actually said that, but she did something because she thought he said that.
Right.
But
Oh, Tooth Capone.
he's giving him too much leeway. He should just say, this is hearsay.
Yeah.
It shouldn't come in, period.
Yeah.
Yeah.
Mm-hmm.
Yeah. Like, why are you giving her
Yeah.
so much room? Because you're giving her a wide lane. And I don't understand why. Hey, at least I didn't pause her too badly this time. She just looks like she hasn't
No.
slept. Because she probably hasn't.
Much. At this point, I don't plan on giving any sort of cautionary or limiting instruction. I haven't heard the parties agree on language. It doesn't sound like the language I've suggested is acceptable to both sides. So at that point, we'll just continue with the question, objection, ruling. Specifically as to the request regarding editorializing and characterizing, I'm going to sustain on those grounds. There's been, I think my information in front of me is that Ms. Murphy is a fact witness. All right. The request that I give the definition of hearsay to the jury is denied. As we all know, the determination of legal matters, including whether a statement is hearsay or not, or any sort of evidence is hearsay, that's a judicial matter, not a legal. It's a legal question, not a factual question for the jury. Those are my decisions. I'll note that it is already factored into a court's ruling. If a statement is offered, if an out-of-court statement is offered to prove the truth of the matter asserted in the statement, it is hearsay. The issue then becomes, is there a recognized exception to that statement or to that hearsay? And is it relevant and material to the case? That's how I'll continue to make my decisions, subject to the objections and the arguments that are made. Are we ready to bring the jury back in?
I did have one scheduling question, if it's okay with your honor. We have, after Ms. Murphy, we have 2 law enforcement officers here. And then our next witnesses are Dr. Broder and Dr. Quintal. Do you feel like I'm safe in telling them they could come after lunch? That was when they were originally scheduled, but they have patients and they're asking if they need to cancel to come early.
I have no idea how long these next I don't know how long Ms. Murphy's going to take. I don't know how long the next 2 witnesses are going to take.
Well,
I have no idea.
I guess the question is, Judge, if we end at 11:30 or 11:40, are you going to want to take a lunch, or do I need to have Dr. Broder here because he's with patients right now? So I need to be able to tell him. We originally thought he was after lunch.
You mean with Ms. Murphy?
We have Ms. Murphy and then 2 other witnesses we plan to do before lunch. I just want to know if I'm safe to tell the doctors they can come after lunch so they don't cancel patients.
My habit would be if we finished with witnesses around 11:45, unless that very next witness was, both sides agreed it's going to be just 5 minutes, I would probably take a lunch break at that point.
Thank you. I had asked it poorly. That's my question. I just want to be safe in releasing them so that, Your Honor, so we can keep moving. Or not releasing them, putting them after lunch. 1:30? Should I tell them 1:30?
It depends on when we finish
Okay.
this morning. I
I'll
don't
just
know.
tell them it's after lunch for now. Thank you, Judge.
Are you ready to bring the jury back in?
Yes.
Defense? All right, let's bring Ms. Murphy in first.
You're gonna get the RTs ganging up on you, and then when I tell Bree you're a nurse, she's really gonna gang up on you. Oh, and Bree, you can also tell Gabby. Gabby's a sinner too.
Happens to me a lot, Gabby.
Gabby likes to sin.
Ms. Murphy, have a seat as you're settling in. Did you discuss your
Hello.
testimony with anyone else outside of this room?
No.
Did anybody try to approach you and discuss anything about this case?
No.
Did you watch anything or any of the proceedings?
No.
All right, ma'am, while you were outside, I did sustain 2 objections that were raised by the defense. And that is, some of your testimony has been editorial rather than factual and has been characterizations of observations as opposed to observations.
Okay,
So just FYI, I did sustain those 2 objections.
okay,
Otherwise, we're just going to keep having questions and answers. I'll rule on objections as we go.
great, thank
All right.
you.
It'll be you and Brian, Bree. You both RTs here. You'll be taking care of everyone.
Bree, if I told you all the medications that I took, this ain't nothing. Trust me.
She'd be like, "Oh, that's fine."
Mhm.
We'll bring the jury in.
Yes, Bree, good luck. I have a feeling you need it.
All right, y'all can have a seat. Welcome back, everybody. Did anybody begin discussions amongst yourselves? Talk with anybody outside the jury about the case or do any research on the people, places, things, or legal topics we've heard anything about?
No, sir.
Everybody says no. All right, you may resume your question.
And I believe as we left off, Ashley and Doug were not speaking to each other. Pretty much not speaking to each other.
Right, beginning on August 16th, 2019, they were not speaking to each other.
Okay. And as a result of that, did you ultimately file anything on Doug's behalf?
I ultimately did, yes.
Okay. And what was that?
We filed gosh, let me think back, it was so many years ago now, a series of things, but one of the first things that we filed was an amended petition for divorce. And so it was actually a motion for leave to amend with the amended petition attached to it, which is the procedure.
So that ultimately means it was not seeking divorce before, but now the petition is.
Yes, that's correct. And still the parenting plan with some additional allegations, but that's what the main first pleading was.
Okay. And at some point after this was filed, did you get information that there had been complaints filed against Doug Benefield?
Yes, I did. So that amended petition was filed, I think, November 6th or 5th of 2019. And then within a month, I would learn that there was a series of complaints filed with.
I'll sustain.
Ultimately, these complaints that were filed against Mr. Benefield, were they documented or filed in any way in your casework, in your cases?
Object relevance.
I'll overrule.
So of course, we didn't attach them as exhibits to our next pleading, but we did file an amendment.
Object editorialized.
Sustained. That would ask for a yes or a no.
Okay.
Can you repeat the question for me?
those complaints, did they make their way, the information at least, into your filings in your cases?
Yes.
Okay. At some point, did Ashley file an injunction request based on these allegations?
Yes.
Okay. And around this time, was there a psychological evaluation ordered with Dr. Broder?
It was not ordered by the court. There was a psychological evaluation that was put into place through, I believe, the Child Protective
Objection
Team.
editorialized.
Yes. Shut up, woman.
So an evaluation was recommended.
I sustained it.
I requested an instruction from the court to disregard the last answer.
Members of the jury, I have sustained an objection. When we had our initial instructions, the preliminary instructions on Monday morning, I want to remind you one of those very important instructions. If an objection is made, you're not to guess or speculate as to why it was made. Likewise, you're not to guess or assume or speculate what the answer might have been had the objection not been sustained and the witness had been allowed to answer. So you're to disregard those last answers.
As part of this process with,
Sufficient?
I'm sorry.
Thank you. Yes, sir.
She should know better.
As part of the process of these cases in court, did Ashley and Doug Benefield, to your knowledge, see a Dr. Broder
Yes, they did.
for a psychological evaluation?
Yes.
Okay. Do you know when this petition for injunction filed by Ashley was set for a hearing?
I don't remember the date that it was initially set because she filed a motion to continue.
Objection
Basis?
editorializing, not responsive to the question.
Oh,
Go ahead.
It was continued several times after she filed a motion for mediation, and then eventually it was scheduled to occur. I
Objection.
believe it was September 30th of 2020.
Okay. So you said it was continued several times because of a mediation. So just what is a mediation and how does that play in?
Okay, so mediation is a settlement conference that takes place. It generally involves the parties as well as their attorneys, and then a neutral person who generally is certified family court mediator. And so what generally happens is a mediator goes back and forth between each side to try to work out an agreement. And in this case, it was ordered by Judge Moreland in response to Ms. Benefield's motion.
To do the mediation?
Correct.
Okay. And did you participate in the mediation?
I did, of course.
And also Doug and Ashley Benefield?
Yes.
And as a result of that, did some of the focus of the hearing coming up change?
In anticipation of the mediation, yes, the focus of the upcoming hearing on the 30th changed.
Okay. And in what way did that change?
Earlier in September, I think on the 17th, Doug and Ashley signed a joint motion to release the psychological evaluation reports in the divorce case, in the 2018 DR 2318 case. Because in that situation, the psychological evaluations had not been ordered by Judge Moreland. They were put into place through.
Objection, not responsive, editorializing.
I'll sustain on the narrative.
So they did a joint motion to release the psychological evaluation.
Yes.
And is that fairly typical? It's needed in this realm to get that result released to the parties?
Oh, of course.
Objection, relevance, it's what's taken place in this case.
Ooh.
A judge would not just release, is not able. Oh, I'm sorry, Judge. I apologize.
A judge doesn't release that report unless.
The judge orders that it can be released.
Okay. And Doug and Ashley did a joint motion for that to happen.
They did.
And to your knowledge, what was their path forward from that point?
The path that went into place was they were reconciling and moving to
Jack's
Maryland.
speculation as to what the path forward was.
And so when we were leading up to the week that he was killed, it was agreed upon that they were going to result in an impasse of the mediation because they were reconciling. And then the hearing on the 30th, the week after, was only going to be to release a psychological evaluation report.
Okay.
And they were going to pursue the move to Maryland.
Okay. So ultimately, the only thing that was supposed to happen at this hearing on September 30th was the release of the psychological event.
That was it.
That was it. Okay. And do you recall what day of the week that was, September 30th?
I believe it was Wednesday. So the mediation was a Thursday prior to the killing. And then the hearing was supposed to be Wednesday, the 30th.
Okay.
She shouldn't even be allowed to use that word.
And what day was Doug killed?
Sunday night.
And that would be the 27th?
Yes.
And who was the judge going to be at this hearing on the 30th?
It was still Diane Moreland. She was still the judge on the case.
And at all times that you dealt with Doug, did he ever seem to you overly angry or aggressive about things?
No, I thought Doug was never angry.
Just
He was
no.
very mellow and
Just
matter of
no.
fact. It was a point of contention between us, actually.
Okay. I have no further questions. Thank you.
Thank you.
Oh, thank God.
Yes.
Look out, lady. I'm coming to get you. My turn. Back up to Chuck,
Good
biatch.
morning, Miss Murphy.
Good morning, Mr. Taylor.
We've met on a few occasions, have we not?
Yes, we have.
And we meet again this morning.
It's lovely to see you.
And you've
So
been an ass
your
every
specialty
time.
is family court.
Family law, yes.
And you've been practicing family law, I think you've told us 23 years. You have your own firm, you and your husband.
Yes.
And in that capacity in family law, correct me if I'm wrong, but when you litigate matters in family court, excuse me, there are rules and procedure that apply to family court, are there not?
In all courts, and including family court, yes.
Okay, such as the rules of evidence,
Yes.
the rules of procedure, family court procedure,
Yes.
and ethical obligations as well.
That's correct.
Those always govern your behavior with respect to the tribunal, the court, correct?
All of our behavior, yes, that's correct.
Are you familiar with Florida Bar Rules of Professional
Objection,
Conduct?
relevance, Judge?
Condom relevance.
I don't know where this is going, so I'll overrule for a moment.
Thank you.
I'm, I'm familiar.
Yeah, Rule 4-3.3, candor toward the tribunal.
I'm familiar with that rule.
All right. You're familiar with that rule's obligation of a duty to disclose false evidence.
I don't have the rule in front of me, so if you want me to read and see if that's exactly in the rule, I can certainly take a look at it. I'm generally familiar with the obligation to provide candor to the court.
Yes, and to disclose if evidence is inaccurate. I think
Yes,
we can
exactly.
agree on that,
Of
correct?
course.
That would include, would it not, a failure to correct a materially false statement of fact?
Yes, I'm aware that that exists, but I don't see how that could apply to my case with Doug.
All right, well, let's see. I want to ask you about a sequence of events now relating to the litigation that you mentioned to us between Doug Benefield and Ashley Benefield.
Was this the injunction you're referring to or the divorce case?
I'll be very specific in my questions, if you'll be patient for a moment.
Of course.
Ashley Benefield files her domestic violence petition on April 23rd of 2018. Is that correct?
I believe that date is correct, yes.
Just so there's no mistake. She then, correct me if I'm wrong, because you seem to have the dates mastered. Ms. Benefield then files a petition for divorce and temporary TPR on May 31st of 2018.
I don't remember the date that she filed those, but she filed, those would be, I think, separate things. And so in response to the petition for parenting plan unconnected with divorce that I filed on Doug's behalf, she filed an answer and a counter petition seeking divorce.
So your answer for purposes of my question was you don't recall the date.
Yes, that's correct. And it wasn't that
May
she
I
was.
approach the witness?
Yes.
See if this refreshes your recollection as to the date.
I need to get my reading glasses, Mr. J.
Oh, me too, ma'am.
He's got his snack on.
Yep. And it shows.
Are these going to be her
While you're looking
1,200?
at it, when I refer to the initials T,
What did you say, Bri? Oh, shit.
Are these going to be her $1,200 glasses?
Uh-huh.
I'm like,
She's an attorney. She can afford laser.
I can't believe I did that. Where were we? Okay. Oh my gosh, you guys, I'm so sorry. We'll get her back to her glasses.
Happens to the best of us.
Yes, it does.
I think I did it 3 times yesterday.
For parenting plan unconnected with divorce that.
That's close
Chrissy.
enough.
Is that, am I too far or am I,
No, that's close enough.
No.
She'll be coming up.
okay,
He's going to put the document in front of her here.
okay. Sorry.
I filed on Doug's behalf. She filed an answer and a counter petition seeking divorce.
so your answer for purposes of my question was you don't recall the date.
Yes, that's correct.
Okay.
And it wasn't that she
May I
was.
approach the witness?
Yes.
See if
I
this refreshes your recollection as to the date.
I need to get my reading glasses, Mr. J.
I won't touch
No,
it.
see that? See that smarmy smile?
It's like when she said, it's lovely to see you. That wasn't genuine at all. It did not come off that way. It came off just snotty.
While you're looking at it, when I refer to the initials TPR, what does that stand for?
Termination of parental rights.
Okay.
Yes, thank you for the reminder. You're right. This is the 31st of May. And she did file a separate case. I had forgotten that.
Well, the question pending was, does that refresh your recollection as to the date?
As to the date, yes, the
Yes.
contents, no.
Was I correct in my statement to you that the date was May 31st, 2018?
Yes.
Now, would you take a look, if you need to refresh your recollection, as to count 2, specifically paragraph 5? Ms. Benefield makes some allegations there, does she not?
She does.
All right. On June 19th of 18, you file Mr. Benefield's answer.
I don't remember that.
May I
Remember
approach?
everything else, lady.
No
Let's see
kidding.
if this refreshes your recollection.
Don't you remember what she wants to?
Is the date June 19th, 2018?
Yes, that's correct.
All right. And that's your answer, is it not?
This is Doug's answer that I drafted and
Oh,
filed on his behalf.
That you
Yes,
drafted and filed on his
Yes.
behalf.
correct.
And in response to paragraph 5 of Ms. Benefield's petition, you deny it, do you not?
Objection relevance, Judge?
I think,
I'll overrule on those
yeah,
grounds.
thank you, Judge. Ms. Murphy, my question was, if you would look at paragraph 5, do you enter a denial?
I'm sorry, it's number 5 is 7 pages long. So I was just checking to see if that was correct.
Well,
Yes,
your answer.
we denied these allegations that
Okay.
he committed those acts during pregnancy.
Now, as part of that action, your client, Doug Benefield, submits to a deposition 27 days later on July 17th, 2018, does he not?
I don't remember that exact date, but he did submit to a deposition around that time frame.
Okay, and in that deposition, while,
Pretrial motion.
Sustained.
Your Honor, she opened the door. She's already talked about,
Maybe
Would you like to approach?
yes.
Whoa, you opened the door, lady.
She had to open the door to something with all the rambling she did.
Yeah, absolutely. She opened her mouth. She opened
No
something.
back door. No back door. But we can do this. Booped y'all with an ad.
Hey. Oh, hang on. Oh,
And I boop you, and I boop you, and I boop again.
Gucci, Gucci, goo. Gucci, Gucci.
Yay, Brian. Haha, Gabby. It's got to be better than what it was. It has to be better than what it was. Oh, well, good.
Oh,
Oh, whoop. Scrubs, scrubs. She didn't think he was paying attention when he was objecting. Oh yeah, he was taking notes.
mm-hmm.
I'm with
She
you,
knew
Chrissy.
every date.
Yep.
Sorry.
I didn't like this guy at first, but I do now. Like I think he's doing his job. But I didn't care for him at all yesterday, like when we started,
No.
because he just was constant about stuff.
Yeah, I agree with his arguments. It's just his delivery that gives me the
Yeah. That sucks.
irrits.
He does have a nice voice, Brian. You are correct,
Mm.
sir.
He just needs to speed it up a little bit.
Yes. You two could read books together, but you have to speed him up. Bedtime stories. All right. Nope, looks like I can't believe I went all the way back to beginning. Embarrassing.
I did that 3 times yesterday.
Oh, did you?
Yeah.
I didn't. You did it. Oh, I got a soggy bottom bun.
Did we get a boop?
There
Ooh!
she is. Oh, penthouse.
Oh, Governor.
Hello, Governor.
Hello, Gabby.
Hello. Chip, chip, Cheerios. I
Well-
changed my name to the Soggy Bottom Bun.
Chrissy,
Did you?
She did. Yes, she is soggy bottom bun. If she was going to tiptoe through
Hiya
the door,
there.
she should not have wore a bright pink dress.
Uh-uh.
Kind of noticeable. Hello there. How are you today?
Hello, Mr. Adair.
How go with? Oh, I was gonna say how go with the pickleball, but it doesn't go with it all.
Adair, is that enough hearts for you?
You get all the hearts. All the hearts. He tiptoed and she swung it open. Oh, he tiptoed.
Mhm.
I read it wrong. I'm sorry, Chrissy. Yeah, she kicked that door open. I think she had to have in some way. There's no way that all of that could have been said. Adair hurt his knee, so he can't pickleball right now. Which is too bad, Adair, because there's a company I read about in my Indianapolis paper that is selling all their stuff for pickleball because they're going out of business. They had filed bankruptcy for some reason. I can't remember the name of it now. But you should look it up. You might be able to get some equipment.
Chrissy.
Ashley looks like she's decoding messages there.
She does. It's like beep, 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 beep.
Calculating.
Chrissy, did you want an ad? Is that what that meant?
Don't you dare.
Oh, and there you go.
I won't get it. Nanny boo boo.
Oh, you didn't? How about this one?
But wait, there's more.
Oh, there's more. I don't know how many times I can hit the button. You about to jump on a plane? I won't worry about you getting here because the flight won't make it because it'll be delayed. One more just for good measure.
Oh, no.
Oh, look, that woman back there looks like she's
Hit the
waving.
eject button. Hit the eject button.
Ashley's saying keep it down. She can hardly hear.
Look at her. She's staring at you, AJ. She's getting all those ads.
Hey, you come out and see me, Chrissy. We'll have a good time. I'll take you and watch you do some shots.
There's a lot more spectators there today. I think they probably saw the stream yesterday and decided to go in person.
Maybe. Maybe.
Those people look like they're having fun watching that. I'm going to go.
Why does his side look so crabby? They all frown. All of them. Like, good grief, this is long. That's what she said. Also, nobody has made the joke about 12 to 15 inches and what it looks like if a...
I've been thinking about it every time he says it.
Me
Yeah,
too.
but does it have the girth of a soda can? Is the question.
Yeah, absolutely. Right on there, Gabby. I'm with you.
I was wondering why he didn't use size at all yesterday during his explanation of how to use the microphone. But today he needs to put in the size.
He's all about it.
No,
today.
you did it yesterday.
Also, I love how AJ just had a whole conversation by herself.
What are you talking about?
You were like, and that's what she said. And then you just carried on.
Oh, yeah, no, I was just... Because I was just beating anybody else to it, so... I was
already almost typing it, so you won.
Yeah, that's why I just said it. So I just was saving you from having to type it. I know, that's what she said. Good.
Exactly, Chrissy.
That's why I got to beat somebody. Also, Chrissy, what I was going to tell you is I don't know what you guys have going around out there in California, but keep it out there. But the two people that have exposed me to the vid here in the last 2 weeks both returned from being out of the country. So they just need to stay in the US, but apparently not in California. Because I haven't heard about it being around here. Other than me being them bringing it to me.
Yeah, we're seeing an uptick.
Yeah,
I want to see dedicated streaming.
Well, the last night I worked,
Power bank to the vape. That's dedication right there.
Yes, it is. Well, Brian, I won't go to Connecticut then.
well, last night I worked, I was like, if I have to put on one more gown and face shield, I'm just going to quit.
Oh, you gotta do
Oh.
that. Ugh.
Dress up, undress, dress up, undress.
Yeah.
Mhm.
No, thanks. No, I
Are
had
you on
one
days off,
friend.
Bri?
I hope so, because
Yeah,
I'm getting tired.
I go back tomorrow.
All right, members of the jury, here's what we're gonna do. I'm gonna go ahead and let you go to an early lunch. It's about 11:20
Oh, Lord.
right now. So the good news is you get to beat the crowds wherever you decide to go. If you could be back downstairs in that jury assembly room where you start each morning at 12:30. And we'll look forward to getting you back up here as soon as we can after that. Please remember, if you do go out somewhere and have lunch,
Don't be
if you go
going
in a
there,
group,
Bree.
that's
Get
just
in
fine. You
trouble.
can absolutely go in your groups, but do not discuss the case at all amongst yourselves or anything about the case. Don't talk about the case with anybody outside of the jury. And please don't do any legal research or research on the people, places, things, or legal topics we've heard anything about. Again, if you're sitting somewhere, just kind of hear in the din of the people behind you something about the case.
All right, get the jury out of there. Adair, I think no, we don't feel like she's really guilty. But in our defense, if you've ever experienced anything that she has experienced, and a lot of us have, you're looking at it through a different filter,
Yeah.
and it just, to for lack of a better phrasing here, it just hits differently, and so no, I am not convinced she is guilty at all. Not at this not at this point, and nothing the state has done today has helped me get there whatsoever.
No. And Gabby, is it the defense rest or is it something else?
Is it what? Sorry.
Is it the defense rests or is it the meat in the sandwich?
Crap, I spelt it wrong too.
She's back here. She can also be here be back about 12:30.
Yeah, Gary, I was going
See you
to
guys back here
out.
at 12:30.
Aussies don't know how to spell, so
Hey, Brian. What'd you
Aussies
say,
don't
Brian?
spell things correctly. So
Oh, when I put up my message earlier, I was like, well, sorry, Brian. I know this is probably worded really bad and badly and lots of grammar problems. The meat in the sandwich. Ha ha.
Took you a while.
Oh, I see it now. I was going back and reading what I wrote, and I was like, wait, did I write something wrong? And then I was like, I looked up and I saw her name. I was like, oh, okay, good.
Oopsies. Let me get live.
how many ads can you get in here?
I don't know. Is this a challenge?
No.
Oh.
No, thank you.
You might have
No,
to
thank you.
get a brace for your clicking finger there.
I can get one. There's one.
Here's another one. Here's one. Here's another one.
I am curious how many times I can hit it, but I won't do that to you guys. I really just want to be like, just.
Can we go back to yesterday and replay the 911 call from yesterday's law and
Sure.
crime?
Do you know about what time that, like, how long into it you were? Because other than like,
it was he what, the third witness or fourth witness? It was. I'll know the guy when I see his face.
okay. Where are you at?
I can't share a screen, can I?
No.
Oh dear, the pea and ham soup's working. Oops. Oh Lord.
There, They did
But
show a photo that she had swelling on the side of her face.
He had firearms as well.
but Adair, I guess I would have to just ask you, what does that have to do with anything? I have several in my house. I'm not unaliving. Only thing that's being unalived around my house is skunks because I don't like them. But I'm not unaliving people.
Pea and ham soup. No, I had pea and ham soup for dinner, and yeah.
Oh my god, I thought that said you peed in ham soup.
Also,
I was like, oh lord.
No.
Yeah, no.
Ham soup and pea in the suit.
A ham pea suit.
oh, you guys are
Yeah.
making it hard to find this video.
Quite a smorgasbord you got there.
Yeah. Oh Lord, Jodie.
I can only find like where you have to buy it. Seriously, people. But even if I didn't like most of the stuff that they showed yesterday, Chrissy, there wasn't a lot of injuries on her, and I just don't think that matters. I don't think you have to have injuries to feel threatened.
Well, domestic violence doesn't always come in physical form.
Right. I have to go to Court TV. I can't find it on Law and Crime. They only have today's, and everything else is behind the paywall.
Oh, what about our stream?
Oh, duh. Did we do something yesterday?
But
His name was something Sand. He was an older guy with a mustache, white mustache.
Yes. Adair, so I'm just asking you, does she have to have abuse? Does she have to have injuries to claim self-defense? Because I don't think you do. If I'm coming at you with something that you know is going to hurt you and you can neutralize me, oh my, then you can neutralize me because I'm going to hurt you.
oh my
even
goodness,
if I haven't
Bri.
marked you.
What a costume change.
Well, these streams are so long, I don't have time to get up to go to the bathroom. So,
Oh my god. Wow.
I love
Everybody,
it. I love it.
Look at that. That's the best thing since sliced bread right there.
Good job. We should have fancy dress themes for different streams.
it gets awful hot in there.
That's gold.
Well, I mean, yeah, once you pee in it, it warms you up real
Are you
fast.
still sitting in your dirty pee pants?
Well, I don't want to give out too much information, but it holds more than pee.
It was the skunk. That's gold, bro. I love it.
So, you can put this on one of your ads. This is the brand right here. Where is it? There we go. So everybody can go out and get one.
Hold
Where do
that
you
up
get that
again.
at a regular CVS or something? Or you pick one of those up?
Actually, I got it
What
at
is
Home
it?
Depot. I've been doing some work in my attic, and I got a lot of insulation up there. So.
Sure, that's your excuse, Brian.
That's it.
Yeah.
That's it.
Mm-hmm. Oh, I heard that zip.
Okay, Adair.
Yeah.
I'm not trying to argue with you, really. I'm not. Adair, please don't take it as I'm trying to argue with you. I'm really trying to see where you're at. And so,
Yeah, absolutely.
what you have observed so far, what makes you lean towards guilt versus innocence? And again, I'm not trying to argue with you. I really am curious.
No.
because
Absolutely.
we all see things differently.
Mm-hmm. I like to hear other people's opinions
Yes, me
and
too.
reasons for.
Yes,
That's
Christy, it
right.
is not
It's a
arguing, it's
discussion.
having a discussion.
Correct.
What do I got? There we go. Yes, I just didn't. I agree with you, Chrissy. I just didn't want him to think I was arguing with him because I'm not. I wasn't in any way. I just curious at what he saw that because like I said, some of us. I know most of a lot of the. Unfortunately, I hate to say that a lot of the women that have been in my chat, we all get that. We all have that different filter, different levels of it. Even some of it's
Yep.
just been
But
horrible.
we've all got different life experience as well, and we all bring our own experiences to the table. So we're
Yes,
entitled to our own thoughts,
and
opinions, and that's fair.
I
and
could tell
that's
you a
what
story for days.
I. Her lawyer, in your opinion, overstressed her abuse at the first. I think.
That's probably backing up the self-defense claim. I suppose that's his
Yeah,
job.
I think they maybe not so much now because it's kind of it's gotten away from it a little bit. They haven't really been talking about it anymore, other than just trying to prove where she's at, or I'm getting raided by my dogs. Where she's at or not, who she sent to the park or didn't. Like they've been talking about kind of that stuff that doesn't matter right today, and so I don't know. I can understand
I
what you're
actually think
saying.
the only thing they've brought in as evidence-wise is the intervention order, isn't it? Otherwise, that's the only real, apart from the complaints she made to
Right.
during the custody, that's really the only evidence as such, like physical evidence to back up her story, I suppose, if you look at it that way. On a factual, do you know what I mean? Like,
Yeah. Absolutely, Chrissy. 100%.
yeah. And sometimes the ones that don't leave the marks are the worst.
Yep.
But she actually has I don't know if you heard it yesterday, AJ. They were saying that she has fibromyalgia as well from it.
The Ashley does?
Yeah. Yep.
Wow. I didn't know that
Yep.
did that.
Yeah, prolonged
Oh,
periods of stress and
yes.
stuff can cause it, yeah. Yep.
Yeah, I don't know. I agree with you guys that. All right. What are you guys doing? I knew somebody left. Oh, he's sitting in a different background.
Oh.
I thought I was on there twice, but the other one was from yesterday.
Yeah.
I'm trying to figure out how to move you guys around, and
Bri does wardrobe change and
Oh, I
bathroom
did it.
change. Wow.
Oh, how'd you do that?
I did it. I did it.
How did you do that? Did you just grab them?
When if I go over your picture, it changes into a hand, and then grab it, and it'll change into a box, and just drop it on. Like I had to drop Gabby on top of Brian.
Well then.
And then it switched.
That's what AJ said, not me.
Exactly. All right. Let me see if I'm in the right spot. I think this is right after he was on right after lunch, I think. Oh, it's muted. Good for me. Sorry, I got to boost it.
All right, you all can have a seat. Welcome back, everybody. You know the questions I'm going to ask. Did anybody discuss the case amongst yourselves or begin deliberations? Talk about the case with anybody outside the jury, or do?
But Adair, there's another way to look at that. He was also not letting her go. So he could have said he was moving to be with his kid. And he could have even convinced himself he was moving to be with his kid and convinced other people.
And
But at the
told
end of
everyone
the
else.
day, it could have been, it was just a control issue over her. And like you said, Jodie, she's his and nobody else's, and that's the way it's going to be. So
Or he
I don't
convinced
know.
himself.
So I don't agree. I don't necessarily disagree with what you said. I don't know. And you're right. We just don't know yet.
No.
Yeah, absolutely. And that's what we're saying, Chrissy. I don't know that it wasn't just control and manipulation, that he was wanting to move closer to her.
I mean, he's not around to tell us, is he? So
Nope. And we don't know what happened. Like I said this morning, they didn't charge her with first degree, which would have been premeditation. It's just second degree. So the state does not think there's first degree
There's enough.
charges there. So that says a lot to me, that they don't know either.
Well, this 911 call was pretty much what convinced me. Hello, mister. Hello.
All right. I think he's after.
Do any research on the people, places, things, or
If
legal
you
topics
scroll, I'll have a
we've
look
heard
at the
anything
face
about?
and I'll tell you.
Everybody says no. Where we left off, the state was.
Hello, Elizabeth. Welcome. Hello. Oh. I'm like, where's Elizabeth? I didn't see her. That's him.
I believe he's
That's him.
the
Yes.
one who called
Yes.
911.
Yes.
That's
Okay.
hilarious.
The
The
neighbor.
neighbor. She ran over to his house.
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth?
I don't know if I'm answering Bri yesterday or Bri today. No, teenagers over here actually pay to have hairstyles like that.
Yeah, he's giving off more of a Key West vibe.
My name is
Yeah.
Ted White. I'm going to be presiding over this
That
case.
chick's funny.
I've been
Roger Ragu. Hang on. Wet Willie.
I can't tell which Jodie's talking.
I know. I'm trying to wet Willie her.
I am literally alive right now by laughter. This is so hilarious.
So confusing. I don't know
Also,
who's
Roger
talking.
Ruggett was my favorite witness.
Oh, mine too.
He
Mine
was the
too.
best.
Yes.
This chick.
Yep.
This chick's really funny. This one.
Yeah, I think so.
Oh, this is great because I'm so confused. I don't know who's talking.
I know.
Okay. Oh, we got the Sailor Man back. Yeah.
Now tomorrow
Folks,
you can
you may
replay
need-
today's stream with all this in it.
Oh yeah. I'll do a screen grab of this now and we'll play it tomorrow. I will. I'll do a snipping tool now.
Chrissy, that comes back September 6th, I believe, is probably jury selection for him. Then September 9th is probably going to start the trial because September 6th is on a Friday. I do not know why you thought of Bluey because I haven't had to watch that. I've seen snippets of it.
Maybe because Brian's shirt is blue?
Bluey.
It's okay. He'll go off camera and change into another shirt later on.
I was going to ask you.
This is purple. Why is
it looks
showing
blue.
Looks blue.
It shows up blue. Yeah, I was going to ask you the other day if I didn't know we were doing wardrobe changes because you had a shirt and tie on, and then you took the tie off, and then you came in with a different shirt. I'm like, I didn't know we had to change clothes. This is going to start a controversy. Is it blue or purple?
New costume for every act. So.
Put up a poll, AJ, blue or purple?
I see that it looks blue, but it
does look blue.
Here in Connecticut, it's purple. So.
Don't even start me about Connecticut, Bri.
I was gonna say maybe it's the smog or something. I don't know. I've never been to
That's
Connecticut.
probably my
The
camera.
smog is just clouding your judgment. It's really blue. It's not purple.
All right, I'm pushing play, so I'm not gonna know who's talking. All right, Gabby, I had to see if you were on yesterday's list right there. So if I hear you, I know it's you. Uh-oh. Brian keeps disappearing.
Some assisted listening devices.
Very well.
All
Thank
right.
you for asking, Elizabeth.
Certainly, here's a pair that you can use.
How are you?
Put that on. Let's keep this facing forward. You should be good. As you see, you might have to turn it around the other way. Yes, sir. I think that'll work better. And the deputy will show you how to adjust it. Oh, did I scare you? Too loud? Sorry about that. That's about control. Okay. Make sure to keep it forward. All right. All right, sir. Does that help?
Yes, sir.
Excellent.
All right. I apologize about that. I didn't mean to.
No, that's all right.
Sir, my name is Judge White. I'm presiding
Need
over
the
this
miracle
case.
here.
Just make yourself comfortable in that seat. Get about 12 to 15 inches from that microphone. It does adjust up, down, left, or right as you need it. Just speak in a loud, clear voice right into that microphone and we'll be able to hear everything.
All right.
Thank you, sir.
Good afternoon.
Hi,
Please state your name.
John William Sant Jr.,
How do you spell Sant?
S-A-N-T.
Where do you live?
And
This testimony could actually be very, very telling as to how her reaction after the event and a non-biased party.
11327 White Rock Terrace in Bradenton.
That was
And
excellent
did you
insight
live
there.
next door to Ashley Benefield and her mother, Alicia Byers?
I did.
Do you still live at that same address?
I do.
Do they still live at the same address?
No,
Okay. Did Ashley have a child when you lived next to each other?
she did.
About how old was the child last time you were together?
At the house, in the neighborhood,
When they were living in the neighborhood?
I'd say 18 months to 2 years.
Okay. And do you remember a day when Ashley came to your house?
Yes,
Okay. Do you remember what day of the week that was?
it was on a Sunday.
And what time of day was it? Light out, dark out?
It was still light, but it was probably early evening. It was between football games.
Okay, so it was between the football games on a Sunday?
Right.
All right. Still light out? What do you remember about Ashley coming over?
From the very beginning.
Right.
Well, I heard a very loud pounding on my door and kind of startled me, but it was loud. And I went and I looked out through the little window, and there wasn't anyone there. So I thought, well, went to the back and looked out the back. I even looked out the side and didn't see anybody. And I was thinking, well, one of my grandkids has a friend in that area there, and I thought they might be messing around, but I didn't see anything. So I guess it was a few minutes. Nobody, must be just someone screwing around. And it happened again.
The pounding.
The pounding happened again, yeah.
I'm having a little trouble here.
All right,
Yeah, if we can get you to scoot up a little bit, there you go.
sorry. What part do you want me to start at again?
Okay, so the pounding started again.
The pounding started for the second time, yes.
Okay, and what did you do
That's
then?
what she
At
said.
that point, now I'm starting to get a little concerned. Someone's trying to either break in or a home invasion and that. So I went back into my room, went into my closet, and I pulled my weapon out.
And you said weapon.
'Cause
what
they'd
kind of
knock.
weapon was that?
It was a Glock 23 40 cal.
So you had your own firearm.
Yes, ma'am.
You pulled that out, and what did you do?
I then came from the closet back towards the door and decided at that point, let's look out the door one more time before I load one in and take it to the door. So I just set it down on the little table beside my chair.
So you set the gun down.
Yeah.
Okay.
And I left, and then I went back to the door.
What
And
did
look-
you?
And I looked at it again. And then that's when I saw I saw a leg sticking out. Someone was sitting on the stoop.
Okay, so you saw a leg. You think someone was sitting.
Well, they were sitting.
Okay, so what'd you do?
Well, Then I kind of noticed who the leg belonged to, or I thought I did. And I went and I opened the door.
And did you know who it was when you saw the person?
I assumed who it was when I looked out the window.
When you opened the door, could you see who it was?
Well, by the time I
Yeah.
got the door open, she was standing up.
So you saw who it was?
Yes,
And who was it?
it was Ashley.
Okay. And you kind of pointed over that direction. You see her in the room today?
She's over next to Mr. Taylor, yeah.
Stipulate that it's Miss Benefield, Your Honor.
Stipulation to ID.
Yes.
And what did Ashley say when you opened the door?
As soon as I opened the door, before I could say anything, she said, he attacked me.
And is that all she said?
At that point, I said, who? He said, Doug. He attacked me and I shot him.
Okay. Is that all she said to you?
That's all she said.
Did she have a weapon with her?
I didn't say it at that point.
Did you see a weapon eventually?
Eventually,
Where was that weapon?
it was laying down just to the right of my door where I couldn't see it, where I was standing at that point.
And when did you see that weapon?
Well, after she said, and I shot him, I said, well, then you better come in. And I moved to the left to let her in, and that's when I noticed it lying there on the ground.
Okay. And what was it?
It was a handgun.
What did you do with that handgun?
Once I got her in the house, I told her, I said, I can't leave that out there. No, I don't know whether she responded or not, but then I went out, reached down, picked it up by the trigger guard, brought it back in the house, and set it down inside the door.
Okay. And when you say inside the door, was that on the floor or was there a table?
It's on the floor.
On the floor. So once you brought her into the house, where did you go?
Once I brought the weapon in, I shut the door and locked it. And I looked at her and I said, what condition is Doug in? And she said, I don't know. Or she
I
said,
don't know.
Don't know. She just don't know.
I don't know.
I said, where's your mother in Emerson? And she said, at the park.
So you knew her mother and you knew Emerson, her daughter.
Yes,
Okay. And she said at the park.
at the park.
And at some point during this conversation, when she was at your house, did she tell you that that gun was hers?
After listening to the tapes, I was able to hear her say it, but it was really faint, yeah.
Okay. Did you call 911?
I did
Have you listened to the 911 call?
many times.
Okay. I'm going to show you State's Exhibit number 1. You can take a look at this. What is this?
I don't know, it's a disc, I guess.
It's a
Oh,
disc.
okay, yeah.
The 911 call.
Oh, okay.
And when you listened to this 911 call, was it an accurate representation of your conversation with the person on the other line? Do you
Yeah.
remember?
Oh, yeah.
Okay.
Oh, yeah. Yeah. It wasn't me.
Pardon?
Yes, I recognize my own
Okay.
voice.
The state would enter into evidence State's Exhibit 1.
Objection. We received?
What was Ashley's mood when she was there?
I'm sorry, Ashley's what?
Ashley's mood?
Terrified.
Okay. Was she, do you remember her crying?
I didn't remember her crying until I was listening to those tapes, and then it sounded like she was crying, but she just couldn't get any words out after that last statement about where her mother and daughter were. That was really the last coherent amount of any words that ever came out of her mouth that I could understand. At that point, it was just stuttering and shaking. And
So if she had done this on purpose, she would have double checked to make sure that the job was done. She wouldn't have just gone next door and went, I don't know. There probably would have been an attempt to conceal the weapon, maybe at some, not just leave it beside her. And it sounds like she was absolutely in shock. So, makes sense to me.
sobbing.
Good advice, lady.
So you did not have any other conversations with her, meaningful conversations with her after that?
No, the rest of the conversation was a 911 operator.
Okay. At this point, I'm going to publish State's Exhibit number 1.
Members of the jury, when physical evidence, documents, photographs, video or audio recordings, and so forth are admitted or received by the court, they may be published to the jury. This means shown to the jury. Depending on the type of evidence, it might be shown to you on the overhead screen, through the sound system, handed out for you to look at, or shown to you. Evidence that is admitted or received by the court will be available to you during your deliberations, and you will have as much time as you need to review and consider the evidence. Members of the jury, you are about to listen to an audio recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way you listen to, view, and consider the evidence.
Thank you, Judge.
Finally, you are about to hear a recorded conversation. This recorded conversation is proper evidence, and you may consider it just as any other evidence. You are also going to be furnished a transcript of the recorded conversation. The recording is the evidence, and the transcript is being provided to you only as a guide to help you follow along as you listen to the recording. The transcripts are not evidence of what was actually said or who said it. If you notice any difference between what you hear on the recording and what you read in the transcript, you must rely on what you hear and not what you have read. Also, any notes that you want to make during the playing of the audio should be on your notepads. Once we have played this audio for you, the transcript, as I said, is not evidence. You will not be allowed to keep the transcript, and the transcript will not go back with you during your deliberations. But the audio recording will be available. So you just take one and pass it down. Help yourself, sir. Yeah, if you want some water. Yes, ma'am.
Thank you.
Manatee County 911, what is the address of your emergency?
Hi, my address is 11327 White Rock Terrace.
Okay, can you repeat that for me to make sure I have it correctly?
The house next door, honey, what's your address? Okay, it's right next door to me. She just came over. Her strange husband attacked her, and she says she shot him. Now, we've not gone over there yet.
Okay, what's his name?
Who?
What is his name?
His name is Doug Benefield.
Okay.
I have not gone over there. I'm not
Okay,
go back.
I don't want you to go over there. Stay on the line just one moment. I'm going to connect you over to Sheriff's Dispatch, okay?
Okay.
One moment.
Calm down, honey. Calm down.
What is your name, sir?
My name's John Sant. KNT. I live next to
Service Dispatch on a recorded line. This is Gabby. How can I help you? Hey, Gabby, it's Karen. On the 11327, I have John Singer on the phone. He's saying the neighbor came over, female neighbor. It was a domestic. She shot her husband. Okay. All right, I'm going to get that on the screen, okay? Okay. Which screen is her at? The 11327 White Rock Terrace. Okay.
That's my address.
That's your address? What's her address? Where does it occur at?
Her address is right next to, I believe it's 11331.
She's on the corner? Okay.
Yes, ma'am, on the
Okay.
corner. She's with me now, quite upset. The weapon is here. Do you
Yeah.
want me to go over and look at anything, or just wait for the?
No, I want you to just wait for the police, okay?
All right, if you could just get them here quick. She came in, she was quite hysterical. I didn't know who was banging on my door. Said that he attacked her, and she shot him.
Okay. I'm just getting that all on the screen, okay?
Okay. I know, honey. Come on, calm down. I know. Go ahead, ma'am.
Where is the gun? Is it with her or is it just?
I have it right here, ma'am. It's sitting on the floor inside the door. My door's locked, so in case he isn't, he can't get up. I'm also armed if he does come over and try to harm her, just so everybody knows.
Okay.
I'm kind of concerned with her mother and the little girl might get back there and find this whatever happened. Don't go out there, honey. Come on. I know. Come on, honey. Sit down. I know.
You can't fake that.
All right, I just want you guys to stay on the phone with me, okay?
No, I'm right here with you. I'm just with her. I'm trying to comfort her. We're in the house. The police are going to want no problem. I know, baby. You got to sit down. Come on. There's no... Well, honey, they want you to stay here. If he isn't, we can't take a chance. That's why I want them to hurry up before we get back from the park.
Deputies are moving as fast as their hand. They're coming priority. They're coming lights and sirens. They just want to get and make sure that everything's okay. So where in the house is he?
Where in the house is he? Her bedroom. No, I don't know what that is. So it's one of the bedrooms. It's a lot like mine, so I'm going to assume when you go into is the garage door open? When you go into the garage, it's going to be on the left? On the left.
Okay. All right, I'm just getting that typed up, okay?
What, ma'am?
I'm just getting everything on the screen, okay?
Okay.
I should have Deputy pulling up here soon. Do you see him?
No, I'm in the back now looking out. I know which way the park is in Central Park here.
Okay.
Wait a minute. Okay, the sheriff's here. Thank heavens.
Yeah.
Okay.
Yeah. Do you
the sheriff's car just pulled.
Yeah.
What do you want us to do?
I'm going to stay on the line with you until a deputy gets with you, okay?
Okay. Okay, the sheriff is here. I'm not too sure where they're going.
I'm just staying on the line with you. The deputies.
I'm right here. I haven't left yet.
Yeah.
I just see it's a SUV sitting out there in front of my neighbor's house, right in front of my house.
You don't have to listen to any more. That's pretty much the end of it. But yeah,
Just become, they're going to take you into custody.
Just to listen to her, like her reaction immediately after the incident. That's what got me.
Yeah, it's and I've said this 100 times watching these trials. Nobody ever reacts the same to a traumatic situation, and that's a really traumatic situation. And so, they want to put us in this box of you didn't cry enough, you didn't say the right thing, you cried too much, you said too much, you didn't say enough. It's never, they just make it fit what they want it to be. But
unless you're in that
relationship,
you don't know what goes on behind closed doors. You don't know. Yeah.
And I did say that I saw some early on comments. I don't remember if on Court TV, Long Crime, whoever it was, doesn't matter, that they didn't see any tears yesterday when she looked like she was quote unquote crying. But I'm like, I don't know. We're not up that close to her face. I've seen people fake cry in court. That's not uncommon. I'm not saying she did or she didn't. I have no idea. But That's so
But that
hard to.
neighbor is lovely. He did a
He's a
he was
great
amazing
guy.
with her. Yeah.
Great guy. And he did a great job. They're not back yet. So, um,
Oh, you're not above me anymore.
yes, I saw your. Thank you. I disagree with that sometimes. But Adair, I also think that you look at this through the lens because I think you're a good guy. I don't think you would
You
do
don't
any.
expect people to behave in another manner.
Yeah, because I understand that. That's your life. You're a good guy. You know that you would not do that to somebody. You know you wouldn't hurt a woman that way or a child or anybody. So it's hard to understand people that do. And I get it. I understand it. Because I've caught myself doing it. And a fun fact, thanks, Bri, on this day in history, July 24th, 1998, World War II epic Saving Private Ryan, that's his name, debuts in theaters. Sorry, I screwed up your fun fact. Oopsies.
That's why we put it in writing.
I never said reading was my strong suit. Oh,
1998. My daughter was born. So that movie must be 25 years old.
That's enough to make you feel old.
So you did that instead of going to the movies?
I was pregnant then.
Alrighty, they're back.
Yes. To answer your question,
Research,
yes, I did.
as I'm sure you all were.
A
What you were
lot.
doing.
I was notified by a deputy
Uh-oh.
that an unidentified female had come to the lobby of the 9th floor of the Judicial Center, had said that she is a reporter and she had information about the case and that she wanted to meet with me.
What's this?
And my response, and my judicial assistant, if I wanted somebody in the room. My response to the deputy was that I can't meet with anyone, but that if there was information to share, we were starting court at 12:30, that she should come to the courtroom and identify herself to the deputies as the person who wanted to speak with the court, and I would hear what she had to say in open court. A couple of minutes later, the judicial assistant that is filling in for my usual judicial assistant came into my office and said that the deputy had called her by phone and said that the unidentified woman had said she would not appear at 12:30, and that was it. So I'm just making a disclosure of extrajudicial matters that happen. I can give you a minute if you'd like to talk with your client and your respective co-counsel.
I would certainly like to know what it was she had to say, and I would invite her to contact me. I would make a determination whether or not it was something that I thought was worthy of being brought to the court's attention and to the prosecutor's attention. That's all we can do.
State, you want to be heard?
No, thank you.
Okay. All right, then let's finish up this impeachment argument, and then we'll get the jury. At this point, I've asked for the jury to remain downstairs in the jury assembly room. Just it's more comfortable. The chairs are more comfortable. They can spread out. They have vending machines and so forth. So, all right, it's.
So did someone approach the judge or?
It sounds like somebody approached a deputy to tell
During
the
the lunch
judge
break?
that they wanted to talk to the judge because they had said they were a reporter. They had information, and the judge isn't going to do that. But so the judge said to be in the courtroom at 12:30, and then they said no.
But they didn't elaborate what information.
No.
That's weird.
So the defense attorney's like, well, they can contact me. I'd like to know what it is. And I'll share if I think I need to. And the state, he asked the state, do you have anything to say? No. So kind of makes you wonder if they, one, don't care, or two, know what it is. But
Judge
that's all right.
Judge Granville down in Atlanta would do that.
Oh, yes. Well, that didn't work out so well. He's gone. That case, that trial. Oh my gosh. That thing is, that is something. I'm so glad I didn't try to do it. I think there was evidence of it, Adair. I do think they talked about that in the
Yes.
first witnesses yesterday, that there was evidence of it.
Yeah, there was an intervention order against him
So,
that she'd had.
but wasn't there, they got his daughter, right, to admit when she was on the stand about his anger, and there was a hole in the wall that was from his fist.
Yep. There was a bullet hole in the ceiling where he'd fired a gun during an argument into the roof in his temper. There was a hole in the wall where he'd punched a hole in the wall during an argument. And yeah, the daughter testified that that's what happened.
Yeah. So yeah, there is. He
definite anger issues there.
Yep. All right, let's see if they impeach this wonderful attorney. Maybe she had a wardrobe change during lunch.
Is she back again?
I think they're
I
trying
thought
to
they
impeach.
finished with her.
Who they're trying to impeach? That they're keeping the jury out for. Isn't it her?
I can't remember.
Miss Fuchsia?
Yeah.
I think it's the attorney, because she was the last person on the stand when they broke for lunch.
Didn't they finish up with her?
No, I thought they got her off the stand, and then they had that big long sidebar, and then the judge said go to lunch. I think the defense attorney is arguing stuff that he wants to ask her.
I think so.
But,
yeah.
Okay.
Push play, and we shall see.
Will. All righty then.
Specifically, I am objecting to the manner in which the defense is trying to impeach this witness. I just want to frame the issue. This witness's character or bias based on what we spoke about before. First of all, I would say character is never appropriate for impeachment. I do have case law on point, but I think it's pretty clear that the only evidence of character that is allowed for truthfulness is reputation. And specific acts of untruthfulness are not allowed. So character, I do not believe, I don't know if the word was just used interchangeably, but I do not believe character has any part of this, and attacking character is not allowed. As to bias, I do not understand how what the defense is trying to do would achieve any bias. No ethical obligation or ethical complaint was ever filed. Even if one was filed, I don't know that would be allowed to come in this case in this manner. I found no case law to say that type of information could come in. But I also have objections to the manner in which this is trying to be done, because number one, Stephanie Murphy testified that the original petition for injunction had allegations in it, X, Y, and Z. Later, the defendant filed for, I think it was divorce, and alleged X, Y, and Z. I think what the defense is trying to say is that this attorney denied that allegation that was alleged in this petition after this attorney had been at Doug Benefield's deposition, implying that Stephanie Murphy knew different, but yet she still denied that paragraph of the petition. I have so many objections to that, but mainly I think even if that type of thing were allowed, This is like a motion to dismiss in criminal court, where you admit a paragraph, you deny a paragraph. It sounded like she said that that paragraph, number 5, was 7 pages. So I can't imagine anyone agreeing to a 7-page recitation from the other side. So I do not think it stands for what the defense is purporting that it stands for. But even if it did, I do not think it's appropriate for impeachment.
Defense?
Okay, so here's what we know. And by the way, if I use the word character in referring to this, I was mistaken and I meant to say credibility. Here's what we know regarding Stephanie Murphy's testimony. She acknowledged that Ms. Benefield filed this domestic violence injunction petition, and she specifically mentioned a couple of the allegations. Court may recall, in particular, shooting the gun in the kitchen into the ceiling, punching the dog, and potentially suspecting that she was being poisoned. So that the court appreciates my position. The fact that she mentioned 3, my position is it opens up the entire petition. She doesn't get limited to just the 3 she chose to mention on her direct, because the state called her, they opened that door. It's before the jury. I'm entitled to rebut it and probe it for credibility and bias. Now, with respect to what Ms. Murphy did or failed to do, she comes before the jury and announces herself as an attorney and that she's representing Douglas Benefield. She then responds to Ms. Benefield's petition where these things are alleged, this inappropriate conduct, abusive conduct, if you will. And she denies that paragraph in Ms. Benefield's pleading, specifically paragraph 5, that Judge White lists all the horribles, the domestic violence horribles. So it's our position, so that we're clear as to how I perceive this should unfold. She then never corrects the record, regardless of whether it's a violation of the code of conduct, which I do think is impeachable, to show bias and favoritism, and to show failure to act within her expected realm of conduct. But in addition, 27 days later, she is present at the deposition of her client, where he admits to all of these: shooting the gun, punching the dog, knocking the dog unconscious, punching holes in the wall, throwing a loaded firearm, I believe perhaps putting a tracker on a car, whatever it is, he admits to it. I am entitled to ask her why, in light of that, she never advised the trial court that her client admitted to this conduct, and why she didn't bring that to the trial court's attention. She never did. So it's not that I am particularly determined to show that she violated the code of conduct, which again, I do think I should be entitled to ask, but merely to show that the trial judge, I will ask you this question also, the trial judge wasn't at the deposition. So the trial judge never knew about these admissions. Now keep in mind, this is what she's presented to this jury. I am trying to rebut that. I am at least trying to cast doubt on that witness's credibility. I have 2 cases in particular, in an effort to respond directly to Your Honor's request. No, I could not find a case where a lawyer was called as a witness, and based upon cross-examination of the lawyer who failed to follow a particular code of conduct, impeachment was allowed. What I do have, however, is
typical scope of cross-examination as it relates to professionals and as it relates to lay people. I want to mention the cases to the court, and then I'd like to read what I think is the relevant section. So the first one is Mendez versus State. It's a second DCA opinion. It's dated April 21st, 1982. They say in this case,
Page number citation.
page number is.
No, the whole citation.
Oh, so the whole citation is 412 Southern 2nd, 965.
Thank you.
The court says in this particular paragraph, cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test a witness's perceptions and memory, and to impeach that witness. And they cite United States versus Williams, federal case, Judge White, 592, Fed 2nd, 1277, Fifth Circuit, 1979. Limiting the scope of cross-examination in a manner which keeps from the jury relevant and important facts bearing on the trustworthiness of crucial prosecution testimony is improper, especially where the cross-examination is directed at a key prosecution witness. More important, and they string cite a bunch of cases to justify that, more important, a defendant should be afforded wide latitude to demonstrate bias or a possible motive of the witness to testify as she has. That's the Mendez case. And in that instance, the witness was a layperson. It was an appeal of the conviction for attempted second-degree murder of a police officer. The court reversed the conviction based on what I just read, Your Honor. I also have, Your Honor, Roosevelt versus State. It's at 42nd Southern 3rd, 293. It's a 3rd District Court of Appeal decision. It's dated August 4th, 2010, Your Honor. This was a conviction for a sexually violent predator.
Thank you, Adair.
And commitment under the Jimmy Rice Act. It was reversed. It was reversed based upon the main question on appeal is whether the trial court erred in allowing the state to impeach the defense expert witness, Dr. Natalie Brown, concerning 3 separate matters. So in Roosevelt, it was a professional witness. She was a psychologist. The state was allowed to cross-examine the expert about an email that she sent while serving as a defense expert several years previously in a Florida criminal case. The state argued this testimony showed the expert's willingness to tailor her testimony to favor the party who had retained her and was therefore admissible to show bias. Here's what the court stated. Our evidence code liberally permits the introduction of evidence to show the bias or motive of a witness. Included within the types of matters that demonstrate bias are those that relate to the interest of the witness, favoritism, and corruption. Dr. Vaccari's willingness to forge her interview notes at the request of the defense attorney could illustrate Dr. Vaccari's corruption as a mental health expert. Therefore, because this line of impeachment could properly relate to the witness's bias, we find that the trial court did not abuse its discretion in permitting it. The last case I have to cite for the court is Russ versus City of Jacksonville. It is at 734 Southern 2nd 508. It's the First District Court of Appeal, Judge White, and it was decided May 19th of 99. The court reversed and remanded the ruling for a new trial because the trial court committed an error when it denied the admissibility of information relating to the prior DUI arrest practices of the defendant's city's witness. So in this case, Your Honor, it was the impeachment of an officer. Turning to the merits of the appellant's argument, impeachment of evidence by the officer's prior acts. Turning to the merits of the appellant's arguments, the credibility, bias, or prejudice of witnesses who testify in a case, as well as the weight to be given their testimony, are a matter for the consideration of and determination by the jury. Where the credibility and bias of an officer is brought into question by virtue of that officer's past acts, impeaching evidence of the officer's past acts is admissible. As the Second District Court of Appeal explained in Mendez versus State, which was the first case I cited to Your Honor, quote, whenever a witness takes the stand, he by that fact places his credibility in issue. Cross-examination of such a witness in matters relevant to credibility ought to be given a wide scope in order to delve into a witness's story, to test the witness's perceptions and memory, and to impeach that witness. The right of full cross-examination is absolute, and the denial of that right may easily constitute reversible error. I'll be happy to show you what the cases if you like.
I was familiar with Mendez and Russ. I'm well aware of those two cases. Those come up quite a bit. And Roosevelt, you've explained it. I'm happy to take them, but it's up to you.
All right. So if the court's aware of it, I don't see any necessity if Your Honor wants it, it's here for the court. My opportunity of Sixth Amendment right that belongs to Ms. Benefield to cross-examine Stephanie Murphy is restricted when the court doesn't allow me to quote the story that she told here today. And that's going to include, respectfully, Your Honor, my then being able to ask Ms. Murphy, so I can try to save time here for the court and everybody else. In fact, did Douglas Benefield make these admissions at his deposition when you were present? And I propose to tick them off one by one. The reason for that is the court may recall that Ms. O'Donnell asked Stephanie Murphy what she observed, not only when they did the first exchange and how pleasant Doug Benefield was, but she concluded Ms. Murphy's testimony by having Ms. Murphy opine what a gentle, kind, and decent guy Douglas Benefield was. And I have previously given Your Honor a written memorandum establishing the case law that says questions such as, well, did you know, Ms. Murphy, that he admitted A, B, C, D? Yes, you knew it because you were present. Are proper questions on cross-examination. If the court disallows that, the court has abridged Ms. Benefield's right to cross-examination. And I might add, Judge White, in the interest of fundamental fairness, given her testimony, I should be able to ask her that.
Steve?
Judge, and I'm confused about exactly what's being impeached. So apparently, what the defense is saying is that because Stephanie Murphy said, during the time that I dealt with Doug, he never overly expressed anger towards Ashley. I guess that's a new one. So apparently that now opens the door to showing that she knew other things. The question to her was, during the time that she was dealing with Doug and Ashley, what was his level of anger? Not what had happened before, not what she knew before. So I'm not sure that's how that opens the door when I ask her what the behavior was during the time that she dealt with Doug. So I'm not, and that's a whole different issue than all the case law we just talked about. I do obviously agree with the case law that you are allowed to impeach under the right circumstances, under the law, if the matter is relevant to credibility. I do not believe that any of this is relevant to the credibility of this witness. I believe that the defense is merely doing this for obvious reasons, trying to get in the admissions of Doug Benefield, which I dispute that he admitted things the way the defense characterizes them. So just by virtue of the fact that they're stated differently, I would disagree with their statements that he made. So I think that is what the defense is trying to do by labeling it as credibility and an attack on credibility. I think even if an attack on credibility was allowed under such circumstances, the specifics of these items would not come in. The fact that Ashley Benefield's petition for injunction listed 3 things does not open up Pandora's box where he can then impeach on the fact that the defendant admitted to those things. The court has already ruled that the state can generally talk about what the complaints were, that they were denied, and that type of thing. That's what the state did, generally talked about what the complaints were, and then that it was denied by the judge. So that's what the state did. I don't know how that opens the door to this type of attack.
Very briefly, Judge Mayor. All right, so I think from the first moment I had a hearing before you in this case, I have explained the procedures that I follow, whether it's a motion hearing, an objection, and that is the objecting party goes or the moving party goes, tell me everything you want to tell me. And then I go to the other party, the non-moving party, or the party in this situation that's the proponent, and I say, tell me every argument that's in favor of you, and then I go back for rebuttal. And the reason I follow that process, and I've been very clear, and I've always followed that process, is because otherwise it'll just be back and forth and back and forth and back and forth. At some point, I have to make a decision and move on. All right. In this particular situation, as with all cross-examination, multiple factors are at play for any particular witness for impeachment purposes on cross-examination. Their perception, where they were, what they could see, what they could hear. There's 5 senses. Their memory of that, their ability to recall, their ability to communicate, their bias, any motivations they may have to testify a certain way, prejudices they may have, interests they may have in the outcome or a particular ruling, prior inconsistent statements, prior convictions. There's another number of avenues. And that's explained further in the case law. I have not been provided a case on point for this particular scenario. So as Mr. Taylor has astutely pointed out, whatever ruling I make may very well be the subject of an appeal to the 2nd District Court of Appeal. They may find I did something wrong or let something in I shouldn't or kept something.
All right, Jodie. You're going to go to bed. You're bidding us adieu.
Oh, yes.
Night, night, Governor.
Did you? Arrivederci.
Arrivederci.
I might be in the chat. I'm going to lay down and and watch a little bit before I become unconscious. But it was lovely speaking with you all and being here again. And I shall see you all on the morrow.
Yes, I
Good
will
night.
see you
Bella.
in the morning, and you go get some rest. You deserve it. I will we will be here. I'll be here till today's over. So we will be all caught up for you in the morning.
Thank you. Thank
All
you.
right. Go to
I
sleep.
shall see you then.
See you later, Sam.
Bye.
Bye.
Aw, I miss Jodie already. Jodie, come back.
Adios.
Adios, amigos.
There she went. Poof. She's gone.
Boop.
All right. Let's
She's
see
outta
what
here.
he has to say. His face while he's sitting there listening doesn't give anything away. He just stares straight at you. Like,
Yeah, he has the same face all the time.
yeah, it's like, are you thinking or feeling anything, sir? Because you don't give it away.
Well, the first day when he was looking out over the top of his glasses, I was like, well, that's not good. But
Yeah.
now it's like he always looks that way. So it's hard to tell.
Yes, he has a great poker face. Like, he has no tells. I haven't picked any up yet anyway. All right, let's see what he's going to do.
Something out I shouldn't. And that's just the nature of trial work, the nature of being a trial judge and making decisions on the fly. But I'll frame this one up as best I can so it's ready for the appellate court. I find that the current avenue of impeachment of Ms. Murphy is improper. I'm going to sustain the objection. I find that it is improper impeachment to attempt to get in the victim's statements made in a deposition in a civil case unrelated to the criminal case through the impeachment of his attorney in the civil case based on an allegation that she violated a rule of professional conduct by not amending her answer to his complaint when it is alleged that she subsequently became aware of contrary information. I find that it doesn't provide any basis for impeachment under the existing case law, and this may be the case that says it does. All right. So are we ready to bring the jury back in?
Yeah, yes.
Before you bring them back in, just so I understand, so I'm precluded from basing my cross on the failure to conform to the professional code of conduct. Am I likewise precluded from probing her statement that Doug was a gentle individual and that the complaint that was filed was unfounded? In fact, the court report played back that was her characterization, that the allegations by Judge Moreland were unfounded.
I sustained that objection. So, sustained. Are you ready to bring the jury back in?
Yes, but do we need the witness on the stand?
Yeah, I'm just asking right now,
Yeah.
are you ready?
Yes.
Are you ready?
Yeah, I would like to first make a motion. I move for a mistrial. I move for a mistrial based on the court's absolute and consistent denial of Ms. Benefield's right to cross-examine, and at every turn, the court's ruling adverse to the defense, despite the fact that the court has, under the same circumstances, allowed the state to be able to pursue it. I think individually, perhaps, it could be argued that they don't reach the level of reversible error, but I think cumulatively, especially given the state of mind that the court displayed in writing the order denying the stand your ground, where Your Honor fully stated that Ms. Benefield was guilty. I think we are seeing the result of that, and we are being denied not only right to cross-examination, but the right to a fundamentally fair trial.
Would you like to be heard?
Yeah.
Denied. You ready to bring the jury in?
Yes.
You ready to bring the jury in?
Yes.
All right, can you have Ms. Murphy step back in, please?
He's making a great record in case they do have to appeal it. State knows it's gonna be denied. I've never seen the state not try to argue it, but whatever. It would have been something if he said granted and the state didn't even argue it. They would have deserved that. But yes, he is unrelenting. He's just making his record. There's Miss Bright and Shiny, and don't think for 1 minute she doesn't know what she's doing, because she does.
Actually, I think he should have granted it. They didn't impose it. So, yeah. Okay.
Yeah, they didn't say anything. Yeah.
Mistrial.
Yep. Bye.
Well, actually, no, because mistrial means he's got to hear it again. If it had been for dismissal, then that would have been different.
Yeah. That would have been hilarious, though, because they would not have seen that coming.
Yeah. Oh, Judge, no, what we meant to say was.
Yes. Oh, I like him too, Chrissy. He's just making a really clear record of this.
He's doing a great job, I think.
Yeah. Man, all those people just look, not that they should be happy because they're there because somebody they liked is not here anymore, but dang, this is in their everyday life. They look miserable. All right, come on, Jerry. So I don't even know, his questioning sounds like has just been so limited, and hers wasn't. The prosecutor's wasn't. Oh, Judge Mama. It's been here in a while. Great. Thought they were there. So much noise. Yeah, her side has filled in. There we go. Don't be chewing gum in the courtroom, lady. Judges kick you out if you're chewing gum in their courtrooms.
It's tobacco.
Well, we do have a
Ping.
spittoon. Yes. All right, here we go.
On the people, places, things, and legal topics we've heard anything about.
No, sir.
All right, everybody says no. When we broke for lunch, Mr. Taylor was cross-examining Ms. Murphy. You may resume your cross.
Thank you, Judge White. Ms. Murphy, we've pretty much established that the homicide occurred on September 27th of 2020, correct?
That's my understanding, yes.
Okay. And then you've told us here today that Dr. Broder's report was set to be released 3 days later on September 30th. Is that correct?
Yes.
All right. And the inference by you in the state's theory is...
Objection?
Ooh.
So I'm sorry, Judge, was that overruled?
Overruled.
Thank you. The inference by you and by the state's theory is that Ms. Benefield then killed Mr. Benefield to stop the release of Dr. Broder's report.
Are you asking if that's what I believe or if that's what the state's inference is?
Well, you've discussed the matter with Ms. O'Donnell, have you not?
I have, yes. Yes, I have.
And in fact, she's provided you with all the documents in the case, hasn't she?
I don't know if she's provided me with everything, but I have gotten a lot of documents in the case.
By direct conversations with Ms. O'Donnell.
Yes, I did a
Okay.
discovery request.
And so is the implication not that, as you testified before the jury earlier, Miss Benefield shot and killed Mr. Benefield because of this report that was coming out by Dr. Broder 3 days later.
Absolutely. I have no doubt.
Okay, so that's the theory of the homicide.
Right.
All right, so I want to pass you some emails, see if you recognize them.
To move, bro.
Yes.
Closed captioning said, "Send me a friend." Wonder what the emails. Probably aren't going to see him. Is my guess.
This lawyer is such a witch.
She is. Well, which one? This one on the stand?
The
Or
one in
the
Fuchsia.
yeah. Yeah. I mean, if you needed somebody to fight for you, I'd probably pick her. Because I think she would, but it's hard to have lawyers on the stand because they know what they can do. They know where they can go. They know the line.
It'd be different if she was just doing it, but the eye rolling and the smirking and I just don't. I don't like it.
She's kind of arrogant about it all. Like she just knows.
And she knows what she's doing.
Oh, absolutely. And Ashley's decoding because she was on that. I didn't see all of it, but the thing that Jodie played yesterday with Vinny, she was on there, and I mean, she fully believes that Ashley unalived him on purpose.
Yeah, I remember that a little while ago because I was like, why did she look so familiar? But she did like a panel thing where she just went on and on and on about.
Yep. Hello, Bob. Cocktail juice is okay. Wow, that's a lot of
So
noise.
I would like to pass these documents to you and let you just take a look.
She is going to see them.
Take your time.
Interesting. And welcome back, George. How you doing? It's not a trap, George. You can't prove it.
Okay, so I have a series of simple questions for you. Do you want to reconsider whether or not the release of Dr. Broder's report was set for 3 days following the incident?
It was agreed with,
Do you want to,
no, I'm not going to
Answer
revisit
it.
that.
you can answer and then explain if you like. I'd like you to first answer.
Okay. I'm not revisiting the answer. My answer is the same. It was set for the 30th, 3 days after.
Okay.
And I can explain further if you want to hear more.
No,
No.
that's fine. As long as you've reviewed that, it refreshed your recollection, I trust?
It does. I don't think it's a complete conversations, but yes.
Okay. Now, is it not a fact that Dr. Broder on the 3 days following the event was on vacation?
What event? The murder?
Yes. The 3 days following the event that this report was to be released, is it not a fact that Dr. Broder wasn't in town? He was on vacation.
I don't think that's correct. I think he was on vacation the week prior, but I don't know. I try to remember everyone's vacation, but this was a lot of years ago.
Is that document in front of you contain emails between you and?
Objection. Relevance.
Ooh. Does that document that you were holding contain emails between you and Judge Moreland's judicial assistant?
As well as other people.
But that's not what I asked you. I asked you, does that document contain emails between you and Judge Moreland's judicial assistant?
Not only, but yes.
All right. And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report?
Dr. Broder was returning from his vacation on the 23rd. So if you look back
Not
through the emails.
not responsive to my question, Your Honor. She's editorializing. I asked her for a simple answer. She can feel free to explain it after if the court feels that's appropriate.
Also stated, it called for a yes or no.
Well, and that's why I'm saying she.
I apologize. Let me know how it goes, Bree, and let me know what they say about all this vid stuff and how long I have to stay away. Even though I don't have it. Also, isn't it, why do I hear stuff? Sorry. Isn't it super annoying to, when attorneys get up there and they're like, they want you to answer yes or no, but then you watch an attorney and she can't do that. And you just want to be like, see, yes or no answer. They get crappy about it all the time. I don't need you to tell me everything else. I just want to know if that's you and the doctor in the emails. And she cannot do it. It's annoying.
I do not recall.
It makes me want to really just take her eyebrows and really move them up on her forehead. Like, just make some lines in there. It's okay. It's natural. See? Look, mine move all the time.
It's physically painful for her.
It is. I figured it out, Chrissy. My phone had turned up.
Botox.
I think. Am I the only one hearing things? Don't answer that.
I only hear you.
I hear something. I turned my phone is down. Everything else is muted. Maybe I'm picking up somebody else's. I don't know. Maybe it's a ghost. I don't know. Boop. Yeah, it's like little whispery thingies in my ears. I'm going to hit play. This woman, though. She is a Botox. I liked Cocktail Beach. That was hilarious. She's a Botox Beach for sure. And I'm sorry, women, don't get filler in your cheeks. It doesn't go over well. The older you get, the worse it looks. Don't do it.
Okay.
No, it called for a yes or no, so
Oh, okay.
your objection.
Is sustained. Got it. All right. So is the answer to my question
I don't know.
yes?
Can you repeat the question?
I knew you were going to ask me that.
Well, I want to be accurate.
Can I ask the court reporter, Your Honor, to read the last question back?
Go ahead, ma'am.
And you still maintain, after reviewing that the hearing was set for release of Dr. Broder's report?
Yes.
Now, could we agree if Dr. Broder was out of town and not available, and the court would not entertain the hearing unless Dr. Broder was present, could we agree that that hearing 3 days later would not take place?
Mr. Taylor, I don't think you read the emails correctly, because the hearing that her assistant was referring to was a hearing to take place on the 23rd when Dr. Broder was not available because he was on vacation. I'm talking about the hearing that was on the 30th when he was available. That was 3 days after your client killed my client.
And it's your testimony then that the hearing would have taken place?
Had he been alive, yes. On the 30th, not the 23rd,
Yes.
which is what I think you're
All right.
confusing.
You referred to a letter that you sent to Ms. Benefield on March 14th, 2018.
My memory is that it was the 15th of March, but if you have it, that would certainly help. And do you have the email that was sent with it?
No.
Okay, this is not the letter that I sent. This is a draft of a letter.
Mm-hmm.
The letter that I sent on the 15th was on my letterhead, so this is not the letter.
Okay. The letter that you did send on the 15th, I think you told us, if I'm not mistaken, was an effort by you on Doug's behalf to advise Ms. Benefield, among other things, that he wanted to try to work things out.
No, I don't think that's correct. No, that's not what I said this morning, nor was it the intention of the letter. And I don't have the actual letter I sent to verify, but there was nothing about reconciliation. The letter was about whether she would agree to him being present for the birth of his child, what was supposed to be the next month.
All right. So you sent the letter to see if she was willing to have him present for the birth of the child.
Yes, that's right.
We're in agreement.
Yes.
All right. Were you aware whether or not there was any prohibition at the time that you sent that letter from Douglas Benefield coming in contact with Ashley Benefield in any capacity?
I'm aware that there was an injunction that was entered by mutual agreements. It was what people refer to as a mutual restraining order out of South Carolina.
Correct. And it was in effect at that time, was it not?
It was. They would have had to have a written agreement modifying that.
So that would have prohibited Mr. Benefield from being present with Miss Benefield, would it have not?
No, I don't have the South Carolina order in front of me, but my recollection.
do.
Oh, that would help if I could see it then.
May I, Your Honor?
You may approach, yes.
Here's the transcript, here's the order.
What is the date of the transcript?
Well, the date of the hearing was November 3rd, 2017.
November 3rd. And you were aware that the order was entered for a period of 6 months, correct?
Didn't you hand this to me for me to look at?
Sure.
Okay.
Okay, so what's the date that the hearing takes place?
The hearing took place on November 3rd, 2017.
And at that hearing, Doug was present.
It appears so, according to the order
All right.
that was entered
And
10 days later.
if you look at the last page, I believe paragraph 2, the judge orders.
I'm going to object to going through this hearsay piece over.
Are we only talking about the order?
Right now, she's looking at the transcript.
No, this is the order.
Okay, the order.
If it's a court order and you're asking the witness to interpret it, I think that's okay. I think she's demonstrated that she has sufficient experience, training, and knowledge.
All right. So the hearing concluded on the 3rd.
It appears that it did. You know, I wasn't there.
Yeah.
This was before my time.
But you were aware of that when you sent the letter to Miss Benefield. In other words, you knew you were sending the letter because Mr. Benefield was not allowed to communicate with Miss Benefield. Wasn't that why you sent the letter?
No, that's not why. Maybe that's why he didn't send her a letter, but that was not the reason why I sent the letter. I sent the letter so that it was a formal request, not in between the two of them directly.
Would you agree that had Douglas Benefield asked that of Miss Benefield, it would have been in violation of that order?
Mrs. Fain.
Let me pass to you, if I can, this document.
Did you see it?
I did not. I don't know.
I need you to show it to opposing counsel before you show it to a witness.
I thought she had a copy.
He probably got confused of who opposing counsel was. Forgot she's not on the stand. Because she's being super hard to get along with.
Miss Murphy, is it not a fact that you knew on September 18th of 2000 that the only matter being heard 3 days later on September 20th was the injunction, not the release of Dr. Broder's report?
Now, I think you're getting the dates confused again. So this was September 18th, was this email talking about the judge setting a hearing on September 23rd, because in this email, she did say the only matter being heard on September 30th is the injunction. That changed after this time. And you don't have those emails, apparently.
Do you?
Well, no, I don't have my file with me. It's 3 boxes worth of documents. But before we even went to mediation, it was agreed and the court was advised that we were going to be addressing only the joint motion for the release of the psychological evaluation.
Which was not said on that day, correct?
You mean the 23rd, which is what they're talking about in this email?
Yes.
Right, it was not said on the 23rd. Dr. Broder was on vacation.
Okay.
It was going to be said on the 30th.
Did you know whether or not Doug Benefield sent a package to Miss Benefield in November of 2017?
I don't remember the date. I know that he did send her a package before this order was signed, but after the hearing took place in South Carolina.
Okay, so after the judge ordered no contact, he sent her a package.
My understanding is that Doug did not really understand what was going on at this hearing. I know Ms. Benefield was even chastised by the court for manipulating that system.
Well, thank you for adding that. Let me just ask you a question. What is it about you may not contact Ms. Benefield that you think Doug didn't understand. By the way, Doug was there and heard the judge say it, so enlighten us, please. What do you think it was about you may not contact Ms. Benefield that Doug would not have understood?
Doug did not have the court order when he went.
Hello, Memento Mori. Hope I'm saying that correctly. Welcome. I think this attorney just finally got to where we were going because I wasn't sure. So, welcome. Glad you're joining us.
Went to buy her birthday present. He told me that the negotiations about this mutual restraining order took place in the hallway outside of the courtroom. But I wasn't there, so that's just what I was told. And we had the time that he received this order from the judge, from his attorney's office, and it was after he sent the package.
Okay, so this report by Broder, the one that you acknowledge and the state suggests is the theory behind the homicide, Miss Benefield had signed a voluntary agreement to participate in that evaluation, correct? It was not court ordered. Isn't that what you told us?
It was not court ordered in the
Okay.
family law court.
So
I don't
she
know what she signed.
She voluntarily participated.
I don't know. You're going to have to talk to Manatee County Sheriff's Office because it came out of that office or the CPT office.
Well, you were the lawyer for Mr. Benefield. Was your client ordered to participate?
I don't know that we're in agreement with the word ordered. So when I think of an order, I think that a judge has ordered people to do something. And so we had filed a motion for a psychological evaluation in the family law court. And so if that judge had signed the order, that would have been an order. So my answer is I don't know if either of them were ordered to participate.
You're not aware of any commandment that either Mr. Benefield or Ms. Benefield participate in Dr. Broder's evaluation.
It's my understanding that they were both required to as part of the investigation with the Manatee County Sheriff's Department.
Give me just a minute, Your Honor.
Yes, sir.
It just took him a long time to get there, Chrissy. And once he finally got there, he didn't stay there very long. He certainly doesn't make it easy.
Please.
Oh, she's definitely dancing. Absolutely.
Are you asking for a moment?
Yes. Please.
I cannot. We thought it should be allowed, but we're not attorneys. If anybody else has any different take on it, let me know. I don't know. I didn't understand it.
The only thing I got out of it was just because she's unethical doesn't mean that she is lying, which doesn't make any sense to me.
I missed the first part. Because she's unethical doesn't mean she's lying.
Yeah. I mean, that's what I got out of what the judge was saying. But
Yeah. Huh.
again, I'm no lawyer.
Yeah, me either. But, you think that's a weird. If I can see that, and if that's the argument the judge is using, that would not make sense to me. Okay, Chrissy. The cases that he brought up. Okay. That the attorney brought up. Didn't correlate to this one and what Bryce said. Oh no, I don't. I don't know that I don't think he's trying to throw this case for the state.
No, I
don't,
think he's trying to. I think the judge is trying to be fair. It's
yeah,
his interpretation. It's just the way he explained it, which I'm sure lawyers understand, didn't make sense to me because I'm not a
right,
lawyer.
right, right. And I mean, just, we don't agree with it. Probably just on a completely different level of why he doesn't agree with it. We don't agree with it because she said so much, and that it felt like he should be able to counter it, and he wasn't. But no, I don't think he's trying. I don't think
I
anything like
really
that.
like the judge.
Yeah, I think he's done a good job. And I think the defense attorney has done a great job of keeping the record really, clean if they need to have an appeal. So I mean, they're doing their jobs. We just may not agree with
Yeah,
the
and I think
ruling.
it was, at the end he said, I don't think any of those cases are on point that say that I have to do it this way, the way you want. But in appeals, maybe this is the case that's going to prove that. But
Yep.
this is my ruling. So
Right. And that's kind of a problem with the law, because he gets to interpret it the way that he interprets it, and then somebody else gets to do it how they see it, and it's not necessarily uniform anywhere, because you never know how one judge is going to see it and interpret it, and then go to the next and they do it completely different. So I guess that's where the human factor comes in. And I don't want robots judging us, so I'm okay with it. I don't trust AI.
agreed.
I don't trust that at all. I just hope he is about done with her, because he's probably really lost the jury by now.
All right, one last shot.
She wouldn't have felt it.
Can I see the document
Yes, same document, actually.
of the same one from before?
Yeah. Does that document have any impact on your position that the release of Dr. Broder's report was scheduled for September 30th?
It was scheduled for September 30th. We knew before the weekend that the hearing on the 30th was going to address the joint motion to release the psychological evaluations. Ms. Brown and I had extensive discussions about that, because Ms. Benefield was agreeing to dismiss her petition.
Ms. Murphy, I'm sorry to cut you off. Is the answer to my question no?
No, you're not.
That it doesn't change your position?
It does not change my position. It was scheduled for the 30th.
Well, when we say scheduled for the 30th, is it not a fact that the only hearing that was to take place on the 30th was everything other than Dr. Broder's report?
If you
Is the answer to my, let's get a simple answer. Is the answer to that yes?
I don't have the docket, so I guess the answer is I don't know what the docket says. All I know is
You
it was
did not
scheduled for
know.
the 30th.
Objection, Judge Leonard, answer the question.
You trying to make sure you.
All I know is that was supposed to be addressed on the 30th of September.
And were you not told on the 30th September that the only issue that would be heard was the
Objection,
domestic?
asked and answered.
Who was the domestic violence injunction? That's what I'm asking you. Is the answer to that yes or no?
Initially, that was what we were told. That was not the case by the time we got to mediation. The situation had changed.
Yeah. And do you have any documents that you brought here today to support your contention and the state's theory that the release of this report was the incentive for Miss Benefield to kill Douglas Benefield? Do you have any documents that show that that correspondence with the court's judicial assistant was wrong? And that,
Objection, compound question?
and that the only matter being heard was
Objection,
not,
compound question?
was not the domestic violence injunction?
Sustained.
Do you have anything that supports that the release of Dr. Broder's report was scheduled for the 30th?
I don't know what documents you got from Ms. O'Donnell's office. However, I did provide
Do you
emails.
have any documents here today?
I didn't bring anything, nor was I asked to.
Okay,
You should
so
have
you
the
knew,
emails.
wait, you knew you were coming to court to testify before the jury in a homicide case,
Objection, badgering.
Go ahead and answer the question.
that the incentive for Miss Benefield to kill her husband was the release of this report on the 30th. You don't have anything to support that other than what you've told us?
Sustained.
That's all.
Fine. Don't be sure you have one more paper. Mr. Taylor, don't forget your paper.
I'd like to approach also.
I'm done with
Have
it.
the witnesses.
All right, redirect.
Oh, whoops, sorry. Hang on, Brian.
No questions, thank you.
Oh,
Can
really?
this witness be released?
Yes.
Absolutely not. She's under our subpoena.
All right, ma'am, you remain under subpoena, as I said before, same.
Witness
rules on-
jail.
Absolutely not. What'd you say?
Witness jail.
Yes. I mean, if that's badgering the witness, give me a break. I've seen lawyers go after witnesses way harder than that. That wasn't badgering. Whatever. Yeah, I just hope that I am glad, yes, Chrissy, I'm glad that he let him finish the questions before he sustained them and all that stuff. I just hope that in the process he didn't lose the jury because he
Yeah,
lost
it
me on some of it.
took him a long time to get there.
Yep, we took the long way around. Is he excusing the jury?
And I was getting nervous there because he was getting all those dates in there that she was saying, you're confused about the dates. And essentially all he wanted to get her to say was, you don't have any documents about this being on the docket for the 30th. So
Yes.
that was really a one question cross-examination. That's what it should have been.
Yes, but sorry, I've got a hair flying in my face. She wasn't going to let it be that way. She didn't answer. I think it's hard for any attorney to answer yes or no just to a question anyway in general life, but she certainly wasn't going to do it. Oh, I don't want to make that go back to the beginning. What'd you say? I feel like, though, with her, he had to take a certain route. I do agree.
Yeah.
And he was shut down in a sense. But I just hope that you stayed right engaged with it, Chrissy. I hope the rest of the jury did too. And because I got a little lost, I'm not going to lie. I do not have a hairball. I have a hair. Yeah. I just have a hair. All right, let's see what they're doing. I don't know if I think the jury, he sent them out because they all stood. Richie, that's because you're smart and you can multitask.
I apparently
Subpoenas for depositions and trials in the old days had to be procured from the clerk, which is obviously a branch of the court. That was changed many, many years ago to allow attorneys to save time and effort and money for everyone involved, where attorneys of record were granted the authority under the Florida Rules of Criminal Procedure to issue subpoenas for deposition and trial. I would imagine if we pull them up, and I'd be happy to take a look at it, I would imagine that the subpoena that was issued is for the court.
I would have to look at this.
My position is when a witness is subpoenaed to court, and the reason I ask each and every time, can this witness be released? Because I believe witnesses are subpoenaed by the attorneys on behalf of the court. So whether you were subpoenaed by the state or the defense is of no moment to me. I asked, could you be released from a subpoena? The state said yes. The defense says no. That's all I need. So, Ms. Murphy, you are not released from your subpoena.
Thank
The obligations regarding the rule of sequestration in Florida statutes applies to you. Thank you.
Thank you.
Apparently, the state didn't want her to remain under subpoena. Sorry, I muted it. We missed it.
All right, the witness has been excused. Mr. Taylor, you wanted to approach, but the jury's out, so I figured might as well just take care of it now.
Sure. So now I would ask that the court issue a subpoena to Judge Moreland's clerk. The court may recall that we had an in-camera hearing where the court quashed the defense subpoena to Judge Moreland's JA and told me that there were better ways that I could prove my case and that the court shudders to think what would happen if every JA were subpoenaed. What the court's just witnessed is Ms. Murphy lied flat out about the reason why Ms. Benefield feared release of that report, and my impeachment of Ms. Murphy indisputably is going to come from Judge Moreland's JA, who told Ms. Murphy in the emails that I handed her and showed her the only thing that is set for hearing on September 30th, 2020 is the domestic violence injunction. Nothing else will be heard. In fact, I'm going to read for the record. I'm going to read the one sentence email that was sent. The reason I'm going to stop you at this point is you're referencing arguments that were made in camera. The state was not present at your request in order to preserve trial strategy of the defense. Yes. Present at that hearing, when we stepped back into the jury room, was myself, a court reporter, Mary Ann Floyd, the general counsel for the 12th Judicial Circuit, Mr. Taylor, and Ms. Benefield. The state was not present. They didn't have an opportunity to be heard or know these issues. Now, the issues are being brought to light. In order for them to have a fair opportunity to understand the issues and be prepared to argue against whatever motions the defense may make, I certainly think due process requires they're entitled to notice and opportunity. I would do the same for the defense if there was some issue for whatever reason that I had considered in camera or ex parte for the state, and whatever reason the need for the privilege or confidentiality no longer existed, prior to having a hearing on that issue and requiring the defense to respond to it, I certainly think at a minimum, notice of the issue and an opportunity to be heard. So right now, they don't even have a copy of the order
that I signed that you just quoted from, Mr. Taylor, and they have no idea what you're talking about because they've not seen that order because I ordered it to be sealed.
Yes, if the court will allow me, I'll elaborate. And I would like to read the email in particular.
The issue that you seek to have heard right now, I am happy to hear it. However, it is not a pressing matter. You seek to have a witness subpoenaed in order to present, I would assume, during your case in chief.
Yes, sir.
We could certainly address that issue at the end of the day after the state has had a chance to review that order. And I don't recall if the motion. No, the motion itself was public, but then we had the in-camera hearing, and my order was I sealed it.
Yes, sir.
So
we had the email chain also as an exhibit.
Yes, so the email chain is an exhibit. There were two exhibits actually. I can't remember what the other one was, and then we had my order. So I'm going to need to unseal those things so you have you can get copies of them.
I remember what the other one was. It was her prior testimony from the stand your ground hearing.
It was excerpts from the stand your ground hearing, excerpts of Miss Murphy's testimony. Right. That was exhibit 2.
Correct, saying what she said today.
Okay.
So the only thing, if I may, that I want to supplement today's record with is I showed Miss Murphy an email dated September 18th of 2020 at 10:18 a.m. included between her and the judicial assistant for Judge Moreland. And it says the following: good morning, Miss Murphy and Miss Brown. Per the judge, she will not sign an ex parte order for release of psychological evaluation report. The judge will allow an expedited hearing on this motion. I have available Wednesday, September 23rd at 9 a.m. for 30 minutes. However, besides both attorneys being present, the judge has stated that Dr. Broder and Manatee Children's Services must be present at the hearing as well. Further, Ms. Murphy, the judge stated that absent showing where the court granted permission for the other motions stated in your September 17th letter to her, the only matter being heard on September 30th is the injunction hearing.
And that is part of the email string that's one of the exhibits.
Yes, sir.
All right. So like I said, I don't think it's appropriate to hear this right now. I think the state has every opportunity and should be allowed to review my order and the 2 exhibits.
Judge, can I just be heard real quick?
I'm sorry?
Can I just be heard briefly on something?
Of course.
Now, or you want me to wait?
Go ahead.
Okay. I don't know if, because I'm unsure what Your Honor is referring to, because we haven't seen it, the seal. I don't know that any of the things that Mr. Taylor just showed to Ms. Murphy were ever provided to the state in discovery, which is one issue. We received a defendant's exhibit list that was unnumbered and in no particular order. It has 391 items on it. I spent more time than I should have trying to organize it in some fashion, and I do not believe that any of those emails were ever provided to the state in discovery.
Wrong.
If they were, I'm still speaking, sir. If they were, I would just ask if somebody could give me the name, because I numbered them, but it has 391 items on it, and it's some of them have multiple things inside them, and they're not named anything that you can understand. So I'm just asking that if in fact they were provided, if we could, the items that were shown to Ms. Murphy, in addition to what Your Honor has said, unseal, please.
All right, I'll let you 2 work on that, and I will look forward to having a Richardson hearing at the same time that we have the hearing on the defense request for me to reconsider my order quashing the mechanic trial subpoena.
a very aggressive typing, Judge.
Hey, what did the keyboard ever do to you?
Yeah, I don't know, Chrissy. This has gotten very confusing because we're talking about in-camera stuff which took place in his chambers without the other side. He sealed stuff. If it's about the stand your ground hearing, I would think he would want to be very careful about unsealing any of that. Oh no, I wasn't there. Just like the state and our Swan Street thingy. And this typing that is so aggressive.
Yeah, and they should have objected to those documents when they were shown them.
Yeah, I think that's what Chrissy was saying. He does. I was okay until this last witness, and then I got a little lost. So she is accused of unaliving her husband at the time. I guess he unalived that way. They were in a custody dispute, and a divorce was pending, and she is accused of unaliving him. She says it was self-defense. She had a stand your ground hearing, lost that. And then the last witness that was on the stand was her husband's attorney for the divorce, I believe. So that's why that was just so weird and crazy, because attorneys know how to play the game, and she was playing right back with him. So I don't know exactly what's going on right now. They're talking about a hearing that just the defense had with the judge. The judge signed an order. He sealed that order, and now the defense wants that unsealed, but the state hasn't seen it yet. I didn't even know that could happen before a trial. I thought if both sides had to be in there.
I think in some limited circumstances, one side or the other can have an ex parte in-camera hearing on an item if it has something to do with preserving the strategy, their trial strategy. It's unusual, but
Yeah. Because, now the state's going, we don't have any of this. I'm just worried he's going to unseal too much. And whatever he's trying to do, because I'm lost on what that is. I don't know what he's trying to do.
I heard it that time, AJ.
Okay, it's not here. I don't know what it is. See, I told you, I'm not crazy most of the time.
Well, it's either that or we're both crazy.
Well, dang it. Yeah, I think it worked against them. Yeah, I think he should not have done that. I was kind of surprised the judge didn't get mad. Like, hey, we've already dealt with this. We're not dealing with it again. But he didn't. He just like, okay, you want to unseal it? We'll seal it. Thanks, Bob. At least you didn't call us cocktail beaches. I'm not sure about that one. Oh, sorry. Let me see what he's saying.
The two exhibits that were admitted by the defendant during the in-camera hearing, and unsealing the notes and transcripts of the court reporter that was present for the in-camera hearing. I'll sign that right now. Should happen pretty quickly, and state, you'll be able to get copies of that, and we'll see if we can have this argument by the end of today or first thing tomorrow before we get started. On the defendant's request, or a tennis motion to reconsider order quashing, and the state's Richardson hearing. Did you, or I can state the evidence. Yeah, do 5.
Stamping stuff. I'm just trying to see what he's doing. Did he dismiss the jury for the day or just a few minutes? Sorry, I would have to ask if I didn't mute it. But there's so much noise in that courtroom. I don't know the answer to your question, Memento. I can see it underway. Do you know, Brian, if it stays forever?
There's one for the state, one for the defense.
Don't know.
I can see it not mattering because they're not here. I can see it mattering because it matters. So, I mean, I don't know.
This courtroom has a mic for everything in the courtroom. Has a mic for their stapler, has a mic for the person turning the pages. There's mics for their mics.
And it's really loud. And that defense attorney can't find one of them, which is why it's so loud. Because he keeps walking away. And they keep having to turn it up. It's all that background noise. I can't hear like anything. Yeah, I don't know if that lasts. I don't know what that woman's gonna, the woman attorney, whatever her name was, I don't remember. I kind of agree that it won't affect them negatively or positively because I think everybody was lost on what he was doing. When he finally, like I said, when he finally got there, if Doug doesn't follow directions, does he? He contacted her after he was told not to. And then he got away from it. All right, Bri. All right, here's an answer to your question, Memento Mori. The court held that just as the attorney-client privilege itself survives the, I'm going to say, passing of the client for whose benefit the privilege exists. The right to waive that privilege in the interest of the deceased client's estate also survives and may be exercised by the decedent's personal representative. So it can go either way, then, is what I'm taking from that. Is that how you see that, Brian?
Yeah, I think the attorney-client privilege remains after being unalived, but the representative of the unalived estate can waive it.
Yeah, that's how I understood that. Yeah. Thank you for looking that up. I appreciate it. Yeah, we're not attorneys, but we we sometimes can find the answers. Sometimes I look for days and never find it. All right, well, I wonder what we're going to do next, because we certainly have not gotten through 8 witnesses like they said they were going to today.
Yeah, they say they're going to have 2 doctors. They've got 2
Yeah.
doctors supposedly this afternoon.
Yeah, they said after lunch. Well, a little after lunch. So, because I think they have 2 officers to call before the 2 doctors, they said.
That's true.
So, yeah, we're not getting through 8 today.
Well, they should have known. They had a lawyer on the stand. They should have known that what was going to happen.
Yes.
You can't do a lawyer in under a day.
Like, she's going to answer all your questions just fine. But then when he gets up to ask you anything, she's not going to. And she didn't. And she tried to narrate. I guess she really just tried to narrate the whole time. I think she likes to be in control. That's just my personal opinion.
Well, that's just a lawyer thing.
Yes, it is. And there was a lot of ego going around in that room.
A lot of lawyer things going on there.
Yes. All right, well, let's see who's up.
Chris Gillum.
All right, definitely
You
not.
saw this for affirming testimony about to give you the truth, the whole truth, and nothing but the truth.
I do.
The lefty. He must be smart.
I can't hear you, Brian. What'd you say?
I said he's a lefty. He must be smart.
My daughter's a lefty, and she has a horrible time with training with firearms. See what he thinks 15 inches is. Sorry.
It's a lie.
Overextended.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
22 years.
And did you work somewhere else before for several years? How many years?
Yes, City of Palmetto Police Department for 12 years.
Okay. And what position do you currently hold at Manatee?
I am currently a domestic violence investigator.
And how long have you been in that unit?
12 years.
How, I said in that unit, but if you could just describe, does Manatee County Sheriff's Office have a unit for domestic violence?
Yes, we do. We have 4 detectives.
Okay. And where and how is that unit housed?
We are housed at our building is the 3500 block of 9th Street West is the actual address. And within our building, it's my unit and the Crimes Against Children detectives as well.
Okay. Were you in that same position back in 2017 to 2020?
Yes, I was.
Okay. Back then, did your department house child protection services?
Yes, at that time we did.
Okay. And explain that. Were they with you in the same area, or how did that work?
No, they were on the other side of the building. We had our own area and they were on the completely opposite side of the building.
And were they actually employees of the sheriff's office?
Yes.
Okay. Did you do a lot of stuff with them together? A lot of investigations together?
The domestic violence unit, we did not. Every so often, that was mostly the Crimes Against Children detectives that worked with them.
And as a domestic violence detective, have you investigated violations of injunctions and that type of thing?
I certainly have.
Okay. Now, sometimes when someone is asking for an injunction, or when an injunction is violated, it can be charged criminally, correct?
Correct.
Okay. Or they can take other avenues to address the violation. But you're not involved in that other avenue if it's a different court, correct?
Yes, I'm not involved in that.
All right. Did you become familiar at some point with someone named Ashley Benefield?
I did.
And when was that?
December of 2017.
Okay. Generally, what were the circumstances without it getting into a lot of detail?
She reported that her husband violated an injunction that was in place out of South Carolina.
Okay. And that came to you?
Correct.
Right. And we've heard several mentionings of poisoning. Did this have to do with the same issue?
It was the same case, yes, but I had nothing to do with that investigation.
Okay. So the poisoning itself, you didn't have any contact with. It was just the violation of injunction.
Correct.
Okay. Did you speak to Ashley?
I did.
How many times would you say you spoke to Ashley?
I think a fair number would be 30 to 40.
Okay. And generally speaking, was that because you were contacting her or she was contacting you?
No, she started contacting me on a regular basis beginning around February of 2018.
Okay. And what was she contacting you about?
She was wanting to know the status of the case and when Doug would be getting arrested for the violation of the injunction.
Okay. And when you do a violation of injunction, when you're investigating a violation of injunction, you can do several things, correct? You can, well, explain what you can do with it.
We can make a physical arrest in the case. There could be no charges filed in the case, or we can send the case to the state attorney's office.
Okay. So if you send the case to the state attorney's office, what does that mean?
We're just letting them make the ultimate decision if they think there's enough for charges to be filed in this case.
Okay. So it sounds like there's no charges and then arrest and.
Sustained.
So you said Ms. Benefield was calling you asking about the arrest of Mr. Benefield.
Yes.
Okay. And what did you tell her?
That the case was still suspended at that point, and when I had an answer for her, I would let her know.
Okay. And so that was the beginning of your conversations,
Yes.
right? So, did she continue to call
Yes, repeatedly, twice a week at least.
and speak to you personally?
Yes.
And what was her comments? What were her concerns?
It was the same thing. When was Doug going to be arrested for violating the injunction?
Had you ever told her that he was going to be arrested?
I did not.
Okay. At some point, did you decide to forward the charges?
I did.
And is that to the state attorney's office like we talked about?
Yes, it is.
Okay. Did you inform her of that?
I sure did.
Okay. And what was her reaction to that?
She was upset that he was not being arrested.
Okay. Were you able to explain to her that the process and how this was going to go?
Sustained.
Were you able to explain the process to her?
Yes, I was.
Okay. And how did she take that?
She was not happy that I was not placing Doug under arrest.
Okay. At some point, did you speak to Ashley Benefield again? And she told you about a court hearing?
Yes.
Okay. Approximately when was that conversation?
Around the first week of May 2018.
May 2018. And what did she say?
She just got right into the phone call and requested that I arrest Doug for a hearing that was coming up in Manatee County.
Okay, you just said arrest for a hearing.
Yes.
But arrest at a hearing?
Yes, that there was a upcoming hearing in Manatee County.
Okay. And was that hearing involving your case or something else?
It was something else. It was not my case.
Okay. Did you know that there was a hearing or there was even a court issue going on?
I did not.
So she told you there was a court hearing, and did she tell you when it was?
No, that just shows there was an upcoming hearing, and she asked for me to arrest Doug when he came inside the courtroom in front of the presiding judge.
Okay. And what was your reaction to that?
That absolutely would not occur.
Okay. And how did she take that?
She was upset. And at that point, I would call it a dramatic cry, hysterical cry started happening. And I'm still informing her, we're not going to do that. We're just not going to arrest him in the courtroom. And she made a comment, something to the effect of, if the judge sees you arrest him, this will help me keep my baby. So I thought that was a pretty bold statement. And I'm like, I'm still trying to give her the benefit of the doubt. She just gave birth. Maybe she's confused. And I'm trying to explain to her gently, that's just not going to happen, especially not going to happen for a judge to see to help you in a civil matter.
And did you in fact explain all that to her?
Yes, I did.
And how did she react?
We went back and forth 5 minutes or so. Her just kept requesting to arrest him. I said, this is not going to happen. And her tone turned from the crying to very aggressive. And she says, you will effing arrest him in front of the judge and I will make sure you do it.
What did you say to that?
I started pushing back a little bit and I said, it's not going to happen. Whatever you say or do, you cannot make me arrest somebody in front of a judge, and it's just not going to happen.
And what did she do?
I guess she started crying again and came out with a comment, something like, I can't believe you're willing to allow Doug to kill me and the baby.
Okay.
And that hadn't come up in this phone call. That the phone call dealt with me arresting Doug in front of a judge. And then it turned to arresting, or not arresting him, and allowing me to let him kill her and the baby.
Okay. So that seemed kind of different to you?
Yes.
Than what you had previously been doing?
Yes.
Okay. How long did this conversation go on?
20 to 30 minutes.
Okay.
For up to that time, it's probably 20 to 30 minutes.
Okay. And during this time, excuse me, did the defendant ever seem to understand the process of what you were saying?
No.
And at some point, did she change from crying again?
She did.
What did she do?
It just abruptly changed and she let out like a screech or a high-pitched scream. And she says, I'll do whatever I have to do to kill my baby or keep my baby, you a-hole.
Okay. So it's a high-pitched scream, or did you say scream or screech?
Like a screech at first, but it was I'll call it a screech.
A screech.
Yeah.
And tell me, what volume is this?
I could just say it's a very loud, maybe top of lung type scream.
Okay. Could you demonstrate to us?
It's impossible. There's no way I could.
Why would it be impossible?
I couldn't get my voice that high. There's no way.
So it was loud.
Brian, can you do it? Can you get your voice that high? You did yesterday.
Not today.
Well, I had to ask.
Doesn't hurt to ask.
We want the squeaky lettuce. We want
And it
the
was
squeaky
high.
lettuce.
Yes.
And she said, can you repeat what she said?
I will do anything I have to keep my baby, you a-hole.
You a-hole. And did she say a-hole?
No, she said the full word.
Okay. And after she said that, what'd she do?
At that point, I had checked out of the phone call and I was pretty much ready to hang up the phone on her. And she accused me of conspiring with Doug to get her baby taken away.
And had you even spoken to Doug about custody of the child?
No.
Okay. Were there other detectives around you at the time of this phone call?
Yes, there were two other detectives.
And do you recall their names?
Oh, yes. Detective Patricia Hetrick and Detective Brian Moreland.
And did they appear to recognize that you were on a difficult call?
Oh, they did. And at one point, Brian even asked me if I needed some help.
It's the same.
And at some point, how did the phone call end?
Miss Benefield terminated the phone call.
And you seem to have a good memory of this call.
Yes.
And why do you have a good memory of this call?
Because in my 12 years of doing this, I've never had anybody ask me to arrest someone in front of a judge inside of a courtroom. Now, I have had people call me before and say somebody may be appearing in court that I'm looking for so I can arrest them, but I've never had somebody say, wait until he's inside the courtroom in front of the judge.
Thank you. No further questions.
Cross?
Just a moment, Your Honor. Afternoon, Detective Gillum.
Good afternoon, sir.
I want to ask you a few questions about report writing.
Sure.
Do they teach that to you in police academy?
Sure. Back in 1989, they did, yes.
Okay. It's obviously an important part of police work.
Sure.
How many cases would you say could you average that you handle in a month?
20.
Okay. And over the course of a year, we're talking about
300 closed.
So are you familiar with the saying that they give you in police academy, if it's not in the report, it didn't happen?
I've heard that before, yes.
All right. And that's because the report is obviously more reliable than your memory.
I could understand that, yes.
All right. At 20 cases a month, 2.5 years later, you're into like 600 cases. If you got your report, you can refresh your recollection rather than have to recall off the top of your head.
Sure.
Which is why you want to put critical details in your report, because that's what you want to remember.
Correct.
Not necessarily that somebody had on mismatching socks, but that they had something that's significant to the investigation.
Sure.
All right. So your initial involvement, you told us in the case, is speaking with Ashley Benefield on or about May 31st of 2018 regarding the domestic violence injunction in South Carolina.
That wasn't the first time I spoke with her, no. There were several incidents I spoke several times I did.
Did you speak with her on or about the 31st of
I was
May?
prior to that.
Okay, about the South Carolina injunction.
Yes.
All right. And just to be clear, we're talking about the same thing. There was a court that had issued an injunction in South Carolina, stay away from one another.
Yes, in South Carolina, that is correct, sir.
Okay. Now, at some point, did you bring any of the reports that you wrote with you here today?
I did.
Do you recall how many you wrote?
Supplemental reports, 3 or 4.
Yes. All right. So initially, if I can ask you about the sequence of these events, Ms. Benefield had gone down to the Manatee County Sheriff's Office to complain about a package that she received because it came while the South Carolina injunction was in effect.
Yes.
All right. And it would have been Deputy Wesley Weber, to your knowledge, had requested a capias based upon Ms. Benefield's receipt of that package.
Correct.
Just so the ladies and gentlemen of the jury understand, a capias is an arrest warrant.
It's testifying and it's all hearsay.
What is a capias?
A capias is information where a deputy believes that there's probable cause for someone's arrest.
All right. And that was issued by Deputy Wesley Weber.
Correct.
And that would have been on December 14th of 2017.
That sounds correct.
Now, a month later, well, actually, several months later, on May 31st of 2018,
Objection, Judge. I called for hearsay, but I apologize. I'll let him finish the question.
did you write the first of your supplemental reports?
Yes.
And in that report, you stated that Ms. Benefield,
Objection. Hearsay.
Sustained.
in the report, did you indicate
Objection, hearsay.
Sustained.
Did you write anything in your report in describing?
Objection, hearsay.
Can you approach, please?
Hold on, let me have one more shot at it. Did you document in your report anything different than you told us here today about how you characterized Miss Benefield's demeanor?
I didn't go into any details in that supplement at all, in that one.
May I show him the report?
Judge, can we?
Yes.
He doesn't seem to have as much of an attitude with the defense attorney as he did the prosecutor. I thought he was just kind of side-eyeing her. But maybe not.
So she was acting like such a maniac on the phone, and he didn't write it in a report.
Yeah, I didn't describe it. I didn't do anything.
That's why I'm not believing him.
I don't.
Maniac on the floor.
Who's talking?
Copyright strike.
Yeah, thanks, Gabby. I got another one.
Wah, wah, wah.
Yeah, I don't believe him. Yep. I agree, George. Because I'm not buying. And then, oh yes, there was 2 other detectives there. I remember it well. Like, why would you remember it? I don't, it's like, it's not hard for me to believe that somebody would ask somebody to arrest somebody in court. They know they're there. So why is that? He acts like that's just a weird thing. Oh, 100%, George.
During that time, Detective Gilliam, back in May of 2018, you overrode Deputy Wesley Weber's capious request, correct?
I did.
Okay. And you put the case on an inactive status.
Yes.
And I think you decided, as you told us, it would be submitted to the state attorney's office.
That is correct.
Now, on June 5th of 2018, you interviewed Douglas Benefield, did you not?
Correct.
And he admitted to you.
Objection, hearsay.
Sustained.
What was his position with respect when you asked him?
Objection, hearsay.
Finish the question.
Did you send the package to Miss Benefield?
Sustained.
Did you make a determination from your conversation with Mr. Benefield whether or not package had been sent to Miss Benefield?
Objection, relevant.
Can you ask the question again, please?
Sure. Did you make a determination as a result of your investigation whether a package had been sent to Miss Benefield?
Yes.
Did you make a determination as to who sent it?
Yes.
Who?
Douglas Benefield.
Did you make a determination of what the contents of the package were?
It was a T-set.
And was hazmat called?
Objection, Judge. Hearsay.
Sustained.
As part,
Did you say hazmat?
yes, sir. As part of your investigation, did you make any determination whether or not there was a response by
Objection, hearsay.
any other agency to this package that was sent to Miss Benefield?
Objection, hearsay.
Overruled.
Sustained.
It was part of his investigation.
Did you
I'm
tell
not understanding this either.
Mr. Benefield that you would be able to unfound the case if he sent you the receipt? I'm asking him if he told Mr. Benefield.
Can you please approach?
Did you tell Mr. Benefield?
Can you please approach? Can you please approach
Oh,
the bench?
sorry.
Approach. I don't get. I don't get. If it's in his report, the hearsay rule kind of always it confuses me sometimes because if it's in his report, why is it hearsay? He wrote it.
Yeah, he discovered that as part of his investigation.
Yes. So why
And
is that hearsay?
that kind of stuff is yeah, people tell you shit. That's why it gets in your investigation.
Yeah. So I mean,
not-
she's obviously winning.
He's not saying, yeah, so and so told me this, that, and the other thing. He's saying I found out in my investigation. So
Yes. And
But-
I don't get it. Also, her blonde streak is back in force all of a sudden. I couldn't see it earlier.
And then this here,
She had it
this last
re-dyed
one,
during the break.
this last one, he's asking him what he told somebody. That's not hearsay. That's what he did.
Yeah. Yeah, I don't get it. I have only been called once, and I just moved out of the county that called me, so they were like, nope. I've never been called again. My county doesn't have very many trials. All you have to do on a jury is look for lies. Any lie should render the witness null and void. Shifty witnesses, evasive witnesses, all bad. Most of the times it's cops telling porkies. Thanks, George.
That's great insight, George. I agree.
George is a class act.
He got me. Got me in the end.
Keep it classy, George.
It's proof her heart has been Oh my gosh, it's so wild.
I think the last question I asked you was, did you tell Douglas Benefield you could unfound the case if he sent you the receipt for the sending of this package of tea?
No.
So did you write a supplemental report as a result of this interview with Mr. Benefield?
Yes.
And this would have been on June 5th of 2018.
That's correct.
Now, did you put and document in that report anything about Miss Benefield?
I would have to look. If you don't mind, I can certainly.
Please.
Christy, I'm just mad that now you have that song going through my head. I want to let it go. And never to return to my head. You know, most cops can hide that they don't want to come to court, but this guy doesn't. He's like, I hate my life right now.
No, I don't see anything about Miss Benefield in this supplement.
Okay, you did determine, though, that the package, once you got the receipt, you determined the date the package was sent.
Yes.
And that was on when?
November 27th, which is when the injunction was signed off on by the judge. It was the
Yeah.
same day.
But you also determined that the hearing on the injunction was November 3rd, 2007.
That was the hearing, but the judge did not sign off on this until the 27th, which was the same day. So,
Right. But at the hearing, Mr. Benefield was present when the judge announced.
yes, when he announced, but it was
Okay.
my understanding it's not in effect until the judge granted his signature on the 27th, which is the same day that Mr. Benefield sent out that TSET.
Okay. Who is the lead detective in this case?
For which case?
For the homicide case?
I'm not sure.
Is it Detective Warren?
I don't know.
Do you recall contacting Detective Warren on November 30th, 2020 at 7:47 a.m.?
I do remember contacting him. I'm not sure if that's the date, but yes, I did.
Okay. And do you now recall that Detective Warren is the lead homicide investigator?
I'm not sure if he was the lead. I know that he was at that scene, but I'm not sure if he's the lead investigator.
Okay, so you talked to Detective Warren on that day?
Yes.
All right. You then, 16 days later, Detective wrote another supplementary report, correct?
I'm not sure if it was 16 days later. I would have to.
Why don't you take a look and see if that report isn't 16 days following your contact with Detective Warren.
And when did you say I contacted Detective Warren?
You contacted Detective Warren on September 30th, 2020 at 7:47 a.m.
Yes, I entered a supplement on October 15th of 2020.
Okay. Now, following your conversation with Detective Warren on that day, September 30th, 2020 at 7:47 a.m. in the morning, you write a third supplement, do you not?
Correct.
And it's dated October 15th, 2020.
That is correct.
16 days after speaking with Detective Warren.
That is correct.
In that supplement, you list, do you not, the details of what you described today about how Miss Benefield behaved.
That's correct.
So let's make sure we understand this now. This is 2.5 years following the discussion that you related to the ladies and gentlemen of the jury of Miss Benefield's response. 2.5 years later, you remember the details of the conversation.
Absolutely.
And exactly what she said. Quotes, you quote her.
Yes.
But you never mention one word of it in your supplement that you wrote on June 5th of 2018.
You are absolutely correct.
Nothing further. Let me just check. Okay, that's all. Thank you. You go ahead.
Why didn't you add that information to your supplement back in 2018?
In my initial supplement, which was May 31st, I did put in that supplement that she demanded an arrest be made in the courtroom when he appeared. At the time of my interaction with her, I didn't see anything she said at that time as a direct threat to Doug. It had no relevance to my case. I saw this as her just having this massive meltdown because she wasn't getting her way with me. So at that point, it was just not relevant for my case. There was no reason, but circumstances have changed. I thought that's information that needed to be heard.
Okay. So, and what circumstances?
Obviously, Mr. Benefield is deceased at this time. Okay. And her words at that time may have had an entirely different meaning. I did not take it as a threat. I took her saying that I'll do whatever I have to do to keep my baby, you a-hole, as my manipulation attempt for the court system. Not that she was going to create any harm to Mr. Benefield. Now, she never mentioned anything like that. She was never any threats. But I just took that as a manipulation attempt. When she wasn't getting her way with me, it was a meltdown. And there was just no reason for me to put that in my supplement that she was having this massive meltdown because I wasn't going to buy into it.
And so after she murders Doug Benefield, you thought it was relevant, obviously.
I thought that was very relevant information that needed to be heard.
And did you reach out to someone about that?
I did.
Or did they reach out to you?
I reached out to him.
You reached out to Detective Warren, correct?
Yes.
Okay. Thank you. No further questions.
Did Detective Warren direct you to write this up?
Absolutely not. I wouldn't take orders from him to begin with.
And 2.5 years later, you remember that she said specific things. This will help me keep my baby if the judge sees you arrested, quote unquote.
Yes, because it's a very, very bizarre comment I've never heard before in my career.
That's like 600 something cases later.
That's fair.
That's all.
Okay, can you be released from the subpoena?
Yes.
Sir, you're released from the subpoena, you're free to go.
Thank you, sir.
No, I'm sorry, Judge. Sorry.
Detective Gillen. Hold on. Sir, you have not been released from your subpoena. The rule of sequestration has been invoked by the attorney. That means that you cannot discuss with anyone your testimony here today, the questions that were asked of you. With the attorneys, parties, anyone else. You can't talk with other witnesses about their testimony or the questions that were asked of them. You can't watch any of the proceedings that may be online. You are still sequestered pursuant to your subpoena.
Yes, sir.
State.
All right, now comes Detective Moreland. I don't know about that dude. I thought he seemed a little bit more honest with the defense, but I didn't buy what he was saying. I don't know. But I think now we're getting the detective who he wouldn't take orders from anyway. It's like, excuse him.
I can't wait till those two meet again.
I
What do you mean
know.
you wouldn't take orders from me? Why? You think you're better than me?
And he said it so like,
At least
give me a break.
I filled out my reports properly.
I didn't make stuff up and put it in there. Oh yeah, I remembered that. It was just so odd. I remember it all these years later. Sure. It's like I've had people say odd things to me and I don't know. I couldn't tell you when and where they said it. All right. See what 12 to 15 inches looks like for him. Ah, Gabby must be busy. She didn't say he's lying. Oh, sorry.
Moreland.
And we've had some testimony about a Judge Moreland. I just want to make it clear. Is there any relation between you and Judge Moreland?
No, ma'am.
Okay.
We're the same person.
What is your employer?
Manatee County Sheriff's Office.
How long have you been there?
Since 2004.
What is your current position with them?
I'm a crimes against children detective.
How long have you done that job?
Since January 2011.
And crimes against children, is it known by an acronym?
CAC.
CAC. Okay. So if you hear CAC detective, that's what we're talking about.
That's correct.
All right. So you've worked in that capacity for several years. So you were working in that capacity between 2017 and 2019?
Yes, ma'am.
Okay. What does the CAC unit investigate?
Any crime that involves a child, any crime against a child, I should say. Sexual abuse, physical abuse, malnourishment cases, things of that nature.
And we heard that your office, you share an office space with other departments?
Yes.
And what are those?
The domestic violence unit is also in our office.
Okay. And back then, 2017 through 19, there was another entity in there with you. The child protection services, were they in your?
Oh, I'm sorry. Yes, DCF was in there.
DCF. Okay. I apologize. The letters have changed over the years. So.
Obviously, yes.
All right. Did you do a lot of investigations alongside specifically DCF or Child Protection Services, what I call it?
So being in a crimes against children unit, we often work very closely with other agencies, DCF especially. My job as a law enforcement agent is to investigate crimes, basically. The child protection investigators, their job is to protect the children and offer services when needed.
Okay. So they have different goals.
Correct.
All right. When there's an allegation of child abuse, just generally, what is the protocol? To who investigates, who gets the information? Like, how does that go?
Generally, a report will come through the abuse hotline. Law enforcement gets notified, and DCF or child protection investigator will get notified, assign the case, and go out. We usually do that in tandem. Okay. So we're all there at the same time, and like we said before, different goals.
Different goals, but you're there at the same time, typically. Okay. And sometimes reports can come in, someone can just walk into the station, correct?
Oh, yeah.
Or call or do something like that with the sheriff.
And if we get it first, then that deputy, whoever's writing that report, contact the abuse hotline.
Okay. So I want to talk about, well, first let me ask you about Detective Gillen. So you said you're with the domestic violence unit.
That's right.
Do you know Detective Gillen?
I do.
Have you worked side by side or at least in the same space?
We've worked in the same office for many years, yes.
Okay. And he just testified about a phone call that he had that he remembers quite well.
Yes.
Do you recall him having a interesting phone call?
I remember the phone call. Yes.
Okay. Were you sitting there?
We shared a cubicle wall, so we couldn't actually physically see each other, but we could hear, obviously, everything that was going on.
Okay. And did this seem like a typical phone call that he?
He seemed quite exasperated at the end of that phone call.
Okay. At the time, did you know who Ashley Benefield was?
Yes.
Did you later become involved with Ashley Benefield with reference to CAC?
Yes.
Okay. And around December 2019, were there several investigations that came in, started a series of several investigations that came into your department?
Yes.
Okay. So I want to ask you about the first report or the first investigation. Mm-hmm. About when was that?
Can I refer to my report?
Sure. Go right ahead.
December 10th, 2019.
Okay. And generally speaking, what was the complaint?
Judge, based on prior motions and we.
Yes, sir. I understand. Oh, go ahead.
Thanks, sir. This investigation involved allegations of sexual abuse.
Okay. So sexual abuse, obviously of a child.
Yes, ma'am.
And who was the child?
Emerson Canny.
And who was the complaint against?
Douglas Benefield.
Objection. Oh, I'm sorry, withdrawn.
Is it the same objection?
No, withdrawn.
Go ahead.
So did you get assigned to the case?
Yes, ma'am.
Right. And so just as a matter of procedure, when you initially, when Manatee County Sheriff's Office gets a case, you're not initially assigned right away, right?
No.
What happens before you get
Generally, what happens in cases like this is, however we receive the report, whether it be through the hotline, whether it gets reported directly to the sheriff's office, a uniformed deputy along with a child protection investigator will go out to the scene. The uniformed officer will normally write the information down in a report, and that information gets filtered through our supervision. And if it needs to be assigned, it's assigned.
Okay. So theoretically, on this particular complaint, there had been some work done before you got it.
That's correct.
Okay. And then did you continue that investigation?
Yes, ma'am.
And as part of that investigation, was Emerson sent to the child protection team?
Yes, ma'am.
And what is the child protection team?
The child protection team is a state-funded team that, for
Same objection, Your Honor.
Sustain.
for my criminal investigations. Oh, I'm sorry. Sustain.
Next question.
Okay. Did you talk to Douglas Benefield?
Yes, ma'am.
Okay. Did you also speak to Ashley Benefield?
I don't recall if I spoke with Ashley on that particular case. I believe she was interviewed already.
Okay. And what did you do with the case? Were any charges filed?
No, ma'am.
Okay. So I want to talk to you about the second report, and that was what date?
Report date was March 21st, 2020.
Okay.
March 21st.
2020.
Generally speaking, what was that allegation?
That was a physical abuse allegation.
Okay. Physical abuse against,
Douglas Benefield.
and the victim of that would have been?
Emerson.
Okay, same parties.
Mm-hmm.
And how old was Emerson at the time, approximately?
2 years old.
And again, the same question, had some things been done before you got the case?
Yes, ma'am.
All right. Did you continue that investigation?
I did.
And at some point, did a second complaint come in before you were finished?
On the 23rd of, so March 23rd, 2020. Yes.
Okay, so a couple days later.
Mm-hmm.
And what was this complaint?
It was, again, physical abuse.
Different than what came in a few days before?
Yes.
Okay. Did you investigate those two things together?
I put them in the same report. Yes.
Okay. And what did you do with those cases?
No charges were filed.
And I'd like to talk to you about the third report. When did that come to MSO, or when did you get it?
April 5th, 2020.
Okay. And generally speaking, what was that allegation?
Physical abuse.
Of Emerson?
Yeah.
And by Doug
Douglas.
Benefield?
Yes.
And once again, before it was over, did you get another complaint?
On the 27th, another deputy responded.
Okay. And what was that complaint?
Again, physical abuse.
Same parties?
Yes.
Did you again investigate those two case numbers together?
Yes.
And what did you do with those cases?
No charges were filed.
At some point, were you a part of what's called a staffing?
Yes.
And what is a staffing?
A staffing is when the entities, as I mentioned before, come together and try to find a good way, or moving forward, a good way to protect the child.
Okay. And did you attend a staffing on this particular case?
The Plethora.
The Benefield,
Yes.
yes. And as a result of that, Were Ashley and Doug assigned to go to therapy with Dr. Broder, or not therapy, an evaluation with Dr. Broder?
Yes, ma'am.
Okay. Thank you. No further questions.
Cross?
Yes. Just a few questions for you, Detective Moore. The cases that you referred to, I think you said there were 5 of them.
Yes, sir.
I don't want any details.
Okay.
Those cases have to be reported, correct?
Yes.
That's how they're initiated.
That's correct.
And would it be safe to say that in this case, the reporters, without any names, the reporters were...
Objection calls for hearsay.
Go ahead, finish your question.
Reporters were not all the same.
That I wouldn't know. I'd have to go look.
Do you have the reports with you?
I do have.
I don't know what happened. That's not me. That's them. Why did that jump? Weird. Let me make sure that it jumped.
There was an
'Cause
Australian involved there.
I didn't touch it. Jodie, is that
Actually
you?
assigned right away, right?
No.
What?
All right, you guys. No.
I thought that's information that needed to be heard.
Okay. So between 2017, 2019?
Yes, ma'am.
Okay.
Sorry.
10th, 2019.
I don't know if it jumped.
Okay. And generally speaking, what was the complaint?
Judge.
So it appears the report on 12/10/2019.
I just want to, because we're in a bit of a delicate area, Detective, I just want to establish whether or not, if in reviewing your reports, you're able to tell us if the reports were initiated by different individuals.
By looking at my reports, I cannot tell you that indefinitely.
Did you at any time personally interview Ashley Benefield?
I may have. I don't recall if I ever interviewed Ashley. I know I interviewed Douglas quite often. Initially, when I get these cases, the interviews with her were already completed. So.
Did you at any time personally interview the child?
No.
I don't believe I have anything else. Let me just check, Your Honor.
I believe you said, with respect to did you interview Ashley, that you said by the time it gets to you, a lot of times those interviews have been done.
That's correct.
And that would be by who?
Uniform.
Uniform. And then he asked, did you interview the child? Do you normally interview children?
No.
What is the protocol for children?
Forensic interviews are done by child protection team.
Okay. And so generally speaking, you wouldn't say you interviewed children?
No.
And was this child of an age to be interviewed anyway?
No.
Okay. No further questions.
Sir?
That's all.
Can this witness be released?
I'm sorry.
Can this witness
Yes.
be released?
Sorry.
Mr. Taylor, can this witness be released?
Yes.
Sir, you're hereby releasing your subpoena. You're free to go. Thank you. Thank you. All right, members of the jury, we came back early. We went to an early lunch, so we got back a little bit early. It's now, I think, a good time to take our mid-afternoon break. It is about 2:50. So how about if we take, we'll probably end up being about 15 or 20 minutes. So you can go back in the jury room. You're free to use your phones. If you need to send or receive texts or emails or phone calls, just don't talk with anybody about the case amongst yourselves or anyone else. And of course, as we discussed, don't do any research on the people, places, things, or legal topics you've heard anything about. Stretch those legs, and we'll see you back in a little bit. All right. Jury out. You have a seat. State looking at the list in front of me. 1, 2, 3, 4, 5 more on the list.
Yes. 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 I have a question about that.
Yes.
So we've had Dr. Vega kind of on hold. And so I don't know how far we'll get with these next 3 witnesses. I could have him come here, but my question would be is if it was gonna take us past 5, if he comes, do we still do it? Because he's very busy and I need to take up so much of his time. Or would Your Honor rather, because I know we wanted to deal with some other things, would you rather me tell him first thing in the morning? I know you don't know how long these witnesses are gonna come, take.
I can tell the court that Dr. Broder is going to be up there for a while.
And so my question is, if I have him come, can we deal with him today? Or do you think once we hit 5 o'clock, if it's beforehand, you're gonna wanna go home? Which I understand either way.
Yeah, I would imagine that if it starts pushing 5 o'clock, we'll probably break and start again tomorrow.
Yes, sir. Okay. Okay, that's the schedule, that's all I have.
Okay.
I do have something else, if you don't mind, not as scheduling. So the clerk was kind enough to unseal your order, but the items that were attached are evidently in that room locked up. And so I just don't know how we could get a copy because I haven't seen them. And so I just want to address it with the court of how to get a copy.
The evidence clerk is making copies.
Oh, good. Perfect, thank you. Thank you, Judge. Thank you.
All right, anything before the break?
Right.
Yes.
These closed captionings. I'm gonna hurt them. They won't move. So, I wonder if they're finishing tomorrow still. Have 2 long witnesses. I don't know if we're gonna get this done by Friday.
That cat detective was horrible.
Yeah, what's his job? Do you interview
Did he do
kids?
anything?
No. Do you interview the accused? No. Do you interview the accuser? Well, somebody else did that. Like, what's your job?
Do you know who made the complaints? No.
No. What is your job? Are you just in one of those positions where they just pay you to be there? I didn't get it either.
I buy nice ties. for court.
I'm a nice guy. I mean, I don't know. But I do kind of feel sorry for these doctors, because if I was a patient of these guys and they had to cancel my appointment and then they didn't even go to court that day and they had to cancel more appointments, I wouldn't like it. It takes so long to get in to see them sometimes.
Oh yeah.
Like, I have one I have to see every 6 months. And she moved my appointment. I was like a month out. She moved it. Like, nah, that's okay. I have nothing to do and I can't schedule around it because I won't be able to see you for another 6 months.
Yeah. Well, after my visit, I go out to the front desk. They say, okay, let's schedule your next appointment. And they give me a date and a time. And they go, is that okay with you? And I don't even look. I'm just like, yeah.
Sure. Yeah, I'll make it work.
It's good until it's not, because I know 3 days before you're going to call me and say, oh, we need to reschedule your appointment.
Yep. Yep.
It's a good thing I like all of my doctors so much.
And I like all of mine, and I understand her schedule. She has 2 small children. I understand. She went from, I used to be her first appointment in the morning at 6:45. Then she doesn't do mornings anymore. She went to afternoons. But because she had rescheduled, now I'm back in the morning.
Well,
and
I
it's
just
at 9.
I recently
it's
went to
normal
my
time.
annual cardiology appointment, which got postponed a month. I was like, oh, they're busy. But when the cardiologist walked into the room with a deep, dark tan, I was like, where the hell were you last month?
Well, let me tell you, there was a nice beach involved, and it was great. And it was warm. I gotta move my fan. It's blowing all my little fine hairs all over my face. It's driving me nuts. Yeah, I don't know. They seem to, I like that. Seems to be most government employees just paid to be there. Yes, I made a little spot for you. We're just gonna call it CAC, and nobody will ask what that means. And then when you say, "Oh, it's crimes against children," nobody will ask what you do because nobody wants to hear about crimes against children. Perfect. It's perfect.
Oh, I
Yes,
got another ad.
I
Oh,
haven't
this is
touched
Mazda.
anything.
Mazda must pay good.
I've not touched that button since.
I just refreshed the page. That's why I got it.
Okay. I was gonna say
And now I got one for BritBox. They must pay good too.
because Gabby's she got one. I'm like, I didn't do anything. I haven't touched that button since before lunch. So if you're
See
getting
what's
ads,
going
it's
over on defense rest here. Refresh.
yeah, I've got it
No,
up.
still 219.
219. All right, you guys. She needs one more sub to get to 220. That's her goal for right now. Her goal is to get monetized.
I think everybody that's watching at the moment already subbed. So.
Okay. If you haven't, if you're on replay and you have not subbed to the Defense Rest, please hit that subscribe button. Doesn't cost you a thing. Not a thing. It's painless. Won't hurt you when you do it. And Jodie will be so happy after she gets some rest after her marathon stream yesterday. I couldn't believe that she made it all the way through. I could not believe it.
Yeah, well, that was, I got some education because I was always wondering why are all these Australians doing American court? But I guess because she said it's so hard for them and expensive.
Yeah. And didn't she say they only show the Supreme Court over there? I don't think they show this everyday stuff like we see.
She did say that, yeah.
And I think the UK is the same. Well, I guess probably obviously. I don't know that Canada shows any of this stuff.
Yeah, Runkle only shows. Well, I don't watch Runkle as much, but he does all United States cases. He does show some stuff from the Parliament in Canada, but no court cases that I know of.
Yeah, it's funny, and I'm not saying our justice system is perfect because it's far from it, but it's like you have all these other countries that don't show any of their trials, so you can't see what's happening over there, but everybody just rails on our system. Like, well, we can't even see what's happening in your system.
Yeah, everybody hates us, but everybody wants to come here.
Yes. Hello, Katie Cat. Yay, thank you. Jodie's going to be so happy. Thank you so much. Jodie is at 220. Grandma's great. She was visiting earlier today. Jodie is sleeping because it's very early in the morning for her. Oh, there are definitely my state is one of those states that doesn't show anything, and they could, because they passed the law where they could allow cameras in the courtroom, but they still don't. And the judge on the Delphi case was one of the judges in the pilot program to allow cameras in the courtroom and loved it, and is not allowing the cameras in the courtroom for the Delphi case. And you talk about a messed up case. That one's messed up. I don't believe they have the right guy. I think they're really just trying to get the case closed. You are too? Me too. I'm right here in that great state. The great state of no cameras in the courtroom. We'll show you. We'll show you openings. We'll show you closings. We'll show you the verdict. Who cares? I want to see what happened in between.
All right, we're back on the record. State ready?
Yes.
Fitz?
Yes.
I'm
All
gonna try
right.
to move my.
So bring in the jury.
Does she think they have the right guy? I just don't think they have the right guy. A lot of people are trying to see if they don't have the right guy. It's Simpson, I think. Right.
The transcripts for hearing is that what you were? I did.
Oh, 100%. They watched Denver.
All right, y'all can have a seat. Welcome back, everybody. Did anybody begin deliberations amongst yourselves? Talk with anybody outside the jury about anything about the case? Or do any research on people, places, things, or legal topics you bring up?
Oh my gosh. Just move.
No, sir.
Everybody says no. Call your next witness.
State House Dr. Brad Broder.
So you have to face the clerk, raise your right hand, you sworn in.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you. Oh, so, good afternoon, Judge.
My name is Joe Ryder, presiding over the case. As the deputy said, just make yourself comfortable in that chair. You want to be about 12 to 15 inches from the microphone, so you should probably scoot up just a little bit. Adjust this left, right, up, down. And just in a loud, clear voice, it should pick up everything for you, breathing, and
Fair enough.
Good afternoon.
Good afternoon.
Judge, just for the record, we renew all prior objections.
Yes, sir.
Please state your name.
Brad Stephen Broder,
How do you spell your last name?
Broeder.
What is your profession?
I'm a psychologist, clinical psychologist licensed here in the state of Florida and in New York State.
And how long have you been a clinical psychologist?
I got my PhD in clinical psychology back in December of 1986.
And when did you move to Florida? I think you said New York. You were in New York
Correct.
before.
I first practiced in New York and relocated here in the summer of 96. I was licensed here by February of 1997 and have been practicing here ever since.
Okay. And do you have your own private practice?
Exactly. I'm a solo practitioner.
Okay. Do you also do some, what I would call consulting work for the child protection team or child protective services?
Yes, I've been a consulting psychologist to the Sarasota County Child Protection Team since the summer of 1999, and several years later was hired as a consulting psychologist by Manatee Children's Services, which is their name for their child protection team. Pardon me. And recently have been contracted with the Fort Myers Child Protection Team. That's just as of this summer.
Okay. And can you just briefly explain what are your duties with reference to being a contractor for the child protection team? What do you generally do?
Well, through the Department of Health, each county in the state of Florida is supposed to have a consulting psychologist on their team. And that is for several reasons. One, it helps out with supervisory cases if on an as-needed basis, as well as once or twice a year, there's supposed to be in-service trainings where you conduct seminars, do presentations to help the staff there. But primarily it's to attend the multidisciplinary staffings, which they're asking the consultant to come in and discuss a certain case, what might be going on, if you have any kind of impressions or recommendations. Based upon those kind of meetings, then sometimes the psychologist myself would be asked to conduct an evaluation.
Okay. And ultimately, were you asked to conduct an evaluation of Doug and Ashley and Emerson Benefield?
I was specifically asked to conduct psychological evaluations on each of the parents, both Doug and Ashley, but not their child, Emerson.
Okay. The child was pretty young, correct?
2 years, 4 months to be exact, during the time I did the evaluation in the summer of 2020.
Okay. So you started the evaluation about when? You said summer, but.
I believe it was June 1st to be exact when I first met Ashley, and the next day.
Sorry, I lost my cursor. Did you say something, Brian? I could
No.
find my cursor to pause it. Okay. I thought I saw your little avatar like you were
I
talking.
might have coughed. I should put myself
Okay.
on mute.
Oh, you're
Sorry.
fine. You're fine.
Day I had met Doug for the initial intake interviews.
Okay. And what was the general goal of these interviews? You eventually were going to report back, I would assume, to the entity that hired you.
Yes, each psychological evaluation is meant to be submitting a report with diagnostic impressions and recommendations based upon the data that's been collected. The evaluation is based upon whatever the CPT recommendation was, meaning referral for the recommended evaluation. In this case, Manatee Children's Services had specific questions about each parent.
Okay. So, and your evaluation is generally focused toward the best interest of the child. Would that be a correct statement?
Yes, absolutely.
Okay. So you said you first began this around June 1st of 2020.
That's correct.
Did you ultimately complete evaluations of Doug Benefield and Ashley Benefield?
Yes, I did.
Okay. And as part of this evaluation process, did you review documents?
There's a series of steps in any thorough psychological evaluation, which includes collateral data, which is both defined as interviewing other people as well as reviewing documents. Yes.
Okay. And did you do that? You reviewed documents?
If I may, I just brought the reports along with me in case I had to refer to them. But yeah, there was
Sure.
a series of documents reviewed for each of them.
Okay, and we don't need to get into specifics about what the documents were, but you did review several documents for each of them.
I certainly did, yes.
Okay. And what is a collateral interview?
That's when I asked each person to give me a couple names of people that they think understands their situation best that I could contact and call and just do kind of a phone interview. If possible, obviously a face-to-face interview is preferable, but based upon where people are situated and located, sometimes it's just easier to have that telephone conversation. So there are certain people, like the people through Manatee Children's Services, that I was going to be speaking to. For example, Kimberly Griffin, who is the case coordinator. But in addition to that, I asked both Ashley and Doug for their own people that they'd want me to speak to. But then, of course, doing the evaluation, I have the kind of wherewithal based upon what I learned from them, if there are other people I need to speak to or that I believe I should speak to in order to get a more complete picture of the individual.
Okay. And did you, in fact, do that with reference to both of them? Speak
Yes,
to collateral contact?
Yes, I did. Yes.
Okay. Did you meet with Doug and Ashley and Emerson together or separate?
Given the structure of their family unit, I had multiple interviews with each of them individually. I had several interviews with them together, a couple of interviews with them together as the couple, but several additional interviews with them when they would exchange Emerson at my office, and when we would, kind of see how that the drop off or the exchange goes. But I had also seen each parent with the child both in their residence as well as in my office. So there were multiple interviews.
Okay. So this sounds pretty extensive. So how much time did it go on over?
Throughout the summer of 2020, I think the report was actually completed and submitted on September 14th of 2020.
So I want to speak with you about Ashley specifically. Did she ever show any hesitation about meeting you with Doug present?
No.
Okay. Did she act differently when she was with Doug meeting you, as opposed to when she was not with Doug meeting with you?
As I had indicated or described in my report, she did demonstrate or present with a different demeanor when seen together versus when I would just see her individually.
Okay. And when you saw the two of them together, did they discuss the plans for going forward? And I'm talking about moving. So did they discuss that with you?
Ashley had made it very clear that she had every intention and desire to relocate back to her home state of Maryland. Doug had the impression that this was something that he too could do because he had some connections to the Defense Department and some of the work that he did. He felt he'd have more clients up there, so he was perceiving that as he shared with me, a fresh start that they could reconcile and be together in Maryland.
And when Ashley and Doug met with you together, did Ashley indicate that this was the plan, that they were moving all together as a group?
Ashley had no intention of moving together as a group. She had every intention of moving with her mother and Emerson and becoming situated in her grandmother had passed away and the mother had inherited the house. So they had their residence established. So she had that plan.
Okay. And so I guess I wasn't being very clear. Were they moving their items together, like same U-Haul truck?
No, absolutely not.
Okay. So Ashley never told you about that?
Quite to the contrary, she made it clear that she did not want him to move in, regardless of what he thought or whatever he was planning. That was not part of the plan.
Okay. And When she was alone, she would indicate to you those things that you just described? Or
Yes,
did she indicate that when she was with Doug?
when she was with me during our individual meetings.
Okay. When she was with Doug, how was her demeanor? How was her attitude about those issues?
She would basically respond in a very deferential way. She would let him say what he wanted to say, but my focus was not so much on what their future plans were. It was, they weren't even officially divorced. My focus was, again, getting back to the point about the best interest of the child. Child protection team is, how do we get this family out of this stressful situation and then create something that's going to be better for Emerson.
Okay. Did Doug, during your joint sessions, did Doug express in front of Ashley that his hopes that moving forward this was going to be an attempt at reconciliation? Did he express that in front of Ashley?
Yes, he did.
Okay. Did Ashley ever correct him and say, whoa, wait a minute. No, we're not doing that.
Not really. I think the closest she ever got to that was to kind of say, just kind of slow it down and, we'll talk about that later. And that's, that kind of thing. She would kind of deflect attention away from that.
Okay. And did she ever say in one of her individual sessions with you, did she ever say anything to you about she was running out of time and needed to move to Maryland or something like that? Do you recall?
Yes, we had that discussion in one of the sessions.
And can you just explain what she said about that?
In essence, she was very frustrated and concerned that.
I'm not going to object to, as I understand that he's called as a fact witness and he's giving opinions.
Okay, you can answer the question. What was it that she said about the issue of running out of time and wanting to move to Maryland?
She was openly sharing with me her utter frustration with the sheriff's office, with CPT, with the court system, indirectly with myself, although she had also complimented me by thanking me for doing a quote unquote thorough job. But who was going to look out for Emerson, who was going to help Emerson, and she needed to do something. She needed this to be over with so she could get on with her life. She used the phrase, "My life is in a shambles."
Okay. And did she make any statements to you about why she needed this to be over so quickly? Or why was it, did she feel it was taking too long? I guess should be my question.
But she certainly felt it took too long and she just wanted to get on with her life.
Okay. Did she admit to you that she was in fact going to marriage counseling with Doug?
She had been in agreement with them starting with a second marriage counselor, Dr. Quintel, after their attempts at marriage counseling with Sharon Foster had not worked out.
Okay. So she indicated that their intent to go to Dr. Quintel. But during the same time, was she still saying they would not reconcile, or she was saying they did want to reconcile?
I don't think she ever used the word reconcile when with Doug. She clearly made it very clear to me that she had no intention of reconciling.
Okay. And during this time, I would say the year at least before your meeting, did Ashley talk to you about doing things with Doug? And for instance, I'm talking about lunch and activities. Did she talk to you about that?
Throughout the time that I worked with them, it was very clear they were very open, sharing with me the things that they would do together, such as, for example, the hit movie that particular summer was the sci-fi thriller Tenet, T-E-N-E-T, and they had agreed to go see that so the grandma could watch Emerson. They have a quote-unquote date. They enjoyed the movie so much, but also found it kind of confusing, hard to follow, that they agreed to see it a second time together and had a follow-up date for that movie. But in addition to that, they had done other things. She would go to Doug's apartment complex where they could use the community pool and take Emerson into the pool. They shared with me that they had gone to the beach.
She described in detail watching Doug. I think it was Father's Day specifically in my notes there, where she described how nice it was to see Doug playing with Emerson, playing in the sand with Emerson. And so then from there, they would go out to lunch or go out to dinner, sometimes with Emerson and the grandmother, sometimes without. So they were, throughout the time I was working with them, they were seeing each other.
Okay. Did Ashley ever talk to you about the birth certificate for Emerson?
Naturally, in this kind of evaluation, since it concerns a child, they talk about the child and the marriage and the relationship and see each parent with the child. So yeah, that came up. She gave birth at Tampa General Hospital and signed the birth certificate. Emerson Grace Caney.
And do you know whose name Caney is?
She wanted to keep her grandfather's family name, and so therefore she used that name.
Okay, so the child wasn't named Benefield.
Was not.
And did she ever put, or did she indicate to you whether she ever put Doug on the birth certificate as the father?
She did not. That became a point of contention for the two of them, things that they were discussing, changing the name from Emerson Grace Caney to Emerson Caney Benefield. That was an issue that they were discussing.
And did she ever admit to you that she didn't tell Doug that she was even giving birth?
She shared that she did not inform him.
Okay. And you mentioned a little while ago that she was frustrated with some of the agencies. I think you said law enforcement, the courts, that kind of a thing. Did she express why she was upset with them?
She felt that Doug was unfit to parent Emerson, that he was only using the child to get her back, to win her back, so to speak.
Okay. And these agencies, they played into that, or they didn't play into that?
What was described and came out of our discussions in the interview sessions was that she felt that no one was willing to step forward to protect Emerson, that they all got it wrong, for example. So when CPT evaluated the situation where she had bruising on the neck, she described to me that it was several days later, so the bruising didn't show up, and that went down as unsubstantiated, so it was never followed up on. And
okay, so she basically felt like they were getting it wrong. These agencies were getting it wrong.
No one was protecting Emerson. She did not agree with that.
During one of your last meetings with Ashley, did you have a conversation with her in your waiting room?
The day after, a day or two after the report was submitted on the 14th, Ashley showed up in my waiting room, unexpected, unannounced, and she wanted a copy of the report. And I had explained to her procedurally that the work product that I produce is then the property, in this case, of Manatee Children's Services, and had submitted to them. But I let her know that, she'd be able to get a copy through her attorney, but they did have to get a court order to release it. And that's usually what happens. It's kind of a formality, but it's no longer something for me to share or divulge.
Okay. And did she have a reaction to that?
Her reaction was that she felt, again, very frustrated, thwarted in her efforts. She wanted to get on with her life, and she felt, she needed to know what was going to be recommended so she could move on.
Okay. And during that conversation with her, did she say anything that that struck you as interesting during that conversation with her?
Well, she had explained previously and then repeated it then that once she was able to relocate to Maryland, she wanted to establish residence, as she had, in essence, researched it, knowing that if she had established residence for at least 6 months, she could then appeal to the authorities in Maryland to get relief and have Emerson, basically have full custody of Emerson and not that. So she had used the phrase during that conversation that she would take matters into her own hands.
Okay. And did she express to you at that time about being frustrated about the timing, things weren't going fast enough?
By that time, she was, again, ready to move on, and she was frustrated with the entire system.
Okay. And did she make any more statements to you at that time?
Not that I recall. Again, I tried to encourage her to be patient, that her attorney would definitely be able to get a copy of the report, and they could, work things out once they read the report, and they should be able to settle things.
Okay. And did she ever say what she would do if it wasn't fast enough?
No, I don't think she specified anything more than her desire to, again, get on with her life.
Okay. When was the last time that you saw Ashley? Was it that day that you're talking about?
When she came to the office unexpectedly, yes, that was the last time. Prior to that, the last time I actually saw them was, I saw Doug on September 7th, and then I believe I saw them together on the 10th of September.
Okay. And the last time that you saw them together, how did they seem? Did they seem the same as they had the times that you had seen them before?
Well, Doug too is becoming frustrated because he was viewing this as a fresh start, as I said, and
Sustained.
Okay, I'll move on. Did you complete the report for Ashley Benefield?
yes,
And how long was that report?
27 pages.
And did you do the same type of a report for Doug?
Yes,
And was it about the same length?
I think 24 pages.
Okay.
I'm sorry, 25 pages.
Okay. And I think you already explained this, but you turned your report over to CPT when?
September 14th.
September 14th. Okay. And then what happens to it after that is not in your hands.
It is, sometimes I find out, sometimes I get feedback, sometimes I don't. It's the work product goes to, in this case, Manatee Children's Services. And
okay. And did any of your evaluation or contacts give you any concern for the safety of Ashley or her child going forward?
Their original marriage therapist, Sharon Forrest, had concerns. She certainly expressed concerns, yes.
Did you have any concerns? Well, let me ask you this. Did Ashley Benefield ever say to you that Doug physically harmed her?
No.
Okay. Did she present you to you as being fearful for her own safety at the time she was having sessions with you?
Her concern was all about the safety of Emerson, not about herself.
Okay. Thank you. No other questions?
Excuse me.
Cross.
Give me just a moment, Your Honor. Dr. Broder, good afternoon.
Good afternoon, sir.
We've met before.
Yes, sir.
Your history in this case has wound its way through to where we are today, and it's encompassed prior proceedings, has it not?
Yes.
Okay.
Yes.
And you've had occasion to sit for a deposition in this case.
Yes, correct.
And you've also given previous testimony.
Twice before in the
All right.
dependency case.
Don't tell me where.
Okay.
So you've told us that Ashley would act one way when she was with you, but she would act differently when she was with Doug. Correct?
Yes, that's correct.
All right. And your conclusion that you reached was that she would appease Doug. Was that not the case?
Ashley had shared with me a number of times that she felt the best way to keep Doug at bay so he wouldn't hurt Emerson was to kind of appease him, to kind of go along with him.
Yes, in your words, I believe in your report, go along, get along.
I believe that's correct.
Correct?
Yes.
And that would be especially the case when Emerson was involved.
Yes.
All right. So, for example, if she didn't particularly want to be in
Judge, I'm gonna object. Can we approach, please?
This one, it frustrates me so much when they object. It's like, just let him ask his questions like he let you ask yours. I know they're doing their job, but it's like, what do you have to hide? What do you have to hide? I think she did everything she possibly could, and you guys all dismissed her, and now you're charging her. I don't know. I'm getting angry listening to this. Sorry, I'm trying not to. So I'm just chatting because this is hard to listen to. And I know it's hard to listen to for a lot of us in here. I don't care if you're a man or a woman, you can go through this.
I just can't believe how much or how many people have gotten on the stand and said we didn't do anything
I know.
and are proud of it.
I know. And then they charge her and they're okay with it. Like, we did nothing. Send her to prison. Like, I just am. It's hard. It's getting harder and harder to listen to. And I will be disappointed if they find her guilty at this point. Something may come in and completely change my mind, and I reserve the right to do so. But this just is awful. It's awful.
Like I said yesterday, unless somebody comes in and has a video of her lying in wait and ambushing him, I don't see myself changing my mind at this point.
Yeah. And I think what bothers me sitting here listening to this is I know there's another half out there that is saying something completely different than the majority of people in this chat are.
Yeah.
And it's like, where, why? And I don't know.
Well, and again, what we were talking about yesterday and a little bit this morning is that those people probably have every right to think the way they're thinking, because people like this hide what they're doing from everyone but the person they're doing it to.
Yep.
And there might be a little bit still, well, maybe it wasn't quite that way, but you would never know it from the investigation that these people did, because they didn't investigate anything.
Right. They just dismissed her as crazy. George, there won't be one. I believe the judge said no. He ruled against the defense bringing in a DV expert. So if I understood that right, and hopefully I didn't, but I do think that he did rule against that.
That's what I remember saying.
I don't think there's one coming in, which is sad. Sad. Oh yeah, I mean, Chrissy, there's so much going on. It's like it just triggers things. And yeah. Yep. Yeah. I can't. Yeah. You dismiss everything, you excuse everything. It's easier to make excuses for people because it keeps everybody happy. Like Ashley, yeah, she met him. If you listen to everything he said, she was always in public when she met him. That says a lot. The fact she did not want him at the birth of their child says a lot. Like, why would you just, if everything's great, why wouldn't she tell him that she was giving birth early at that? Yeah, it's sad what people like this can do to people. But every time they talk about things taking too long, or she didn't like how long it was taking, or this, that, and the other, I'm like, so she just unalived him? That doesn't make any sense. Why would she do that? Like, what was that going to get her? Besides a chair right there where she is. I don't know, Bob. They didn't show the jury selection. I did hear the defense attorney say, I thought I heard him say something yesterday or in the before they started jury selection, that there were women on the jury, that because he was worried about some information getting to them. But I'm like, you had a hand in seating the jury. It's like your best hope at this point is somebody, which I don't know how they would have got on the jury if they've been through something like this, no matter the level of severity of it. Because then they can look at it differently. They can see the information, they can see the evidence differently, I guess is what I'm trying to say. Yeah, they were alone. They were at her house, her mom's house, getting ready to pack the U-Haul to move to Maryland.
So I think you told us, Dr. Broder, that this policy of appeasement was designed by Miss Benefield to basically placate Doug Benefield.
I think I would use the word strategy. That was her idea of trying to.
Yes, to placate him. In other words, to not set him off.
She knew that she wanted to reconcile, so she wanted to kind of, I think, feed into that so he wouldn't, given her belief that he might hurt Emerson.
Okay. And you, did you decide whether or not the signs were there, but that Doug Benefield refused to recognize them? That she wanted no part of a marriage to him?
Let me make sure I understand the question. Are you saying, did I discuss with him about the signs?
No. Did you acknowledge during the course of these evaluations that the signs were there that Ms. Benefield did not want to be in this relationship with Doug Benefield, but he misinterpreted them and insisted on trying to be with her?
Unlike therapy and evaluation, you're constantly generating hypotheses, meaning asking other questions to make an assessment of the overall situation, different than a therapeutic relationship where you might be making interpretive statements and recommendations.
Let me ask you this.
Answer.
Did you consider that Ashley's position was that Doug was only interested in her and not in the child?
I certainly considered that, yes.
And that was Miss Benefield's position, was it not?
That his sole aim was to win her back, yes.
The abuse complaints, without giving me names, they were initiated by more than the same person, correct?
Correct.
In fact, there was.
Objection himself.
Finish your question.
In fact, there was at least 3 different sources.
I'll overrule. Go ahead.
I believe there were 3, correct.
And 2 of those sources were professionals.
Sustained.
She expressed to you, did she not, real frustration with the system and its responsiveness to her situation?
Yes, she did. She was very forthright.
And she told you that with respect to taking matters into her own hands, it was going to be by virtue of her going to Maryland and petitioning the authorities there.
My concern was that she was going to impulsively abscond with the child and go to Maryland and, yes, establish residence separate and apart from Doug.
Okay, that she would have access to the authorities there, that they might be more responsive.
That was her hope, her goal, yes.
All right. Are you familiar in your practice with domestic violence?
Yes.
Have you treated it before?
I've assessed it and treated it on occasion, yes.
Did Douglas Benefield, from what you learned as a result of your involvement in this case, exhibit
Objection.
Couldn't finish your question.
exhibit symptoms consistent with the domestic violence abuser?
Sustained.
Give me a minute, Your Honor.
He's still getting it out there, though. He's still getting the question out, even if he knows it's going to be sustained. That's got to leave the jury one.
I do have one other area of inquiry, if the court will allow me. Did you find anything aggressive about Ashley Benefield?
No.
Did you find that Ashley Benefield had any impulse or was prone to angry outbursts?
Well, that's 2 different things, impulsivity and angry outbursts. I did not find her to be having angry outbursts, no.
You in fact concluded she was a good mother.
Yes, I observed her many times.
That's all. We'd like to keep Dr. Broder under subpoena.
Redirect.
You're familiar with mandatory reporting laws, right?
Yes, ma'am.
And what does that mean, mandatory reporter?
The mere suspicion of any kind of abuse towards a child or an elder, as well as domestic violence, needs to be reported.
So if someone goes to their child's pediatrician, or someone comes to you as a doctor and alleges abuse, what would you have to do?
I would have to report it.
Thank you. No further questions.
All right, doctor, at this point, we're done asking questions. However, as you've heard, you remain under subpoena. The rule of sequestration has been invoked in this case by the parties, so that means you cannot discuss your testimony or the questions asked of you with anyone else,
Right.
including the attorneys.
Okay.
You can't talk with any other witnesses about what their testimony was or the questions asked of them. To the extent there may be anything online about this case, you're not to review it or watch any of it. All right, so remain available in case you need to be recalled.
Just point of clarification, remain here today or be ready for tomorrow or what?
No, so you're released for now. Just if one of the parties reaches back out to you during this trial period, you will need to report that.
Understood. Very good. Thank you.
All right, State, call your next witness.
State calls Dr. Jason Quintel.
I don't think that helped the state. I think their objections hurt them every time that the defense gets up to ask a question and they object over and over and over again. Now he's just getting the questions out. So I don't think it hurt her. I think it hurts them.
I think that one about did he exhibit symptoms of a domestic violence abuser? Objection.
Yeah.
I mean, they're not supposed to speculate, but if the answer was no, you bet they weren't going to object.
Yep. Exactly. And then she comes back and it's like, but you have to report domestic violence, right? Like, whoa, wait, we weren't talking about that.
Ramen noodles.
Now we're talking about them. Dang it, Gabby. Yeah, I thought it looked good. I thought it was good for her. We'll see what this dude has to say.
My name is Judge White. I'm presiding over this case. As the deputy may have said, just make yourself comfortable in that chair.
Okay.
You're going to end up wanting to be about 12 to 15 inches from the microphone. It adjusts up, down, left, right as you need.
Okay.
If you just speak in a loud, clear voice right into that microphone, it'll pick up everything.
Okay, great. Thank you.
Good afternoon.
Hi. Sorry, I spilled water.
Please state your name.
Dr. Jason Quintel.
How do you spell your last name?
It's Quintal.
What is your profession?
I am a mental health counselor
How long have you been a mental health counselor?
since 1998.
And where's your office?
My office is in Lakewood Ranch, off of State Road 70.
And how long have you been there?
That location we moved into in 2018. Prior to that, we were on Lena Road from 2008 on, and then prior to that, 2006.
And at some point, did you become familiar with Doug and Ashley Benefield?
Yes,
Okay. And when was this?
that would have been in 2020.
And do you recall about when in 2020 that was?
They came in for their first visit as a couple's visit on 7/15/2020.
Okay. So we heard from Dr. Broder, he was talking about his goal was to do an evaluation. What was your goal with meeting with them? Was it an evaluation or something else?
No, I was referred by another therapist to do trauma resolution treatment for both Doug and Ashley.
Okay. And as part of that, did you meet with them together as well as separate, or how did that work?
I did. I met with them originally as a couple. We ended the treatment as a couple, and then there were individual sessions in between.
Okay. I won't hold you to this, but about how many times did you see them?
So I met with Doug twice individually, Ashley 5 times individually, both of them as a couple twice. There was a total of 4 hours for couples, 10.5 hours for Ashley, and 4.5 hours for Doug.
Okay. And at the first session, did it seem to you as though, let me back up. The first session, was it together?
Yes, it was.
Okay. And during that first session, did it seem as though they wanted to work things out?
During the first session, they talked about, yes, they wanted to work things out.
Okay. When they were together, did they indicate they wanted to get back together, like reunify?
The goal was for them to reunify and moving to Maryland.
Okay. When Ashley met with you by herself, did she still make that representation?
That they were moving to Maryland, yes.
Okay. And was there anything different about her representation?
Ashley was different when she was separate from Doug in terms of more descriptive of things that had happened between the two of them.
Bye, Chrissy. I've enjoyed these last couple days with you. Being back. Missed you. We'll be back tomorrow. So have a good rest of your night if we don't see you. I think this might be the last witness for the day. So be safe.
Them that troubled her. So some stuff that was scary.
And we won't get into specifics, but
Ask the question, he's entitled to complete his answer.
so did she indicate she still wanted to reconcile with him when she was with you alone? Did she say she wanted to reconcile with him when she was alone with you?
So I don't recall whether she said she wanted to reconcile with him or not. I think that there were challenges in their marriage and she was questioning whether she wanted to be with him or not.
Okay. Did Ashley tell you that she and Doug were also seeing Dr. Broder?
They both mentioned that Dr. Broder was doing an evaluation and I didn't know what it was regarding.
Okay. And did Ashley say to you at any time that she was frustrated with the system?
I think Ashley was discouraged. There had been many things brought up, accusations, CPS, judge that didn't go her way. So I think there was definitely some discouragement with that.
Okay. And I'm sorry to cut you off.
No, you're fine.
Did she express any frustration at the time it was taking for Dr. Broder's report?
Yeah, she thought that that was taking a very long time.
Okay. And did she express to you that she was worried about what his report would say or worried about when the report was released?
She was worried about what it would say. She said if it were to be disparaging of Doug, she was concerned that he would be upset and take some form of retribution with that.
Okay. Did she, the last time that you saw them was when?
The last visit was on 9/25/20.
Do you remember what day of the week that was? You might not, but.
Maybe Thursday, Friday. Okay. I can look if you need that.
No, that's okay.
Okay.
And about what time of day was it?
I believe that was a morning session, 10:30-ish.
Okay. Did they say Dr. Broder's report was done?
I don't recall them saying that the report was done. I know that they had been waiting on it and it was supposed to determine specific things for how they move forward.
Okay. And did they indicate when they were going to court next?
I do not know that. I don't recall anything mentioned about when court was.
Did they indicate to you when they expected they were going to have access to that report? Excuse me.
No, I don't. There was not a when the report was going to be released. It was going to happen at some point.
Okay.
My understanding is that they still had plans to move to Maryland.
Okay. Thank you. I have no further questions.
Okay.
Cross.
Afternoon, Dr. Quintel.
Hi.
How are you?
I'm doing fine. How are you?
Good. So tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug in meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no.
Sustained.
Not gonna get into this.
Okay, without. Yeah, oh, you have no idea. Without,
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out? Trevor, please don't begin your deliberations. You can use your phones, but don't talk with anybody outside of the jury. And don't do any research on the people, places, things, or legal topics you've heard anything about. Dr. Quintel, I'm going to excuse you to the hallway.
Okay. Take my stuff with me.
Yes, sir. The rule of sequestration has been invoked.
I don't even know what that means.
That's I'm going to
Okay, sorry.
What that means, you can all have a seat. What that means, sir, is that you're not to discuss your testimony or the questions that have been asked of you here in the courtroom. It also means that you can't discuss other witnesses' testimony, and that's with anybody or the questions they were asked. That's with the attorneys, other parties, witnesses. It doesn't matter. You can't discuss anything that's gone on inside the courtroom when you've been in here. Also, that I understand this may be online, and you are not to watch anything online until you're released from your subpoena or the jury has been released from its duties.
Okay.
All right, so
sounds great.
Thank you.
Thank you.
He's a happy fella. Happy. Wow. But something happened.
Thank you. Mr. Taylor, is there anything you'd like to share before I begin speaking?
I think I'm about to catch a whooping. I'm not quite sure why, but go ahead.
I believe that you expressed you're a veteran of over 400 jury trials.
Yes, sir.
This is all rhetorical. You can feel free to answer or not answer. My assumption is that you're familiar with trial process and procedure, that you're familiar with, as you had mentioned earlier, the rules of professional conduct and decorum. I'm also sure that you realize that if this court makes rulings that you disagree with, whether it's a passing disagreement or a fundamental disagreement with a ruling, I would imagine you're aware of the fact that if ultimately your client is convicted, either you or another attorney or a public defender, if she's indigent, will have every right to appeal to the Second District Court of Appeal every decision I've made. From the minute I sat down in this division and started making decisions in this case, all the way through the end of the case. I also would imagine that I'm not the first judge that has made rulings that you disagree with. I would imagine I'm not the first judge that you have looked at up here and said, where in the world did he or she get that from? I would hope that you have not engaged in the conduct like you just did. It was inappropriate. It was unprofessional. We're going to take just a few minutes break. I have this position and I understand criticism. And I expect that. I have often said that I think my job early on as a youth sports referee and umpire prepared me well for the criticism that comes with the job. However, those sorts of side comments are just, they're not appropriate. And I would caution you, sir, not to do that again. That's extrajudicial matters that have nothing to do with the case or the consideration of the jury. All right, so we'll take a 5-minute break and we'll be back.
I think it was frustration. I think it was, if he's talking about when he said, "Oh, you have no idea," I honestly think it was just his frustration coming out because everything he does gets shut down. And an attorney might sit here and say, "This is why," but I don't have that. So I'm just looking at him as a human.
I agree, but he shouldn't have said that. But it does seem like the prosecution is able to get in the things that aren't supposed to be getting in. And as soon as the defense approaches it, objection, not allowed.
Yep. So, I mean, I think it was just frustration and maybe came out before he even knew it. You know, sometimes that happens. I get it shouldn't have happened in there.
Yeah, he might have said, "Did I say that out loud? I'm sorry."
I mean, he owned it right away. I think I'm about to get a whooping from you, Judge, you know? And he didn't argue with him. He just stood there and took it. So you got to give him credit. But, and that guy, that doctor, he's weird.
He is too happy.
Yeah.
He had a little too much pep in his step.
He had something.
You were
I
just
just
stepping
love-
and stepping all over the place.
I love coming to court and testifying.
Woohoo! Yay, court!
Especially about DV. It's great.
Love it.
Well, it's not DV, remember?
But, oh, wait, what am I missing? I'm missing something. Brian, my brain is too fried at this point.
No, I'm just saying that they can't bring in DV stuff. So
Oh, yeah, they can't. The defense can't.
right.
But yet they can ask all kinds of questions.
How rude.
It is rude. And they probably really just think they got to win there because I didn't think the judge was super harsh on him. Just basically knock it off. But, you know.
I'm wondering if he went back to when he asked Broder about, have you treated DV and you know what the symptoms are. He got those questions in. And then they objected when he said, "Did Doug exhibit any of those?" The objection. I'm wondering if we could have then asked, "Well, since you know what it is and you've treated it, what are the symptoms?" And then had him list them off and then said, "Let's look at your report. Does Doug have any of that?" Maybe it could have got in that way. I don't know.
Maybe. Well, he would say that anyway, Adair, because that's where they are in the trial. He would just say if she's found guilty, or convicted. I didn't find that weird, but it was, I thought he just was ready to pounce. Because it seemed like the defense attorney and the doctor kind of took a deep breath together and just, whoops, I didn't mean to do that. And we're just kind of recentering themselves like, okay. And then, you have no idea. And I think it just came out. I don't think he meant for it to.
All right.
Shut up.
Wow.
Oh my gosh. You guys get me laughing at the most inappropriate times.
It's the only thing that gets me through my week.
I'm sitting here like, oh, okay, I look like a jerk.
AJ looks like a lobster again.
It's like, oh, I went to being mad to laughing. Good. But yes, I think it's going to hurt him that they can't talk about it. The defense can't talk about it. The defense can't have an expert because the jury may be wondering. The defense has brought this up this whole entire time for DV, and then they don't bring it up on their defense because they don't know. that they can't talk about it. That is Gabby.
Yes, Adair. Heart, 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 heart.
Times 100. She's a giraffe. You can finally put. Oh, I think you've talked to Adair in voice chat, haven't you?
Yeah.
As I say, she can. You can finally put a voice to the name. But I think you've already done that. You're already ahead of me.
Yepers.
Whew. Well, that was exciting. 5 minutes. When has a court ever taken 5 minutes?
You're like, whew, exciting 5 minutes. I'm out of breath now.
It's like exciting. Okay, 5 minutes is up. Let's go.
Oh man.
Add time.
Yeah. They never take their breaks are always twice as long as what they say. Like 5 minutes. Okay, 25 minutes later. Sorry that took so long. But I thought, is this the doctor he said was going to take a long time, or was it the doctor before this one? He said one of the doctors was going to take a long time, and that first one didn't.
Well, I think he expected Broder to take longer until the judge pretty much said you can't ask him the questions that you're going to ask him.
Yeah. He had to have known, though.
He's the one that wrote the report, so. And that was interesting, too, because I was expecting that report was going to say she's a terrible mother, she's crazy, she's off the rails. But it came out that she was more worried that the report was going to say bad things about him.
Yep.
And I think the state's trying to say, yeah, she unalived him because she was afraid of what the report was going to say. Well, you don't do that if the report's going to say bad things about the other person.
Right.
Which is what she was worried about.
And still, though, it's such... all these things of them saying this report was coming out, so she did that. That's
yeah, and I'm sorry to interrupt you again,
fine.
But the thing that unaliving him was not going to stop that report from coming out.
Right.
So
I don't, and that to me, that's not motive. That's nothing's going to change except you're going to be sitting.
All right, let's round up Dr. Quintel. Get him back in here.
Dr. Quinn, medicine.
As he's coming in, I want to remind both sides that the court has made a number of rulings over the last couple of months regarding the admissibility of certain evidence. Until those decisions and orders are revisited and changed, it is the responsibility of both sides not only to operate within those bounds, but also to advise their witnesses of the prior court orders and admonish them to stay within those bounds. All right, go ahead and bring in Dr. Quintel.
So he's probably not going to be able to say things like he just did.
should have said that before that lawyer testified.
Right.
While you were outside, did anybody attempt to discuss the...
What'd you say, Brian?
I said he should have said that before that lawyer testified.
Yeah.
Interact with him.
All right. Did that person ask you questions?
He said that he knew I couldn't talk, but here's a card. I said, I don't want that.
Okay. All right. Anybody want to follow up questions about that? All right. Everybody says no. Let's bring in the jury.
I keep muting at the horrible times. It sounds like a reporter maybe approached him in the hallway. He didn't take their card and he didn't talk to him. He probably just sat there and smiled at them. That kind of creepy smile he's got going on. If I walked in there and that was my therapist or my doctor, whatever, I'd be like, oh, I'm good. I'm healed. It's a miracle.
He probably just wanted to Can you get me some of what you're on?
Yeah. You're so happy.
Thank you. Doctor, did you, as a result of meeting with the two of them together and separately, did you reach any conclusions about the relationship?
Objection, relevance.
All right, you can approach.
Why can't he answer that?
This whole
That's
thing is about the relationship.
yes. Like, why can't he answer that? That is crazy. Unless he's just trying to see what trail he's going to go down. I'm sure he knows stay in his boundaries now, but that doesn't make any sense to me. If I could revoke it, I would. Because, oh my gosh. It's usually the defense that's doing all this objecting. It's kind of starting to feel that way a little bit, Adair. In these last witnesses that we've had, it's kind of starting to feel that way. Dr. Jason Oxycodone Quintel. Oh, he's got something we don't have. Like sunshine and happiness. She's gonna be revoked right out of here. See ya. High on life. That's right. Like Gabby said. All right, all right, all right. That would be too high of an octave for Matthew McConaughey. He hangs out with Woody Harrelson, so we both know they're high on life. They love life a lot. Actually, I have no idea. He could be clean, but he does hang out with Woody Harrelson. They might be brothers. It's a theory floating around out there. Just stupid facts while we wait for this sidebar to end.
A lot of finger pointing from the defense.
Well, oh no. My stomach is growling. I apologize. I don't have any food left. Her white stripe gets bigger and bigger. I swear she's going to look like a skunk by the end of this trial. And y'all know how I feel about skunks. Well, yes, with a name like Woody. Oh, she's got the book out. I wondered why she had that big book. I saw her put it on the desk or on the table. Like, what the heck are you doing with that? Got the book of law.
I didn't know it was an open book test.
Yeah. That's what he's telling the judge right now. Like, Judge, I didn't know. I studied all night. She's got Post-its and stuff. And she still can't find what she's looking for. I have not ever seen an attorney take a book.
The state is saying she unalived him because of their relationship, and he can't say what his expert opinion is of their relationship.
Yep.
This is just bizarre.
No, Adair. I don't want any storms. No. They freak my dog out, which means I will not sleep because I'll have to be up with her. You keep your storms in your state and go around me. I don't want any storms. Can I whine anymore? Yes. She's looking for cookie recipes. She's probably looking up the blonde streak double toil and trouble recipe. I have newt. Don't want to know. Yeah, call me one. Call me a ambulance. I'll call you when I'm off with my dog, so I have somebody to talk to. I know. You're still just a little bit north of me, so it might stay north. I think both of them. I think the last two doctors counseled both of them. Hey, you'll pop it and go pick it up. Please don't smile, doctor. Please don't smile.
Did you make any inquiry, doctor, about why Doug Benefield would want to stay in this relationship?
Judge, you want to say?
Oh,
You can answer.
Can you repeat the question, please?
Yeah.
Thank you.
Was there any observation by you in response to why Doug Benefield would want to remain in this relationship with Ashley Benefield?
I questioned why both would want to stay in the relationship, but specifically to answer the question with Doug, I did bring that up in a session, that it seems like Ashley is saying very disparaging comments, and I'm not sure why and what you see in that ongoingly moving forward. I did bring that up to him.
In fact, you were perplexed by it, were you not?
I was confused, sure. It did, yeah.
Would it be a fair conclusion to say that he was hell-bent on staying with her?
I would say that he really wanted the relationship to work from everything that he told me.
Okay. We're going to have to recall you, so I'm done.
redirect? All right, sir. So at this point, you are going to remain under subpoena.
Okay.
You're free to go now, but one of the parties, one or both the parties may actually call you back later. So all those instructions I gave you earlier still apply. Don't discuss your testimony with anyone, even the attorneys, any other witnesses. You can't watch anything that might be online or read any news.
No interest in anything of that. Anyway.
You're free to go now. Thank you, sir.
Have a good rest of your afternoon.
You too, sir.
Thank you.
Oh my goodness. Is he gonna like skip out of there?
Approach about scheduling.
Okay.
Hello, Carmen. Good morning. Your morning. Scheduling, why can't we hear? We need to know your schedule, people. Your schedule messes with our schedule. Ashley, blink the schedule to us. We know you're taking down code. I like how the headphones match her sweater today.
All right, members of the jury, the next witness may take quite a while. So instead of keeping you so late tonight, the attorneys and I have agreed it's probably better to just come back tomorrow morning and start fresh. So I'm going to let you go for now. If you would please, same tomorrow time. Are you guys okay with the time?
Yes.
All right. Let's again plan, what would we say today, 8:45? And get you up here and hopefully get started right about 9. So let's do the same thing tonight. Please remember, no discussion amongst yourselves. Talk about the weather, nothing else. Don't talk about the case with anyone outside of this jury. And don't do any research on people, places, things, or legal topics that you heard anything about.
Yes, sir.
Okay?
Judge.
We'll see you tomorrow morning. You too. Take care. All right. Thank you all. We'll see you tomorrow morning.
All right, that's it.
I thought they had a motion to argue.
Do they? I thought he said we'll see y'all tomorrow morning.
He did, but I thought
The original order that you
it was
did,
something
and then
that
the
he
clerk
said he was
provided
going to
me
pick up at the end of the
the
day.
transcript and the emails. I think you said something, when you said transcript, was that the transcript you referred to? Because the court reporter hasn't transcribed what happened.
Correct. I sealed, if you look at my order, I sealed her raw data, her notes, and any transcripts.
Okay, so I was gonna ask her to do it, but I wanted to clarify before I did something wrong.
I have not requested it. I don't even know if one has been done, but it has been unsealed if there's one.
Thank you, sir.
Does your order, Your Honor, allow the clerk to give them a copy?
Yes. Everything's been unsealed.
Yes, Adair, she's out on $100,000 bond. She is not charged. She's not charged with first degree unaliving. She's charged with second degree unaliving, which means they don't think it was premeditated. So yes, she is out on bond. If it was first degree, I don't believe she'd be out. I believe she'd be stuck like Chuck. But I don't know. We may not have a popular opinion amongst ourselves with everybody else, but I'm going not guilty at this point. Not guilty.
Me too. At this point.
Soggy
So I
bottom
guess
bun.
what they were talking about, all that ex parte stuff. I guess they're not going to be able to get to it today because they didn't get the copies. But
Yeah.
that's what they were supposed to argue at the end of the day today.
Yeah, I forgot about that. She's tried to not smile a couple of times. I think she's scared to. When somebody has smiled at her, I think, or I've seen her kind of act like she wants to smile, but then she doesn't, because you know everything she does is going to be judged. So I don't know how that'll work out for her. But Gabby, yes, thank you everyone for watching the sandwich live and joining the chat. Thank you to everyone who has gone over to Jodie's page, The Defense Rest, and hit that like and subscribe button. She got to 220, so we need to just keep on keeping on going past. She will be happy when she wakes up from her slumber.
Yeah, I'm not guilty.
You're not guilty?
Page for now.
Yeah. Like I said, we probably aren't the popular opinion, but
Adair. Oh, Adair.
So Jodie's hosting tomorrow. So 9 a.m. is what he said. So I assume we will start around 9 a.m. Eastern time.
Woot, woot.
We will convene at that time.
So we will be here.
Right, bring your hazmat suit.
Yes, that was so funny. Oh yeah, we're done, Carmen. Go back to bed.
I have to wash it.
Did you pee in it?
Yeah. That's what it's for.
Ew, Brian.
Well, you know, they don't they don't do the breaks when it's convenient for me.
Well, Bry's now a soggy sandwich.
Ew. I've been sitting here. I got up once to shut the door because I knew the dogs were going to start going nuts because they're like, dinner, excuse me, man, dinner time, dinner time, dinner time. So
See you
I
later,
shut them
Bob.
down. Bob, good to see you.
All right, guys. We will touch base tomorrow.
Yes.
Have a
I will see
great
you
night.
No one's touching my base.
Well, just don't leave it by the back door.
Well, that's locked up, so we're good there.
Okay. Bye-bye.
See you, Brian.
Bye.
Oh my goodness. All right. Gabarina. Oh, hey, Carmen, that's your dog. She wanted to stay in here with me. Sorry about your luck, girl. All right. Since Rue has barked everybody's eardrums, made them bleed. Bye, Gabby. I'm out of here. Thank you all for hanging out. See you guys all tomorrow morning. We will continue this trial and see what's happening. And I got to go because she's not going to shut up. So my apologies. And I'll see you guys all tomorrow.